Let's rock.
Woo! We made it. Holy crap. I'm very tired. But we made it. I got up here only 30 minutes late. I ain't even working right. It's still not functioning properly. Good morning. Oh my God. Good morning to the congregation. Appreciate everyone for coming in. Grab a pew. Take a seat. We're going to be here for a little while today. Finishing out this freaking trial. We have made it. And the folks that have made it all the way through. My God. Sheila Duffy. Thanks for that share. Already helping me out. I appreciate that. Thank you guys. All right. Yeah, we're going to be starting out. I went over a little bit what we're going to be doing today last night, which is the rest of this trial. We're going to be starting out with Judge Dowhard, my favorite judge. I will miss thee. Given the jury instructions, which are going to be 53 minutes to start us out. And yeah, we're going to go from there and see where we end up. But again, everyone coming in this morning. Let me see who the fine folks are. If my mouse would fucking work. Boom. Kathy coming through. Sheila Duffy. Teresa. Jen's in the house. Wild side. Hell yeah. Candy's popped in this morning. Bassett Page. Morning, my friends. Morning came so early. Remember, this is the last episode, so what are we doing? Kicking off a new season 6, believe it or not, of Murder Church. Starts Tuesday night, 8 p.m. Eastern. Charlie Adelson. But without further ado, let's get in here and do the damn thing. Make sure the sound is working. Got a little spicy right at the end last night. Phil Spector's wife was being sassy to the judge. He was putting a gag order on her, saying, "Don't talk to the media." She was doing interviews with Court TV before this thing was over. And he said, "Do not do that, or I will hold you in contempt." She started fighting him back. Got a little heated. Until Plord, one of the defense attorneys for... I'm losing my mind right now. One of the defense attorneys for Phil walked over and presumably said, "Shut the fuck up, you crazy bitch." Nosy Rosie coming through here. Jessica coming through here. Appreciate it, guys. Let's go.
Court's again in session. All right, on the record, the defendant's present with his counsel, the district attorneys are present, the jurors and the alternates are present. All right, ladies and gentlemen, we've arrived at the time where I will instruct you on the law. Again, if anything the attorney said during and you will be instructed further, if anything the attorney said during their arguments conflicts with my instructions, it's my instructions that will control. After you begin your deliberations, a short time thereafter, you will get copies. Each of you will have a copy of the instructions that I'm reading to you that you may use in the jury room. We will take them back after the close of the case. The one thing I ask is on them, since we will be recovering them, don't write on the jury instructions. I mean, they're there for you during your discussions. If there's a discussion on the law, the foreperson doesn't have to pass around the court's instructions is the way it's often done. I'm trying something new in this case. Other judges do it. We'll see how it succeeds. It certainly won't cause any problems. It should only benefit you. But each of you will have a copy of the instructions to read in the jury room. I don't think there's any reason for you to take notes during my instructions. I'm not telling you can't. I think what's better for you to do is simply to listen to me and just listen to the instructions, and then you'll discuss them inside the jury room. Since you'll have your own copy, I can't see any reason for you to take notes.
Jury's like, Jesus Christ, how have we gotten here?
Takes about 35 minutes probably to read the instructions, I'm guessing, maybe less. I don't think any more than that, so try to make yourselves comfortable. And once we're done, you'll begin your deliberations. Members of the jury, I will now instruct you on the law that applies to this case. Each of you has a copy of the instructions to use in the jury room. You must decide what the facts are. It is up to you exclusively to decide what happened based only on the evidence that has been presented to you in this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. You must reach your verdict without any consideration of punishment. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflicts with my instructions, you must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary, everyday meanings. Some of these instructions may not apply, depending on your findings about the facts of the case. Do not assume, just because I give a particular instruction, that I am suggesting anything about the facts. After you have decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not do any research on your own or as a group. Do not use a dictionary or other reference materials. Investigate the facts or law, conduct any experiments, or visit the scene of any event involved in this case. As you recall, the court conducted a jury view of the scene at 1700 Grand View Drive in the city of Alhambra. That was your only opportunity to view the scene. Do not return to the scene, pass by the scene, or further investigate the scene. You have been given notebooks and may have taken notes during the trial. Please do not remove your notes from the jury room. You may use your notes during deliberations only to remind yourself of what happened during the trial. But remember, your notes may be inaccurate
God, without
or
notes in
incomplete.
this one? You kidding me?
If there is a disagreement about what actually happened at trial, you may ask the court reporter to read back the relevant parts of the testimony to assist you. It is the testimony that must guide your deliberation, not your notes. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt, unless I specifically tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. You must decide what the facts are in this case. You must use only the evidence that was presented in this courtroom or during the jury view. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys discuss the case, but their remarks are not evidence. The questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you to understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asked a question that suggested it was true. During the trial, the attorneys may have objected to questions or moved to strike answers given by the witnesses. I ruled on the objections according to law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. The court reporter has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask that the court reporter's notes be read to you. You must accept the court reporter's notes as accurate. During the trial, you were told that the people and the defense agreed or stipulated to certain facts. This means that they both accept those facts. Because there is no dispute about those facts, you must accept them as true. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and the other to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. The people must prove not only that the defendant did the acts charged, but also that he acted with a particular intent and/or mental state. The instructions for each crime explain the intent and/or mental state required. An intent and/or mental state may be proved by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence...
Damn, look at this. Christine coming in, going to show off her number. Bam, I love it, Christine. A member for 9 months of the Buzzed and Confused. Thank you so much, Christine. I appreciate it. If you've been jamming with us through this whole trial, holy crap. Or even watched a portion of this trial, because we've been doing it for 16 freaking months. I feel like I was a different person when I started this trial. I've grown so much. Thank you so much. I really appreciate it.
To conclude that the defendant had the required intent and/or mental state, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent and/or mental state. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did not have the required intent and/or mental state, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent and/or mental state was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. The testimony of each witness must be judged by the same standard. You must set aside any bias or prejudice you may have, including any based on the witness's gender, race, religion, or national origin. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? Has the witness been convicted of a felony? Has the witness engaged in other conduct that reflects on his or her believability? Was the witness promised any benefit in exchange for his or her testimony? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that the witness says. Or if you think that the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. Every crime or other allegation charged in this case requires proof of the union or joint operation of act and wrongful intent. In order to be guilty of the crime of second-degree murder and the allegation of personal use of a firearm, a person must not only intentionally commit the prohibited act or intentionally fail to do the required act, but must do so with a specific intent and/or mental state. The act and the intent and/or mental state required are explained in the instruction for murder and the allegation of personal use of a firearm. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of the greater number of witnesses or any witness without a reason or because of prejudice or a desire to favor one side over the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. During the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and for no other. There has been evidence admitted in this trial of other guns recovered from the defendant's home. This evidence was admitted for the limited purpose of 1, determining ownership of the Colt Cobra, Peoples 26, and 2, corroboration of Dorothy Melvin's testimony regarding the defendant's use of a shotgun. The fact that the defendant may have owned or possessed other guns may not be considered as evidence that he committed the crime charged. Both the people and the defense must disclose their evidence to the other side before trial or within the time limits set by law. Failure to follow this rule may deny the other side the chance to produce all relevant evidence, to counter opposing evidence, or to receive a fair trial. An attorney for the defense failed to disclose Dr. Michael Bodden's opinion that the weight of Lana Clarkson's lungs indicated she was still breathing after the fatal shot was fired. The people had a right to be notified of this evidence prior to his being recalled to testify. Instead, the people did not learn about it until he testified to his opinion. Additionally, Sarah Kaplan testified that she observed Dr. Henry Lee recover an object from the foyer of defendant's home. If you find this evidence credible, there is no evidence that whatever was removed was turned over to the people. In evaluating the weight and significance of the evidence, you may consider the effect of any of the late or non-disclosure. The defendant did not participate in either the late or non-disclosure of evidence, and you may not consider these events as evidence
Oh, seeking justice. Thanks for that share. I really appreciate it, guys.
the defendant committed a crime. You may consider this evidence only pursuant to the guidelines I gave you earlier in this instruction. If you find that investigators or experts from the prosecution lost or mishandled evidence, you may consider that fact in evaluating whether the defendant had a full and fair opportunity to present his defense. If you find that the witness, Melissa Grosvenor, has been convicted of a felony, you may consider that fact only in evaluating the credibility of the witness's testimony. The fact of a conviction does not necessarily destroy or impair a witness's credibility. It is up to you to decide the weight of that fact and whether that fact makes the witness less believable. If you find that the witness, Melissa Grosvenor, has committed a crime or other misconduct, you may consider that fact only in evaluating the credibility of the witness's testimony. The fact that a witness may have committed a crime or other misconduct does not necessarily destroy or impair a witness's credibility. It is up to you to decide the weight of that fact and whether that fact makes the witness less believable. You have heard evidence of a statement that the witness made before the trial. If you decide that the witness made those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Witnesses were allowed to testify as experts and to give an opinion. You must consider the opinion, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and to give an opinion based on the assumed facts. It is up to you to decide whether an assumed fact has been proved. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. If the expert witnesses disagreed with one another, you should weigh each opinion against the other.
I just forget how loud this mic is. Like, I try to keep it away from my mouth a little bit. Hold on. And this mouse, I need to change these batteries. It's driving me out of my fucking mind. Like, if I keep it right here, it's still pretty loud. Damn it. Like, I need to get this under control. I do get a lot of comments of my sound is just a little too loud. Check, 1, 2, check, 1, 2, check. I got to get that under control.
You should examine the reasons given for each opinion and the facts or other matters on which the witness relied. You may also compare the expert's qualifications. Witnesses who were not testifying as experts gave their opinions during the trial. You may, but are not required to accept those opinions as true or correct. You may give the opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. A defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider, for any reason at all, the fact that the defendant did not testify. Do not discuss that fact during your deliberations or let it influence your decision in any way. You have heard evidence that the defendant made an oral or written statements before the trial.
CMK on X. Thanks for that share. Appreciate that.
You must decide whether or not the defendant made any of these statements in whole or in part. If you decide that the defendant made such statements, consider the statements along with all the other evidence in reaching your verdict. It is up to you to decide how much importance to give to such statements. You must consider with caution evidence of a defendant's oral statements unless it was written or otherwise recorded. The defendant may not be convicted of any crime based on his out-of-court statements alone. You may only rely on the defendant's out-of-court statements to convict him if you conclude that other evidence shows that the charged crime was committed. The other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. The identity of the person who committed the crime and the degree of the crime may be proved by the defendant's statements alone. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. The people are not required to prove that the defendant had a motive to commit the crime charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. If the defendant tried to create false evidence, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. The people presented evidence that the defendant committed 7 offenses of assault with a firearm involving 5 witnesses that were not charged in this case. You may consider this evidence only if the people have proved by a preponderance of the evidence that the defendant in fact committed the uncharged offenses. Proof by a preponderance of the evidence is a different burden of proof than proof beyond a reasonable doubt. A fact is proved by a preponderance of the evidence if you conclude that it is more likely than not that the fact is true. If the people have not met this burden, you must disregard this evidence entirely. If you decide that the defendant committed the uncharged offenses, you may, but are not required to, consider that evidence for the limited purpose of deciding whether or not the defendant had a motive to commit the offenses alleged in this case. Motive is an emotion that may impel or incite one to act in accordance with his state of emotion. In evaluating this evidence, consider the similarity or lack of similarity between the uncharged offenses and the charged offenses. Do not consider this evidence for any other purpose except for the limited purpose of motive. Do not conclude from this evidence that the defendant has bad character or is disposed to commit crime. If you conclude that the defendant committed the uncharged offenses, that conclusion is only one factor to consider along with all the other evidence. It is not sufficient by itself to prove that the defendant is guilty of second-degree murder. The people must still prove each element of the charge beyond a reasonable doubt. The defendant is charged in count 1 with murder. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act that caused the death of another person, and 2, when the defendant acted, he had a state of mind called malice aforethought. There are 2 kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant acted with express malice if he unlawfully intended to kill. The defendant acted with implied malice if 1, he intentionally committed an act, 2, the natural consequences of that act were dangerous to human life, 3, at the time he acted, he knew his act was dangerous to human life, and 4, he deliberately acted with conscious disregard for human life. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes death is committed. It does not require deliberation or the passage of any particular period of time. If you find the defendant guilty of murder, as a matter of law, it is murder of the second degree. As I have instructed you, to be guilty of the crime of which the defendant is accused, second-degree murder, the defendant must have committed an act that caused the death of Lana Clarkson. It is the prosecution's contention that the act committed by the defendant that caused the death of Ms. Clarkson was to point a gun at her. And excuse me, ladies and gentlemen, a word was left out, and I don't want to leave it for later. And we will correct your instructions to reflect that, which resulted in the gun entering Ms. Clarkson's mouth while in Mr. Spector's hand. The prosecution bears the burden of proving that the defendant Spector committed that act. If you do not find that the prosecution has proved beyond a reasonable doubt that the defendant committed that act, you must return a verdict of not guilty. If you find the defendant guilty of the crime charged in count 1, you must then decide whether for that crime the people have proved the additional allegation that the defendant personally used a firearm during the commission of that crime. You must decide whether the people have proved this allegation for the crime and return a separate finding for that crime. A revolver is a firearm. Someone personally uses a firearm if he intentionally does any of the following. 1, either displays the firearm in a menacing manner, or 2, fires the firearm. The people have the burden of proving this allegation beyond a reasonable doubt. If the people have not met this burden, you must find the allegation has not been proved. When you go to the jury room, the first thing you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you have discussed the evidence with other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family or friends, spiritual leaders or advisors or therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury These exhibits will be sent into the jury room with you when you begin to deliberate. If you need to communicate with me while you are deliberating, send a note through the bailiff, signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by a written note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on questions of guilt unless I ask you to do so. Your verdict on each count and any special findings must be unanimous. This means that to return a verdict, all of you must agree to it. It is not my role to tell you what your verdict should be. Do not take anything I said or did during this trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. You will be given verdict forms. As soon as all jurors have agreed on a verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff.
Welcome to the final day.
Return any unsigned verdict forms. Before I have the bailiff sworn to take charge of you, there is an inquiry I need to make. Despite my best efforts, there are occasionally things that slip out into the press that just shouldn't be there, and it's not the press's fault. They report what they're given. We have told you not to read any accounts of the trial or listen to any accounts, and hopefully you have all done that. I believe you have. Anytime there's someone who's inadvertently seen something, certainly you've let me know. I need to ask any of you, or all of you, and then indicate by raising your hand, over the weekend or today, has anyone read or heard anything about this case that might in any way influence your ability to be a fair and impartial juror? Just raise your hand if you think you've seen or heard anything. No juror has responded. Please swear the bailiff.
Do you solemnly swear that you will take charge of the jury and keep them together, that you will not speak to them nor allow anyone else to speak to them upon any subject connected with this case? When they have agreed upon a verdict, you will return them to this court, so help you God.
Yes.
Do you further swear to take charge of the alternate jurors and keep them apart from the rest of the jury while they are deliberating on the cause and until otherwise instructed by the...
Oh, shit. I see Kathy coming through my Venmo machine. Kathy helped with a $5 holla. Advancing the will just a little bit. Kathy has been amazing. Always amazing. Kathy and Pumpkin, some of my favorite people on earth. And yes, I said people for a cat. Please put Bassett Page on the will in memory of her kitty Freya. Oh, man. And also we have the kindest folks in the world here in the Buzz Nation. So yeah, I will put Bassett Page right on that thing. Thank you so much for being so kind and generous, Kathy. Thank you. So yeah, Bassett Page, you got a spot. And again, yeah, I'm sorry to hear about Freya.
Yes.
All right, ladies and gentlemen, if you would go in, the 12 jurors will now retire to the jury deliberation room. I'm going to ask the alternates to remain for a moment.
She came right behind that with another one, 420, and she said put Pumpkin on the will also. Now Pumpkin's got a spot as well. Can't forget about Pumpkin. Thank you so much, Kathy. Appreciate that. With a 420, let's go. I'll get a count here.
We will put you in a different room, keep you apart from everyone else. If there's any questions or anything, and I do them in open court, the alternates will be brought back to hear any testimony that's read back or to answer any questions that are done before the jury. With that in mind, you may begin your deliberation.
Molly Tyson, thanks for the share.
The evidence and the instructions will come in shortly, but not right this minute, so go ahead and get started.
Beautiful people.
All right. Chandra, do you have someplace to take the alternates? All right. If the alternates will follow the bailiffs, they will secret you away where you can't be bothered. You'll be brought back for lunch. Talk about the important things here. The jurors have begun their deliberations. The alternates have left. Obviously, I'm going to have to make some grammatical corrections, even though we all looked at them. They're still there. And certain ones I made because I didn't want to miss, but most of them are, like an A or the or statement instead of statements. I'll just go back and correct them. I don't think we need to do that. Take any time just so it's cleaned up.
The obvious verbiage about the attempted crime.
Yeah, the attempted commission, and that's, well, actually, we may have to do it so that their instructions, I would wanted to do it and not tie you up, but we better do it now so that we're all in agreement, because come to think of it, they have to match what I read.
The two that I noticed the court made specific corrections on orally were 3146, taking out attempted commission.
Right.
Or attempted commission. And what has previously been discussed as special instruction 4, it's now going to be called, I think, defense. I don't know what it is. It's the one that starts out, as I've instructed you to be guilty of the crime of which the defendant is accused. It's the pinpoint instruction, the Sears instruction.
It's what?
The Sears instruction.
Okay, let me see if I can find it.
The fourth line down,
Yeah, addition of the word to.
the word to between was and point.
Right, okay.
I'll take care of those two.
Okay, well, let me go through them.
It's like
a lot of them I did
4 days,
just
I believe,
on the
we've seen
fly,
here.
so to speak, so we better double check where I was sort of editing rather than try to interrupt. So let's just read the instructions to yourself, and if you see one that, they're all grammatical corrections.
201,
Okay?
in the second to last sentence, you use the word not. I don't know if that matters. You used the word when you were instructing that.
Well, if you're bringing it up, Rosen, it probably fucking doesn't.
That was your only opportunity to do the scene as opposed to this. I don't know if you want to correct it to conform to what you told them.
Which line is this?
On 201, the last of the second to last line where it says, this was your only opportunity to do the scene, you said that was your only opportunity to do the scene. I don't know if you want to correct it for that.
I don't recall saying it, but I'm happy if the parties agree to change it.
Yeah, just if you want to keep it consistent, that's all.
I didn't notice when we were...
I didn't either. I'm just going to leave it. It's totally irrelevant, and since I don't recall it,
Totally irrelevant. Big fucking surprise. Rosen?
without a complete agreement, I won't change it.
On 318, you struck the word A in the first sentence.
Okay. I think I read it to, and to give opinions. It actually reads "and" on my copy. And
I'm
that's
I'm just going with the deliberations about what the videos we got left.
I changed it, so just to give opinions, okay? Take out the word "and."
And then, yeah. But
Let me look at that instruction, because I think there's several grammatical
you're on
errors.
332?
I'm on 332.
Okay. I'm talking about 318, the one before it.
Okay, I'm sorry.
You correctly removed
Right.
the word A.
That's correct.
Okay. So
That's
now,
fine.
yeah, on 332, you struck the word opinions
And.
on opinions.
Right, it reads "and to give opinions."
And to give an opinion.
No, to give opinions. I left it plural, I believe, but anyway, I want to take out the word "and."
All right, okay. So it'll just be to give opinions.
Yes.
Jesus fuck. God, Rosen's a cunt. What a fucking idiot. What a fuck face. What a piece of shit. Just gonna talk some shit about Rosen, of course. I can't anymore. Are they going through what they literally just read to the jury, so it's already been read? Like, what is going on?
The next correction I have is on 358.
Okay, let me go back then, 358. Okay,
And you made all those, you removed the word "a" from in front of the words.
we already did those, I think.
Okay.
Right, that had already been done.
And then the next one I had is the People Special Instruction 3.
Hold on a second. Now, I believe, well, let's go to 375. Consider the similarity or lack of similarity between the uncharged offenses and the charged offense. It should not be plural.
I'm sorry,
We're in the third paragraph from the bottom. In evaluating this evidence, consider the similarity or lack of similarity between the uncharged offenses and the charged offense, singular.
Yes.
Okay? In line 3146, if you find the defendant guilty of the crimes, it's crime, and I believe I self-edited.
I'm sorry, where are you?
3146, first sentence, instead of crimes, it should be crime.
Right. When you finish that, can we back up on?
Okay, sure. Go ahead.
On People Special Instruction 3, which precedes it,
Okay.
you correctly inserted the word "to" at
Right.
line 4, where it said Clarkson was 2.8 gun.
Right, we already did that. I thought we mentioned that. Okay. Very last page in the instructions.
Right?
Your verdict on each count,
my
your
point.
verdict on the count. The count.
Why would
Okay.
they not? This should have.
Okay, so
This
take out
part
each,
should have
make
been
it the-
before the actual reading. Like it's.
Third line from the bottom, you will be given A verdict forms. You
No,
will be
no, I
given
don't
verdict
know. I don't
forms.
know
Take
shit.
out A.
I'm just watching this.
Anything else that
right?
you want to go over with?
No, I think that was it.
Take a few moments to correct all.
Yeah, I know. That's not a problem. They understand. It takes, then when he has to separate the historical portion from
Just
the, then
gives
that takes time. They
Rosen
know they
time
won't get him
to
right off the bat.
interject with nonsense.
Let's talk about jury questions and how you want to handle that.
What I would suggest, just informally we could chat in the chambers, and I think what we agreed upon is that everybody be on 1 hour call from the defense side. All defense team members do want to in fact be present. I, pursuant to your request, I think I provided Wendy with all my numbers, but I'll double check to make sure she has them.
That, the only thing, that's fine with me. That only puts a burden on you that everyone get here, because my view is if somebody says, gee, I can't make it today, we're not going to stop. So it's within reason. If for any reason somebody just can't make it, then I'm going to proceed.
And I also have Mr. Spector on 1 hour call, and I have a direct number to him, so should he need to be here, I can reach him within the time.
What do you want to do about, does he want to be present for all questions and all discussions?
Can we take it on a question-by-question basis, and we'll see what it is?
Well-
Some things may be mechanical, or...
That's fine. I mean, he has a right to be present.
Right.
But if counsel indicates to me, second, do you want to be present or do you want to do it telephonically? How do you want to handle it?
Well, again, it depends what comes up. I mean, if it's, for example, if it's a reread, and it's a lengthy reread, Generally speaking, it's usually done in the
Well,
jury.
we have transcripts. This is real easy to do rereads once we
Right.
determine what they
So I'm saying
want.
for that, I don't think it's going to be a problem. And it would depend upon the particular question. I think I would want to notify the rest of the team and see what
Hey,
they
Jan, good
Well, I need to take a
morning.
partial waiver, then at least explain to him what his rights are. Do you want to talk to him first?
I think what we
Having
can
a
do is
good
take
weekend?
partial.
Okay.
And then I'll discuss it.
Welcome to
with
the end of
Well, I'll give him the option.
Bill
Is basically I'm giving you the option and
That's
him
fine,
the
let's do
option.
it that way.
All right, Mr. Spector, and this is also for your counsel. Anytime the jury has a question, you have a right to be
AKA fuckface murderer and rapist.
present when the attorneys and I discuss that. Couple of things can happen. The attorneys may agree that we can do it over the phone, and if it's something that the reporter ends up doing by reading testimony from the transcript, sometimes no parties come in, an agreement is reached, I put it on the record, and then the reporter takes care of it. Is that agreeable to you if that's what they choose to do? I'm not saying they have to. Anyone, you can be here, and your attorneys can be here anytime they want. If you choose to waive your presence and tell counsel, and they tell me, and they want to waive their presence if they do, that's fine. Is that agreeable to you?
Yeah.
Okay. Okay, and just one other thing. What about readback? Do you want readback to be in the presence of everyone or to be in the jury room? Okay? Okay. First. Note that the people are fine. Okay.
Thank you. In the presence.
In the presence, so all readback then will be done in the presence of all parties, all right?
I had one question. Clearly, just one of us is.
Oh, no, the two of you do not have to be here. If you choose that one of you is fine, that's fine with me. Okay. If they choose to. You're all representing Mr. Cooley, so that's fine.
With respect to the team over there, it's kind of a moving target. I note that Mr. Brunon and Mr. Reardon are not here today. Does that mean, does the team, all five of them, have to show up?
What I said was, I'll give, if anybody wants to be here, that's fine within an hour. But once we reach that point, other than, hey, I'm just running 5 minutes late, wait for me, we move forward. I mean, that's the understanding. I can't, with that many lawyers, it's just too hard to, okay, that's
Before
fine.
you leave the bench, could I have a moment with Mr. Rose?
Sure.
We may.
Well, we also need to discuss some evidence. At some point, we need to discuss the admissibility of some exhibits. Yes.
Whatever we need to do on the record, certainly I guess we should finish up. And Mr. Rose wants to broach the subject that we just broached with him off the record in chambers
Okay.
first.
All right.
And then
That's
we can
fine.
discuss it outside.
Let's go in chambers.
Can we, before we go in chambers, I have one other matter, maybe we approach on for a moment.
Yes. Just sent a note saying she wanted to apologize. No problem. That's these things happen. There's a lot of stress, and a court understands that on everybody in these things, and things happen, and I understand that, and it's not a problem. Okay? All right? Good. Let me just say something. This is not directed to anybody in the courtroom. This is sort of directed to at large. It's not a problem in California usually, but I want to make sure if anybody ever tries to contact a juror while they're
Morning,
deliberating, this
Simmy.
is sort of to the
Welcome
world
in.
at large. I hope you don't have any plans for a few years. Seriously. Don't be that foolish. Okay? All right. Now you want to go in chambers? Okay.
Thank you.
All right. All right, back on the record, we need to talk about some redactions that the parties have not been able to stipulate to, so we'll take a... You can just start whenever you're ready.
Right, I will. Your Honor, may I approach the court?
Yes.
Give the court a copy of each of the exhibits that are actually in dispute, and I've labeled them
Okay.
as marked by the defense during the case.
All right. Go ahead.
Just up front, the H3
Okay.
and H3 and A4,
I have them in front of
those
me.
are actually agreed upon by both parties, and the court could actually put that aside
Okay.
as redacted. That makes it easy.
That she certainly does. I'm ever appreciative. Okay.
The Exhibit K3
I have that.
are actually Long's drugstore records. And this
Correct.
is probably the biggest headache between both the prosecution and the defense.
Okay.
The defense wants the entire document in, and our position is that only the relevant portions, which are the drugs in question, or the prescriptions in question, as well as a time frame of 2002 to 2003. These records actually go back, they're 13 pages, and they go back as far as 1997 and have all kinds of irrelevant medication. And we just couldn't sit down and agree to much more than anything. I think there's certain medications that the court ruled it was admissible, and the time frame should be restricted to 2002 and 2003. Actually, our position would be as close to 2003 as possible. So I think at this point in time, the court probably just going to have to go through that document and indicate its ruling.
Or give us a thought as to what time period is important.
Well, tell me what you're attempting to get in so that I may...
It's a kind of a convoluted document, but the Asilomar is the medication regarding bleeding. That goes back all the way to 98. So that portion we would like in all there. Then we think everything, from let's say 2000 on, like last 2 years.
Well, what medications, why are they? Just tell me,
Okay, Asilomar,
if you're looking for a time frame, eventually tell me what things you're concerned about.
all of the Vicodin medications, whenever they were given, or pain medications like Vicodin, and there's like Percocet and so forth. Some of those to go back all the way to 98. In other words, she's on and off of those all the time, and then there was a lot of testimony regarding basically...
Was there any testimony as to Percocet?
Yes, just a quick reference to it, that she was on that. And then also other barbiturate-type medications, I want to say Firearm, if I'm not...
Was there any testimony?
Yes, there was.
Was there testimony as to what that drug did?
Yes, it was a different type of pain medication, along with, I think it also had some other effect also. There was something with it. That, like, for example, the Vicodin, sometimes had different things with it also. So I don't see anything that prejudicial in any of this. In other words, it's just medications, dates, and when it was given. Maybe some of it is not strongly relevant. In other words, it's marginally relevant, but it's certainly not prejudicial. I would just as soon give the whole thing in. That's sort of where we left it.
And people's objection go also as to certain drugs that the counsel just mentioned. There's 2 drugs that is indicated in this record, as well as what the court look at W3, the highlighted portion in W3. These drugs are irrelevant. I think if the jury sees it and is familiar with those drugs, I think it could prejudice the people's case. These drugs, the use of these drugs, or for what they're used, is irrelevant. And I understand from Mr. Plord that there may be some testimony that will support that these drugs caused someone to bleed more. And we can stipulate to that these drugs cause that, but the name of the drugs is irrelevant.
It was talked about extensively by a number of witnesses.
It started out, and the court was trying to be sensitive, to matters that were not directly relevant at the time, just because the medication may be used for one purpose, but the bottom line, there's been testimony to it, and for the jury not to be able to consider it, that's another problem. It really has nothing, I don't see any prejudicial value. I'm trying to be sensitive to the issues, but the defense has a right to get its information, and there was testimony to support it, so I'm going to let that in. Now, as the other, as to the Long's records, basically, the people, do they have something that they believe is a problem? Now, time frame is one thing, but just as far as any drug is concerned, then if you want me to...
Yeah, I believe we should start with the relevant dates, and I think we should only start in 2002.
And the reason for that, especially if it's pain medication, there was some people testified she took pain medication because of her wrist injury.
West Virginia, we get paid Jack Diddley fuck.
It tends to show that is incorrect.
Well, if
Jack
she wasn't
Diddley
taking it
dick.
for that, she may have been taking it for something else. I think the records fairly support the idea that she was taking it. She certainly took it for some legitimate period of time, but it was being overprescribed consistently from 1998. That's what these records show. We think that's probative in general.
Except there's been no testimony to support medication back to 1997.
Other than the Long's records, which are properly...
Well, it shows that she took medication, but not what she took it for, not what the prescription may have been for. It does allow certain inferences that weren't testified to, and that's the problem. I agree that records are fine to support testimony, but you're asking the jury to go ahead and speculate, in essence, hope that they find something, and then draw certain conclusions in their mind for which there's no support in the testimony. And that's the bottom line. Yes, Ms.
If I may, 'cause I'm
Yes.
going to
Okay.
Ms. Hayes testified a lot about the drugs that have been taken by Ms. Clarkson for a number of years, and there was questions raised by the prosecution about whether or not Ms. Hayes was telling the truth for all these periods of time. If you recall, there was an issue with Neely Hudson talked about whether she had cleaned up for a time, didn't clean up for a time. And I think the issue of the drugs is not so much relevant at the 98 point as to what the drugs were, but for the issues of who's to be believed about whether or not there have been drugs taken, especially drugs with alcohol during a period of time. And that's why then the 98 issue became a little bit more relevant than it had been earlier on when we got that whole fight between Neely Hayes and Jennifer.
Find her testimony.
Neely Hayes or Jennifer?
Anybody you want.
Okay.
If it's relevant to their testimony, I would be more likely to let it in without limitation.
Put up the computer, Your Honor, if you don't want to.
Okay, all right.
I think with that guidance, Mr. Plourde and I will be able to work out something.
Okay, all right, let me know. As long as, before it goes into the jurors, that's
These are
fine.
very hard to redact because they're so complicated.
I understand. Anything else?
Yes, Y3.
Okay, let me-
These are pages from her day planner. There are 3 particular pages here, Your Honor. in,
Wendy, you can take the original back. I've got. Okay, go ahead.
The court will see just a highlighted portion on the first 2 documents.
First sober day, that was argued. There was argument.
It was argued.
Yes.
But unfortunately, it was argued prior to discussion of the what exhibits came in or not.
You know what, but it's still, even if there had been, it's consistent with certain testimony about her, trying to become sober when she was sober. It's supported. I would have allowed that in.
We'll submit on that, and the
Okay.
next page, when it says meeting 1 month, I believe it was argued as well.
The emails corroborate both that and the prior
Right.
appeal.
Okay, meeting 1 month, okay. September is, okay, it would appear that she was probably going to AA or something else.
That's the inference that they
Right.
draw from that.
Not an unreasonable inference out of if you look at the email.
It's in her own words. I'm going to allow it.
Finally, the last page, which is bait stamped 5591, I believe that is a duplicate of W12, or what's in W12.
5591?
That's the last page that the court has of Y3.
Oh, okay, just 1 second. Okay.
Exhibit W12.
And you agree that, so we can withdraw this one, or the council can withdraw this one as well.
We'll withdraw this one as long as W12 comes in, which
Okay.
is basically therapist Catherine Bean.
Right, and that's been testified.
Yeah, the
to.
court
Okay.
already ruled on W12.
Just if you're withdrawing it, make sure that Wendy knows.
Right.
The last page of Y3 is withdrawn. So instead of being 3 pages, it's 2 pages.
Right. Y3 may have had a number of pages. It's only going to be 2 now, and then W12 will have that other page.
Okay, make sure that Wendy knows.
Okay, we'll check with her.
Your Honor, finally is Y10. And
Okay.
as the court will see, just the first 2 pages of Y10, there's just a couple of highlighted portions,
Right.
and we'll submit on that what the court decides.
Yeah, we agreed on most of it, just there's a couple of little teeny.
You can't agree on to take those out?
Well, which ones?
The ones that are highlighted? I mean, I commented on that when I saw the letter the first time.
Yes, we'll submit.
They're to be stricken.
Thank you.
Thank you. They don't provide anything that has anything to do with this case. Okay?
I believe that's it, and there's F8 and Q10, but the council agreed that there was no testimony to support that, and I think that's out.
Okay?
Thank you, Your Honor.
All right. Stay here. Okay. I'll see my guys in chambers. Thank you.
All right, moving to the next video, which is 24 minutes. The jury deliberates in the trial of Phil Spector.
Present. The jurors and the alternates are not present.
I'm going to be right back. I'm going to go to
We have 2
McDonald's.
issues that we have to deal with.
I will be watching
One
on
may
my
or
phone
may not be
and in the
dependent
chat.
upon
I'm
the
going to
other
go get a
one.
biscuit.
And then we will
back.
see what happens.
If this
The
does switch
jury-
over to another video, it might not be full screen, but the sound should continue rocking and rolling. But it won't be long. I'll be right back. It ain't that far away. It's about 10 minutes. I probably will be a little bit later than this video, but I'll be right back.
has announced to the clerk that they believe they are hung. I have no idea what any numbers are.
They're already hung. They're already freaking hung.
Or whatever anything else is. We'll find that out when we call the
Thank you,
jurors
brother.
in. However, in the meantime, and this may or may not be mooted out
He makes
by
them
what
keep
the
going.
jurors tell us, I have been reviewing some case law, and I have become extremely concerned that despite both parties' belief that this was an all-or-nothing proposition, which I agreed with, and said I couldn't come up with the theory that would support manslaughter instructions, that in reviewing a case in specific, a California Supreme Court case, I believe I may have a sua sponte duty to instruct the jury on manslaughter, which would necessitate reopening argument. We'll see when we talk to the jury. The case I'm relying on is People versus Lee, 20 Cal 4th, 47. And I'll tell you what the facts of that case are, because although they're not directly on point, there's some matters in that case that are leading me down this path. And of course, I'll hear from you before I make any decisions, and we're all going to hear from the jurors and see sort of what where they're at. In the Lee case, it's a husband who killed his wife. There was a gunshot. It was a contact wound. No one knew exactly how the shot ended up there. The children had observed the father kill the mother or heard the shot. They had seen them arguing. They had seen a gun. Forensic examination showed that it was a direct wound to the head. Under those facts, the Supreme Court, in a plurality, not a majority opinion, although several of the justices in a dissent on other grounds joined in the thinking of the plurality written by Justice Baxter, he held that brandishing, you would think that it was only an assault with a deadly weapon, if you will, if there was any crime because of the contact wound, that brandishing was an included and necessarily lesser offense, not related, but lesser. And the court had a sua sponte duty to instruct on it. Justice Rogers, in her dissent, she concurred, which gave it a 4-3 vote. She was very unhappy with the majority's finding that. In fact, she went to great lengths to point out, much as in our case, that the facts did not seem to support it. What we have in this case, and it's a phrase that was often used, the absence of evidence is not evidence. But we don't know what happened in this case. The people have a theory. They've supported that theory by their 1101B evidence. The defense has a theory. But the fact is that we don't know what took place and how the shot took place. And I need you to look at that case. And you can brief it, you can orally argue it, you can do anything you want with it to convince me that I don't have a sua sponte duty to instruct on the lesser included offense of involuntary manslaughter, which if I do, and I'm not saying I will, I'm not saying it's appropriate until I hear from the jury, that this case will have to be argued on that limited proposition. You would have a right to re-argue it because no one has told the jury how it fits in. So I just want to let you know that. With that in mind, now we'll bring out the jurors and the alternates and find out what their issues are. Yes.
I just want to indicate one thing.
Yes.
We're not going to argue from the hip.
Oh, no. Oh, no.
I don't want to do that. I want the opportunity to look at the case, do the research.
You're not arguing today. That's not what I'm indicating. I would probably send the jury home if I reached that conclusion.
Let's see what we get.
We would ask the court not to inquire as to a numerical split in this matter. There is a body of law that seems to suggest that if the split is lopsided, any effort to urge them to continue to deliberate would be coercive. We would ask the court simply to inquire if anyone thinks that further deliberations would be helpful in reaching a verdict. If anyone says they would not be helpful, we'd ask the court to declare a mistrial at that point.
You better give me a case that says I can't inquire as to how they are numerically split.
I don't have a case that says that, Your Honor, but I do have any number of cases. I'm sure the court's familiar with them, with the concept that, certainly if the split becomes known, it's the end of the story. But there are...
Well, it's the end of what story?
If they come out and tell you, for example, it's 11-1 for not guilty, and the court sends them back in to continue deliberations, that would be improper. Likewise.
I'm sorry, I have never quite heard of that. You want to give me a case on that?
Yes, Your Honor. The People v. Proctor, which is 4 Cal 4th at 499, I think the particular quote is probably found at about page 538.
Okay, give me the quote.
I'm sorry?
Could you give me the quote?
I don't have the quote, I just have the holding, Your Honor. And basically it says, as I said, that if the the way the split is determined, guilt versus innocence or vice versa, that it is improperly coercive to continue the deliberation. And there is a string cite included at that page that I referenced.
Okay, I'm going to go take a look at the case before we do anything else.
Yes, sir.
What's the exact note that the jury sent? Can we?
They haven't sent a note. They just told Wendy that they were hung. Or if they have sent a note, I haven't seen it.
I'm sorry.
Okay. Is this what's in the folder? Okay. Exactly what they said. The jury has reached an impasse. We do not feel we can reach a unanimous period. I assume they meant a unanimous verdict. Okay, I'll be out shortly.
Your Honor,
Thank you.
while the court's back there, I would ask the court to, just to save a little time, the court may want to take a look at People versus Moore, and I'll give you the site. It's 96 Calat 4th, 1105. 96 Calat 4th, 1105.
For what
Specifically
proposition?
at, I think about 1118, page 1118. In that particular case, the trial judge gave a pinpoint specific instruction, the language of which has been upheld post-Allen, the Allen instruction, which was problematic here in California. In this case, actually gives the language of what is proper for a trial court to ask the jurors to continue deliberations if the court reaches that conclusion that it needs to do that.
I'll look at that as well.
Okay.
Yes, Mr. Rosen.
Can I see the note?
Sure.
Can I give the court one additional cite, please?
Yes.
It's People v. Carter, 68 Cal 2nd, 810, and the relevant language is at 816.
Okay. Thank you. We'll be in recess.
And, Your Honor,
Yes.
during the recess, would it be possible if we could try to reach Mr. Reardon and perhaps
Sure.
him in?
Yes, absolutely. All right, back on the record. I think, Mr. Bruno, you and I were talking at cross purposes because I just don't think I heard you right, because I certainly can inquire how they're split numerically. It's just I never have the jury tell me which way they're leaning. But certainly...
We're saying the same
We're saying the same thing. That's why I was so surprised.
However, I was taking it a step further, just based on the federal jurisprudence that has held that a determination of even the numbers on each side of the issue can in and of itself be coercive if there is a substantial majority on one side or the other.
And you realize the case you just cited specifically says that we're not bound by the federal system and in fact upholds the way California does it.
That's what gave me the idea, Your Honor. The law is not a static thing, and we always want to make sure that due process proceeds apace.
Okay. All right. We're actually saying the same thing in different ways. I've also taken a look at the Moore case, which the people cited, but I think it's premature to even worry about going there at this point until we find out what the jury wants, needs, or what their feelings are. So let's bring in, do we have the alternates as well?
I do, Your Honor.
Okay, why don't you put them in the box first, and then we'll bring out the jurors. All right, the jurors and the alternates are now present. Juror number 10, you're the foreperson of the jury? Yes. You've indicated by a note that you believe that you are unable to arrive at a decision in this case?
Yes.
How many ballots have you taken? 4. Without telling me which way the vote is going, I just want 2 numbers. Can you tell me what the numbers are, how the jury is split? Do not tell me how many in favor of guilt or how many in favor of innocence, just the numbers.
7 and 5.
7-5, okay. I need to make some inquiries of you, and then I'm going to inquire of the other jurors as well. There are many things that the court can do to assist you. I can reread specific instructions. If you have an area of the law that you believe is troubling you, I can either seek to find further instructions or perhaps clarify the instructions as written. I have the power under certain circumstances to allow the parties to re-argue all or a portion of the case to you. Do you believe as the foreperson that any of these might assist the jury in resolving its dispute?
We've discussed that at some length. I believe it comes down to the individual jurors' conclusions that are drawn from the facts. At this time, I don't believe that that anything else will change the positions of the jurors based on the facts that are in evidence.
Okay. I'm going to ask each juror whether they agree or disagree with that, and please feel free to state your mind. Juror number 1, do you agree with that? Juror number 2?
Yes, Your Honor.
Juror number 3?
Yes.
You hesitated. Do you think there's a chance that there are certain other things that the court does that might assist the jurors?
Possibly rereading some instructions that might not be clear.
Okay.
to people.
All right, thank you. Juror number 4?
Yes.
You think there's more that can be done, or you agree with the foreperson? Thank you. Juror number 5?
Yes, I think that, as juror number 3 said, if we could get clarification on a couple of the instructions.
Okay. Juror number 6?
I agree with the 4, please.
Thank you. Juror number 7?
I agree with the 4.
Thank you. Juror number 8?
I agree with the 4%.
Okay. Juror number 9? Just speak your mind, sir.
I think there's maybe something we could read back. I don't think that's the case.
Okay, thank you. We don't have, juror number 10, I assume, is that your position or not? You may be speaking on behalf of the other jurors. You think there's anything more that can be done?
I honestly don't.
Okay, thank you. Juror number 11? Okay, and juror number 12?
Maybe, but I think it's a long shot.
Okay. Can I ask juror number 3 what area of instructions you think might be useful?
Possibly the reasonable doubt.
Okay. Juror number 5?
Special instruction 3.
Special instruction 3, thank you. Juror number 9?
I think the difference between reasonable doubt and just doubt.
Okay. All right. What I'm going to ask you to do at this time, ladies and gentlemen, I would like the jury to go back to the jury room, not continue deliberations. I need to talk to counsel. The alternates will go with the bailiffs, and then we will reconvene shortly, and I will tell you how we're going to proceed in this matter. Thank you. Keep in mind the admonition. What it is my intention of doing, you're welcome, at this point is to allow the jurors and the alternates basically to go home for the day. I want to discuss some of the things that we discussed prior to them coming out, and we can decide how we're going to proceed at this point. I certainly have some ideas, but I'll be glad to listen to any input from you. And I think if we do that, then we'll have a little more leeway. All right? All right, let's bring back the alternates and the jurors as well.
Your Honor, before we do that,
Yes.
just so the record is clear, we are asking at this point that the court declare the matter a mistrial and discharge the jury.
The motion is denied, especially in light of the fact, and that's not controlling in any event, but the fact that 3 of the jurors believe that further instructions would be helpful, and especially in light of the comments that I made prior to the jurors being brought out, that I think we may need to re-instruct the jury and re-argue the case on the area that I've indicated. That would be inappropriate, so the motion is denied. All right, the jurors and the alternates are now present along with the parties. Ladies and gentlemen, what I'm going to do in this matter is follows. It is a possibility, and I merely say this is a possibility, that I will give you some further instructions tomorrow. I'm going to send you home for the afternoon. I want you to take a break. I want you to just put the case aside for the rest of the day, and when you come back tomorrow, we'll have some further guidance as to where we're going. There is also the possibility, and it's just that, it's a possibility, that I may have the attorneys re-argue a portion of the case to you, and you may have some new instructions as well. With that in mind, it's very important, especially at this stage of the proceedings, keep in mind the admonition. Don't discuss the case among yourselves. Don't allow others to discuss it with you. Don't form or express any opinion on the case until you come back and you're actually involved in deliberations. Just set the case aside for the rest of the day. We'll see you tomorrow morning at 10 a.m. 10 a.m. tomorrow morning. You're excused at this time. Thank you. It's going to be a little while because they'll line up at the elevator and it's take some time before they're out of the hallway. Actually, Wendy, why don't you just close the door? Take care of that problem. All right, the jurors and alternates are now both out of the courtroom and out of hearing. Here's what I suggest we do. I suggest that we recess, that both sides take the opportunity to take a look at the Lee case. You need to look at Justice Brown's dissent because she sort of arrived at where we did originally. You're not going to get a lot of guidance by Justice Baxter's opinion in the sense that it details the analysis. It sort of comes to a conclusion, basically that, you know, even with this set of facts, that still you would need to give involuntary manslaughter. So I want you to take a look at that. The defense will have a chance to discuss it with Mr. Reardon. You should also look at the Moore case and see whether both sides deem it appropriate. I think I know what both positions are going to be. Yeah, that's 96 Calap 4th 1105. And the instruction that the court ended up giving begins on 1118 of that opinion. And take a look at how appropriate it might be to give that instruction. I need to have you, however, we need to be ready to go forward, even if I choose not to follow this route and give any instructions pursuant to People versus Lee. You need to get ready to argue that limited area of evidence. It shouldn't take very long. It's basically arguing the instruction and how it applies or doesn't apply to the evidence. So something you need to think about. My guess is it would take approximately, and I won't give you a limitation, but I would suggest that probably 30 to 45 minutes would be more than sufficient for each side to argue this. It's per side. It's not going to take very long.
Divvy up the arguments.
I would treat it the same as I would closing argument. People open, defense responds, people close. It's that simple.
Your Honor, am I hearing in your comments here that you're going to have us come back tomorrow morning and make this decision?
Yes, but you need to prepare tonight as though the decision was made. And I'm not suggesting it is. I'm simply saying that the jurors, I don't view this as being complicated. Now, if you think that there's a problem, then both sides should let me know. I suppose we certainly could, if I decide to go that route, that I certainly could put it over till Thursday.
Your Honor?
Mr. Reardon, yes, a voice.
Yes. Are you able to hear me, Your Honor? I had a suggestion.
Yes, Mr. Reardon, I can hear you well. What is your suggestion?
My suggestion, Your Honor, is that you've denied the mistrial motion, and there's been some specific requests from the jury, I believe, for some testimony and re-instruction on reasonable doubt and so forth. My suggestion would be that tomorrow morning, the jury receive the guidance they specifically asked for, the re-instruction and any testimony. I think the course of instructions on lessers is such a big issue that my suggestion would be that we give them what they've asked for, we see if it makes a difference by the end of the day, that by tomorrow at the close of day, that you receive written briefs on the question of re-instruction, because I do think there's a good deal of law that you'll want to consider. And then if the jury hasn't made a breakthrough by the end of tomorrow, that on Thursday morning at 9, we argue the issue of whether you're going to go ahead on the lessers. If you decide not to, you decide not to. If you decide to, that would mean that the parties have had till Thursday to prepare their opening or their arguments on lessers. But I think the whole trial hangs in the balance of making a correct decision on that, and I think the court would benefit from getting written submissions that could be to the court certainly by tomorrow afternoon.
Thank you. The bottom line is I'm not so sure that I need a written brief. I've already researched this issue when I found the case on my own. I think what the jurors were asking for was not rereading of testimony. I think what they were asking for was a rereading of the reasonable doubt instruction, or perhaps something more. The court would never reword the reasonable doubt instruction. Basically, it is what it is, and that's all they're going to get on that matter. I'm not sure that that by itself will help them, though I will be happy to do that tomorrow. If counsel feels that they need, until Thursday to be ready for argument, if that's the way we go, I probably have no problem with that, assuming the jurors have no problem, and I have no reason to believe that they do. But time to prepare a brief I don't think is necessary. The bottom line is, if the court should have instructed despite what the parties wanted, and I'll allow anyone to give me input on Lee or any other case that they find, I don't think I need written briefs for that. And certainly it appears to me that that probably is something the court is going to have to do no matter what. How that might affect the jury ultimately, I don't know. I'm happy to give them what they want at this time, but based on 25 years of experience, rereading reasonable doubt rarely has any positive impact. I'm not saying it won't, but it rarely has any great change, or have I seen any change in a jury's impasse based upon the rereading of the reasonable doubt instruction.
Your Honor, could you now give us to Thursday to prepare argument if we're going to do argument, re-argue the jury on the lesser offense? It's going to require us to split our effort this evening to first address the procedural question and then try to muster an argument. And I think we'd all be more comfortable, at least on this side of the table, if we knew we had until Thursday to formulate an argument in that regard.
Okay, people wish to be heard?
Well, we're ready to argue tomorrow if it fits within the court's time frame. We could argue this tomorrow.
I'll give you till Thursday. So what our schedule is now, we'll bring the jury's coming back at 10. I will happily reread the reasonable doubt instruction to them. I don't know if that's going to do any good. I've sort of given what my opinion is. We can argue as to the appropriateness and the legality and any other issues we want on the giving of involuntary manslaughter, and then if the court decides to do that, we would be prepared to go forward Thursday morning.
Thank you.
Well, one point of clarification.
Yes.
If the court does go in that direction, the involuntary manslaughter, will the court be giving a stone instruction?
I may or may not. I'll take a look at it. There's two different versions, at least there were in CalJIC. I have to see what's in CalCrim these days. I think there's still two different possibilities of dealing with lessers, and in all likelihood, the court will give one of them. I don't know which. It's really, at this point, it's a matter of simply telling the jury how to go about going through the greaters and the lessers, and ultimately they arrive at the same place. It's just a different procedure for doing so, so I don't think that's critical to anything the defense is doing.
Right, and they've already considered the greater, obviously. And
right.
We understand. Okay, thank you.
Okay.
Is there, if the court, since at least I think two of the jurors indicated that they were interested in the reasonable doubt instruction, if the court goes ahead and instructs them tomorrow on the reasonable doubt and allows them to continue deliberations while we formulate our arguments on the potential lesser, would the court allow us to argue on 2 points, reasonable doubt and the lesser? I think those 2 points.
Well, I think you're always arguing reasonable doubt. I consider that part.
Okay, I just don't want to be hamstrung by that's part and parcel of arguing a lesser or any other crime. So
I would also indicate that something you need to consider for tomorrow, whether or not, if I choose, and I have no opinion at this point, the so-called Moore instruction, I would give that tomorrow. So you need to think about that, and obviously it would have to be rewritten somewhat because it refers to CalJIC instructions that are no longer. If anybody wants to have a proposed instruction, that's fine. You can certainly offer that, and we'll see where we are. So I'll see you at 10 o'clock tomorrow. Actually, I'll see you at 9:30 tomorrow morning.
sounds good.
Okay, thank you. We're in recess. All right.
All right. Sorry about that. Last 5 minutes of this, we're going to go back.
Before this court is now in session, the Honorable Larry Paul, Judge presiding.
All right, back on the record, the defendant's present with his counsel, the district attorneys are present.
This is the 2-hour, 16-minute video.
There are several issues that we need to address this morning as follows. One, whether the Lee case that I cited to you yesterday mandates, if you will, a lesser instruction of manslaughter in this case, which would then lead,
bacon,
if
egg, and
so,
cheese and McGriddle.
to question number 2, whether it would be appropriate at this point to
Super unhealthy.
instruct the jury given the timing. That's one set of issues.
Also, Bluebird, I said it in the chat, but thank you so much. I got you on the wheel. Welcome in here.
Did the court say manslaughter or involuntary?
Involuntary. I just said manslaughter. I didn't say voluntary or involuntary.
Okay. Make sure.
We've only been talking about one theory. Okay. And then a further issue that needs to be addressed that I'm not sure that the parties have addressed or are aware of, but yesterday one of the jurors indicated there was some problem with special number 3, and we need to address whether that is an appropriate statement of the law. It is an appropriate statement of the theory of the people's case, at least as articulated during the trial, but whether it's appropriate and whether there's any remedy for that. Then we also need to address whether the so-called Moore instruction should be given, and if so, in what form, and whether reasonable doubt instructions should be reread, and also whether the possibility of re-arguing the case is appropriate, depending on what the court finds. So I'm happy. I've read and considered the memorandum filed by the defense this morning, and I'm happy to hear from anyone who wants to address the issues. Mr. Dixon?
Yeah, just one issue really first that involves all this. If, let's just assume, if the court is right and decides that under Lee, the involuntary instructions should be given.
Well, it's not right or wrong. It's a question of whether Lee applies. I pointed that case out. I'm concerned about it.
Let's just assume for discussion that it is. The jury's continuing to deliberate. If the court comes to the conclusion that the lesser included should be given, and between now and that decision or the argument in the instruction, the jurors reached a verdict, wouldn't there be a problem?
There would be, but I don't believe the jurors are doing very much. They're waiting for further instruction from the court. They indicated, and I indicated, I believe, to them yesterday that we would be doing some further things tomorrow, which is now today, and to just take a break from deliberating. Okay? Mr. Bruno?
Yeah, good morning, Your Honor. First, I want to apologize to everybody for keeping you waiting.
That's okay.
I went in this morning and got so engrossed in the law, the time just slipped away from me.
Okay.
Your Honor, in the first category of issues that we have, well, first of all, let me just say this. Mr. Spector would like very much for the court to defer these arguments until tomorrow morning when Mr. Reardon can be here. Mr. Reardon prepared the brief overnight, which we filed this morning. He is intimately familiar with all of these issues, and Mr. Spector has asked us to request the court to put us over until tomorrow morning.
I think we can go ahead and argue. It's the content that's controlling. I mean, not that anyone's argument isn't persuasive. It's the facts and the law, which I think is pretty well set forth. You may proceed. Thank you.
Your Honor, in regard to the first two categories of questions that the court posed having to do with the lesser included, there are three significant problems that face the court. Whether or not the defense was given notice that these charges would be offered by the prosecution and considered by the jury, whether or not there is evidence in the record to support the giving of an instruction that would support a verdict on an involuntary manslaughter, and then finally, and perhaps most critically, whether or not what appears to be an absolute prohibition by the Supreme Court on opening or reopening jury instructions after deliberations have significantly been undertaken. Just, if I may, to recapitulate how we got to this point, from the time of the indictment, and in fact, even prior to the indictment, but certainly as incorporated within the indictment, the prosecution has had one theory in this case from the beginning, and that is that Mr. Spector placed the gun in Ms. Clarkson's mouth and pulled the trigger. That was true at the time of the indictment. That was true throughout our pretrial litigation and trying to narrow the issues and bring the evidence into focus. That was true in opening statements. That was true in closing statements. The prosecution has never taken the position, we have proven beyond a reasonable doubt that Mr. Spector put the gun in Ms. Clarkson's mouth, but we've also proven beyond a reasonable doubt that he didn't, that he did some brandishing, he did some other activity. And given the caliber of attorneys that they are, they would never take such diametrically opposed positions. Two opposites can't both be true at the same time. So they have elected to proceed on that theory, and we, in turn, have taken the other side of that coin. We have always taken the position that Mr. Spector did not cause the death of Ms. Clarkson, did not place the gun in her mouth, that she did it either intentionally or inadvertently based on the factors that have been presented to the court. So in terms of having been given notice that these charges would be brought, it simply never was contemplated by either side, by the court, or by anyone. That's an important component of due process, being able to address the charges that are made, and we simply haven't been given notice. Additionally, the second question is whether or not the evidence would support the giving of an involuntary manslaughter instruction. First of all, we'd have to fix upon a theory of culpability. Is it brandishing the gun? Is it a form of intoxication? Is it some form of gross negligence? To this point, the court, well, I assume the court doesn't know. I certainly don't know what the theory would be, how that would be articulated. And the court very presciently, at the time of the instructions conference, made this finding. He said, I have for weeks now been thinking of alternatives, and what if this, what if that, just sort of trying to get a head start on whether there is a possibility of voluntary manslaughter or involuntary based on the facts of this case and also based on the defense. I don't see it. The reason you didn't see it, Your Honor, I would submit is because it wasn't there. The court went on to say the problem with a sudden quarrel would be there is the reasonable man standard, which I don't think anybody would say has possibly been shown, which would mandate voluntary manslaughter. That's true. We never indicated that this was a shooting that was based upon any kind of provocation. That would be antithetical to what we have maintained. Likewise, there's been no evidence of brandishing in this particular case. There's been no evidence of any particular gross negligence that has been proffered by evidence and argued to the jury. So when the court found that there was no factual basis to give that instruction, the court was correct. Now, nothing's changed since then. Obviously, the evidence hasn't changed. The Supreme Court hasn't enlightened us with a new case that has opened new possibilities of criminal culpability. The only thing that's changed, Your Honor, I would submit, is that the jury appears unable to reach a verdict based on the evidence that they have and the instructions that they've been given. And for the court now to say, well, let's throw something else into the mix, can be perceived. I don't think it would be intended, but it could be perceived as an effort to get a verdict, any verdict, because we've put so much time into this case. And I'd submit that that simply would be an improper thing to do and wouldn't be warranted by the evidence in this case. Now, the court has brought up Lee, and on first blush, Lee appears to be opposite, but when you carefully read the case, it is, first of all, strange to begin with, the procedural history and how it got to the verdict and how the issues got to the Supreme Court. But if you distill it down to the issues before this court, does it require this court at this time on this record to give an involuntary manslaughter instruction? And the answer is it clearly doesn't. The case in that regard stands for no more remarkable proposition than the fact that if there are two theories of involuntary manslaughter that have been proffered to the court, in that case the intoxication to the point of unconsciousness or some form of gross negligence in pushing around a person with a gun in your hand, then the middle leg of involuntary manslaughter, that is misdemeanor manslaughter, in that case posited upon the predicate offense of brandishing, should have been given sua sponte. But the facts of that case fully supported the other two theories, and that theory for that matter. There was direct evidence of brandishing. There was compelling evidence of gross intoxication to the point of inability to form an intent to kill. There was also evidence of gross negligence, a drunken man waving around the gun. We don't have those theories in this case. They potentially could have been developed. They weren't. The evidence doesn't support that. And Lee does not support the proposition that at this point in time the court should, on this record, give that involuntary manslaughter instruction. Finally, and probably most compellingly, the Jennings case, and I assume the court got the corrected citation.
I did.
That case simply is kind of a reiteration of the Stouter case that was decided at the beginning of the last century.
1904.
Right.
Yes.
But sometimes the old rules are good rules, and just like sometimes old lawyers are good lawyers, there's something about the venerability of a principle. And in that case, the Supreme Court held that after the jury deliberations have begun.
I thought I had muted my mic. You guys just heard me eat all of that. I'm sorry about that. Jesus.
It is improper to, and an impasse has been reached. It is improper for the court to say, well, let me give you another way to get to a guilty verdict. In that case, they instructed on an attempt that wasn't warranted by the evidence. Although an attempt was clearly a lesser of the charged offense. Jennings restated that principle in a rather matter-of-fact way. In that case, the jury was instructed on the principal offenses of assault with intent to commit murder. The court rejected an included offense of assault with a deadly weapon, as well as an included lesser offense of simple assault. The 245, the assault with a deadly weapon, was rejected on a constitutional argument that is no longer applicable, but wasn't rejected because it wasn't a lesser. So the court initially refused to give lesser instructions on the 217. The jury was unable to reach a verdict. The court reconsidered and gave instructions on both of the lessers, the 245 as well as the, looks like a 240. The Court of Appeal said that's absolutely prohibited. You can't do it because it's coercive, because Stouter says you can't do it, and it invades the jury's province. And it does appear that the court is attempting to suggest how the jury should decide. And there's been no case that has qualified that. Jennings itself referred to the, I think it was Butler was the name of the other case that in kind of passing and in dictum said, yes, this is what Stouter says, once the deliberations have begun, you cannot instruct on lesser included if they come to an impasse.
Do you want to give the reporter, I don't mean to interrupt, but give the reporter the cites on both Stouter and Jennings?
Yes, Your Honor. Jennings, the correct citation is 22 Calab 3rd, 945. Stouter, the case that it relies upon is spelled S-T-O-U-T-E-R, and it's 142 Cal 146.
Thank you.
So for those three reasons, the court at this point should not re-instruct this jury on any lesser offense and consequently should not require us to argue any lesser offense.
Thank you very much. People?
Judge, can I just add?
Yes, Mr. Rowan.
Mr. Brunon touched on this, and I just want to refer the court to volume 64, which is dated August 29th of 07. And that was the volume that Mr. Brunon was citing from, and he cited in part the discussions that went on regarding the lessers, but there was a little bit more, and I don't know if the court's had a chance to look at it or not, but I did last night. And I noted that the court not only went through the decision-making processes, Mr. Brunon has indicated that, in fact, lessers would not be included because there was no evidence of it. I would pick up on page 11004, and herein I'd just like to read for a moment, if I may. The court, right, I think initially when the case started out, there was a lot of talk of alcohol intoxication, but nothing was presented to the jury that would be sufficient to proceed with that. So based upon that, the court will instruct only on murder. And Mr. Jackson interposed a concern at that point. I don't know if the court recalls it. And it goes on to say, Mr. Jackson, Your Honor, on that note, the court, yes, Mr. Jackson. And following up on that, what Mr. Reardon just indicated, one of the things I spoke with him briefly off the record this morning, what it was is Mr. Jackson was concerned about somebody making an argument that a lesser would be appropriate in their argument, even though they weren't being instructed on it. And he goes on to say, he said, referring to Mr. Reardon and myself, that they are not going to engage in any gamesmanship wherein they don't ask for a lesser and we don't ask for a lesser, and then someone stands up in front of the jury and says, quote, now we don't think he did it, but even if he did it, he didn't do this crime. There is some other crime he may have committed, close quote, et cetera, et cetera. That's Mr. Jackson. And the court responds, the court, how could they, given the fact I am not instructing Mr. Rosen? It would be totally improper. The court, I would cut that line of argument off immediately. Mr. Jackson, I agree, Mr. Rosen, it would be improper. And it goes on. But I think that's important, too, because it not only contributes to the discussion that the court counsel had, it really set a very bright line distinction in the sand. And one point that was made in the brief, and Mr. Brunon very eloquently touched on it this morning, I think it needs emphasis, is that, as Mr. Reardon said in this brief, and I think he wrote a very excellent brief, the point is that nobody, starting back in September of 2004, when this grand jury was convened by then Deputy District Attorney Doug Sortino, if I went back last night and I looked at his opening statement and I looked at his closing remarks, and there was never, ever, even over 3 years ago, the slightest indication that this case was ever going to be tried on anything other than the theory of second-degree murder supported by an implied malice consideration of the evidence and the facts. And he stated that back in September of 2004. Nothing changed during that time. Certainly nothing changed during the course of the presentation of evidence by either side in this case. And because of that, that's how it was defended, as Mr. Brunon said. We defended this case and responded to this case based on the government's theory from September of 2004. It never changed. Things may have been done, probably would have been done, in fact would have been done quite differently had there been that consideration from the start. There wasn't. And you can't cure it now. I mean, the evidence is in, the arguments have been made. So I just want the court to take that into consideration. It was addressed by Mr. Reardon in his brief, but I felt that it was important just to read from the transcript of the time that we did have these discussions several weeks ago on August 29th.
Thank you. People.
Your Honor, may I, with the court's permission, stay seated?
Yes.
My notes are kind of spread out in front of me. It appears that the defense's arguments concerning the first point and the second point are sort of interlaced between them. The notice requirement that Mr. Brunon touched on, and the point that both Mr. Brunon and Mr. Rosen just made about having the record not bearing out evidence to support the giving of this instruction, they both kind of overlap one another, and I'll try to address each in turn, and I'll use Mr. Reardon's moving papers as a guideline. Mr. Reardon indicates at first blush that there are three factors that he believes are determinative in this court's decision as far as giving an instruction or not giving an instruction concerning the lesser. He says, number one, that there's no substantial evidence in the record to support it. Number two, that we, the prosecution, never articulated the theory that this was anything less than a second-degree murder, implied malice murder. And number three, basically an amorphous complaint saying the court would be treading on thin ice to do it. First of all, there needs to be a distinction made between what the defense is saying is no substantial evidence supporting the theory. And that kind of, like I said, interlaces into the notice requirement. It's impossible to say that there's not substantial evidence in the record to support a misdemeanor manslaughter instruction. What I'll phrase it as a misdemeanor manslaughter instruction based on brandishing. That's impossible to say. When the court spoke on the record, which Mr. Brunon quoted, And the court indicated, I don't see it. And you remember that dialogue that we all had. And you said, if this is anything, I mean, he put the gun in her mouth. If the jurors believe the facts as they've been presented, the gun was actually inside her mouth, and everybody here at the tables would agree that that is, in fact, an assault with a deadly weapon. It goes beyond brandishing. And that word beyond is the seminal phraseology. It's not that there's no evidence to support brandishing or support the misdemeanor manslaughter. It's that we all surmised that the conduct was grave enough that it subsumed misdemeanor brandishing and went beyond it to a different degree. The same as Justice Brown articulated in her concurring opinion, and I think that's why the court pointed us to that language in Lee. In her concurring opinion, Justice Brown said something to the effect that in that case, under those facts, in her opinion, that a reasonable jury would have to believe that the conduct went there to the manslaughter and substantially further. But the manslaughter is in fact factually and legally subsumed within the conduct of the assault with a deadly weapon in that case. And I'll get to Lee in just a second, and I believe the court is correct. Lee is factually foursquare with the facts that we have before us on several grounds. So I want to make sure that I start out by saying what the proper playing field should be. There is no reasonable argument that the facts don't support a brandishing. You can't assault someone with a gun without first brandishing that gun. I mean, everybody would have to agree with that. The defense, all the defense lawyers would have to agree. Therefore, it is supported by the facts. The court took the position, and I think we all did, that, yeah, it's supported by the facts, but my goodness, based on these facts, it appears to go beyond that as well. Actually going into an assault with a deadly weapon, actually putting a gun in someone's mouth. That is a far cry from saying the facts don't support it. So with that said, I want to talk a little bit about the notice requirement that I think is interlaced with this argument. There is no difference in the prosecution's theory, my theory, Mr. Dixon's theory, the indictment, the opening statements, the closing arguments, the rebuttal argument, the facts that we've presented. There is no factual difference at all. Not one thing would have or could have been done differently had we been deciding from the get-go to include a lesser included of manslaughter. The facts are the facts are the facts. We wouldn't change our theory. If I stood up and re-argued to this jury, I wouldn't change my theory, and I would tell them I'm not changing my theory. Our theory of the case is, and I believe the facts bear out the idea that the defendant actually pulled out the gun, put it in her face, it went off. During the course of that, in pulling out a gun, that is in fact brandishing. Brandishing only requires that you draw or exhibit a weapon in an angry or threatening manner. It's impossible, factually, legally impossible, to assault someone with a firearm without first brandishing it. Therefore, it's not that the defense hasn't had notice of what the potential crimes are. I mean, we can...
Two names away from a spin, only two.
Add counts or seek to amend complaints or seek to amend charges anytime before the jury returns with a verdict. It's perfectly appropriate. That's the kind of second point that I want to make sure we clear up, is that when the defense in Mr. Reardon's moving papers and in the arguments this morning from Mr. Rosen indicate we've never heard this, quote, theory before, I don't really know what they're talking about, because the facts have never changed. And the theory of brandishing or misdemeanor manslaughter is legally subsumed within any theory of assault with a deadly weapon or implied malice. The difference between an implied malice murder and a misdemeanor manslaughter, involuntary manslaughter based on a criminal act, for instance, brandishing, is simply the single element of conscious disregard for human life. All of the other elements are the same. If you add conscious disregard, which is an amorphous gray area kind of element, then you get to implied malice. Anything less than that without the conscious disregard is gross negligence or implied malice, involuntary manslaughter. So with those kind of preface comments, I want to speak to a couple of things that Mr. Reardon puts in his moving papers, which I think bear some discussion, not a lot. Mr. Reardon indicates, kind of to finish out his first point, that there is, quote, no evidence which would permit a reasonable jury to conclude that even if Mr. Spector held the gun in Ms. Clarkson's mouth, resulting in the resulting homicide was less than a malice murder. That is absolutely incorrect. Under a reading of Lee, Lee specifically addresses when the facts support something beyond but including the subordinate crime or the lesser included crime. And this is what Justice Brown was dissenting about, or why she wrote a concurring opinion separately. She agreed with the holding but disagreed in that one element.
Damn, 16 months. Thank you, Steve, for hosting the schoolish trial. No, thank you for sticking with me for this long. Holy crap. Also, 16 months. Quite the feat in itself, Kathy. Thank you so much. Happy anniversary.
And that's exactly what the Lee court, the plurality opinion, disagreed with on insofar as Justice Brown's articulation of what she thinks the law should be. They specifically addressed the arguments that are being made by the defense, the Lee court, and said, no, that's wrong. If the lesser included exists, and if it exists on these facts, it must be given, and it is error not to give it. With regard to Mr. Reardon's claim that Mr. Spector, that there's no evidence that Mr. Spector committed a non-lethal act that was the proximate cause of her death, that is absolutely incorrect also. The non-lethal act is the brandishing. A jury could decide that the defendant brandished a gun during the course of which the gun went off in her mouth. Plain and simple. No conscious disregard for human life, that is a misdemeanor manslaughter conviction. If they decide there was conscious disregard for human life and there was some other fact that persuaded one or all of them that there was something more that Mr. Spector did to put the gun in her mouth, then that would bump it up in that person's mind to an implied malice.
Notwithstanding Lee, if the facts are so clear, why didn't you argue them, and why didn't you ask the court to include lessers?
There were discussions held about that, and we all agreed that, in fact, a brandishing at that time, it was my opinion, and incorrectly so, it was my opinion that if, in fact, we all agreed that brandishing didn't need to be given, that we could concede that fact. The court didn't need to give it. If tactically or strategically we didn't want it, and the defense didn't want it, we didn't need to go there. That appears to be absolutely incorrect. Lee doesn't give us that choice. Lee says that if we don't give it, and the facts support it, then that is error, plain and simple. The defense, and I would note this with regard to the notice requirement, the defense, Mr. Reardon specifically, I don't believe can make the argument that they weren't on notice that brandishing and that theory of liability was on the table, because at some point during either my argument or Mr. Dixon's argument, or both, Judge, Mr. Reardon approached the bench and said, hey, you know what, I think based on these arguments, manslaughter needs to be given. He's the one that said it. It's not like they weren't on notice that that was on the table or that was a potentiality. As a matter of fact, they asked for it. And the court decided...
Excuse me, they never asked for it. That discussion came up with, depending upon what your theory was and whether or not Instruction 3 was given and in what form, as to whether that might mandate manslaughter instructions, but the way it was finalized, they never asked for it.
The first discussion, you're right. My memory is after the animation was shown, Mr. Reardon specifically approached the bench and said, if their theory is something other than the gun was in her mouth, in other words, that animation shows something, and he didn't realize that the camera angle was simply from the mouth.
That's right. But
he said there has to be a manslaughter instruction.
But ultimately, you argued back, and you said that's not what the animation shows.
That's correct.
And that satisfied.
That's correct. And I'm not saying the court was wrong by not giving the instruction at that time. I'm simply saying the defense can't argue they weren't on notice that those facts existed, that that was a potential. They actually asked, hey, look, if that's where we're going, then this is an instruction we need and we'd like to have. So it's, I just say that to say the defense knew that this was on the table at some point. And to answer the court's question pointedly, why didn't we ask for it? Because it was a strategic position, our strategic position at that time, that it wasn't necessary. But that is not taken into account Lee. And I believe that if, in fact, the court doesn't proceed with the course it's going on, that there may be built-in error by not giving the jurors the instruction, by not giving
if there was a verdict, if this case were to proceed with a verdict, if the court was not to instruct on manslaughter, the theory of invited error clearly controls this. That's one thing we talked about.
And we concur with that. We're not changing our opinion. We do not believe the evidence supports involuntary. We're not asking for it. We're objecting to it.
All right. Thank you. You may proceed. Thank you.
So that I addressed that just to once again address the notice requirement. With regard to turning my attention specifically to Lee, and this kind of segues into what the court was just asking me about. In Lee, there was an individual who was in a fight with his wife, or argument with his wife. He had been drinking all night long. The argument escalated to one of physical contact. The defendant then walked away. The husband walked away, grabbed a gun. The daughter was watching as they continued to fight and watched as he brandished the gun in front of her, in front of the daughter. The daughter then leaves the room, and as the fight begins to escalate, nobody is in the room. There's no direct evidence as to what happened exactly, but there was a contact wound, a gunshot wound to the wife's head. She died. You have drinking, getting angry, a gun is withdrawn and utilized, and there's there's a contact wound to the head of another individual that's established through circumstantial evidence. In this case, Mr. Spector had been drinking. The facts support.
Yeah, Charlie Adelson's 2023 trial starts Tuesday night.
The following: that Mr. Spector had been drinking. That in fact, and this goes to another thing that Mr. Reardon put in his moving papers. He asks kind of a hypothetical question: where's the evidence that Mr. Spector ever brandished the gun? Well, the evidence comes from the 1101B witnesses. The evidence of motive is not simply what motivated him into the term we think about it. And the court has explained this over and over and over. It's how.
Just so you got to go buy a lottery ticket.
Certain emotional stimuli. We have 5 different women who show how he reacts to this emotional stimuli. When Lana Clarkson wanted to leave, there's circumstantial evidence, a plethora of it, that he became angry. He withdrew a weapon and brandished it, and she was shot to death with a near contact wound, a wound inside the mouth. I mean, factually, it's on all fours with what we have here. And the court in Lee, Justice Baxter said, writing the plurality opinion, the court didn't instruct on misdemeanor manslaughter, an unlawful killing without malice in the commission of an unlawful act not amounting to a felony, to wit, a brandishing. That was error. When the defendant used the gun in his quarrel with Nor, that's M-E-E-N-O-R, the wife, he violated Section 417, period. That is the violation. If it goes no further, the violation is there.
Betas. That was weird. It's interesting to know that it does fix itself when it happened when I was gone there for a minute, but I got you.
Committing the offense of brandishing. In Breverman, Supra, and they cite Breverman. Do you want me to cite it?
I have Breverman right here.
In Breverman, we confirm that the duty to instruct sua sponte on the lesser included offense is not satisfied by instructing only on one theory of an offense if other theories are supported by the evidence. And I think that's the seminal language that we have to look at, and that's probably what was missed when we discussed this at first. The question is not, is that the theory we're proceeding on? Because I'm not going to stand up and change my theory. Mr. Brunon's right. I'm not going to stand up in front of this jury and change a theory. If the court decides that it's appropriate to give this instruction, I will explain that crime is subsumed in the higher. That lesser crime is subsumed in the greater offense. The court says that obligation of the trial court exists even if the defense objects. Not just if they concede to it, but even if they were to object to it. Over everybody's objection, the court would have to instruct on that. And that's where I tend to think that we are beginning to get into very touchy territory if the court doesn't instruct on it, because I believe that a second-degree murder conviction would be subject to an appeal, be subject to reversal, because they weren't instructed properly on the lesser. And now is the time to do it. and I'll address the last point last because I think it's important to distinguish it, and that's the Jennings court. And I know the court is aware of Jennings. The defense cited Jennings and its predecessor. I think it's Souter.
Souter.
It's distinguishable, Judge. Now is the time that this court could and should instruct on the lesser if it believes that the lesser is mandated under Lee. Why? Because the court has not undertaken to engage in a dialogue with these jurors about why they are hung. In both Souter and in Jennings, more pointedly, there was a very specific discussion about exactly what the jurors needed to come to a conclusion. In Jennings, quote, a dialogue ensued between the court and the jurors, which made it apparent that the difficulty with the jury reaching the verdict lay in reaching a unanimous determination on intent to murder. So then the judge took it upon himself or itself to instruct on that particular issue and give a lesser included offense that would answer that question. In Souter, it was even more obvious. Quote, and this is Jennings quoting Souter. Many of the jurors had practically told the court what their opinions were, and that if the instructions were changed so as to meet their views, they could find a verdict of guilty, contrary to the former instructions, meaning the original instructions. The project of instructing the jury for the first time after they had been unable to agree for 24 hours, they might, notwithstanding the first instructions, convict the defendant of attempt was clearly an afterthought suggested by the statements of the jurors as to how they then stood, how the jurors then stood, and apparently intended to help them, not generally to arrive at a verdict, but to arrive at a verdict of guilty. That's not what this court has done. This court has not engaged the jurors in a dialogue to find out specifically what will help you reach a verdict of guilty or what will help you reach a verdict of not guilty. This court indicated before the jurors were ever questioned, before the court knew what split, if there was a split on this hung jury. The court indicated on the record, I have a concern about Lee. That is very different from what the Jennings trial court did and the Souter trial court did. They both undertook to basically impose a verdict on the jurors. This court, very distinguishable to those incidents, is simply saying, I believe that there is an issue that exists. It exists because of the Lee-Baxter decision, the Lee decision written by Justice Baxter. And having read Lee, I believe, and it's our position, the people's position, that the court is absolutely right. It is a mandated decision. I'm sorry, it's a mandated lesser included. We should have seen it beforehand. We didn't. But now is the time to fix it.
I'll correct it again. I haven't concluded that Lee mandates that. I pointed out that it might.
I'm arguing that it does. I'm simply making that argument that I believe, after reading Lee, I believe Lee does mandate that there is a lesser included offense that's necessary given the factual scenario in this case and its factual similarity to the Lee facts.
Oh, yeah.
Thank you. Mr. Bruno?
Baby Buzz. 4 months. Kicking its ass, Bluebird.
Esteemed
I appreciate your
colleague,
support. You've been awesome.
Mr. Jackson is trying to make a silk purse here out of facts that wouldn't even amount to his barnyard sow's ear. After killing that metaphor, here's the problem. Notice is a different concept than sufficiency of evidence. The fact that the prosecution may have proceeded on different theories ab initio, but didn't, deprives us of the notice that we're entitled to. Everybody at this table knows, for example, that murder, charge of murder includes first degree, second degree, both by implied malice as well as felony murder. However, we also know that if the prosecution chooses to proceed down the premeditation path, for example, that they cannot, at the time of jury deliberations and jury instructions, and certainly not during deliberations, change their theory to include felony murder. That's not just me saying that. That's Shepard v. Reese, which is cited in the pleading we filed. In that case, the prosecution proceeded throughout the trial, throughout the arguments, and up to the point of instructions on the theory that the murder was premeditated. Apparently having an aha moment overnight, the prosecution asked the next morning to also instruct on felony murder. On writ of habeas corpus, the federal court said you can't do that. The defendant is entitled to know the theory. If you're proceeding on a felony murder theory, you have to give him notice so he can defend against the felony. Well, that's the situation here as well. If the prosecution was intending to proceed on a theory that somehow, while Mr. Spector was waving the gun, it inadvertently or accidentally found itself in Ms. Clarkson's mouth and then went off without an intent to kill, they should have told us that so we could present our defense. The fact that they wouldn't have done anything differently is absolutely irrelevant. Would we have done something differently had we been advised of that theory? And the answer is yes. Next point. That's the notice point, which we haven't been given up until this point of what the theory is. Now we're seeing, or hearing, at least I'm hearing, that the theory is that because over the past decades there have been incidents of brandishing, therefore we approved brandishing in this case with sufficient clarity that the court should instruct on it, even though the court limited that evidence to motive, not common plan, not a conduct offense, but a motive, a state of mind, why he might have done something, not that he does this in these circumstances. And that distinction has been attempted to be obliterated from the first time it was raised, but it is the basis of 1101 jurisprudence. You have to limit the evidence for the purpose it was admitted. Now, beyond that, what evidence of brandishing in this particular instance is there? None. Only speculation based on prior conduct. What evidence is there of gross intoxication to the point of unconsciousness? None. Prosecution didn't offer such evidence, even in passing. Their witnesses didn't say that Mr. Spector was so intoxicated that he appeared to be nearly unconscious. This evidence doesn't put the court on notice that there is a viable involuntary manslaughter instruction lurking in this case. It's because there isn't. And then finally, attempting to distinguish Jennings and Stouter, with a T, on the fact that there was reference in both of those cases to the colloquy between the jurors and the judge is simply, I would say, grasping at straws. If that was a determinative feature in either case, both courts would have told us so. The entire discussion of the content of the dialogue in Jennings, for example, is there was a dialogue. If the nature of the communication is the determinative consideration, don't you think the court would have given us a little bit of guidance as to where the line should be drawn, how much information the jury has to disclose that would allow a reinstruction on a new theory after deliberations have begun? In Stouter, where there's a greater elaboration on the procedural history, the opinion in no way says, had the court made less inquiry, had the jury said less to the court, then this belated instruction of a lesser offense during deliberations would have been permissible. So that's simply an argument that's not supported by the case law. There are rarely absolute rules, but I would submit that the rule prohibiting the court from reopening instructions, argument, and ultimately evidence, because if we're going to argue about involuntary manslaughter, then we ought to be given the opportunity to consider what additional facts we can offer to either support or detract from that theory. It's simply not an appropriate thing to do at this point. It would be error for the court to do it.
Mr. Rosen, you're poised. Did you have something?
No, I was listening to Mr. Bruno, and it's a pleasure to hear him argue. 3 points very briefly. First of all, I'm sure the court and all counsel are familiar with the Lee case, and it may just be that Mr. Jackson misspoke. He indicated in his argument that there was no witness to the brandishing. That's not correct. Yeah, I'm lifting right from the statement of facts, and it says he, referring to the defendant, pulled me, spelled M-E-E, nor, N-O-R, from the kitchen sink where she was washing dishes into the hallway, where the couple continued to push each other with a gun between them. Mary went back to her bedroom. Mary, of course, is the daughter. So the facts clearly say that Mary was present when that went on. So it is different, very different than here, because you do not have an eyewitness to any brandishing whatsoever in the record or otherwise. The other point I wanted to make was Mr. Jackson indicated why they didn't ask for lessers and why they didn't argue it. And the only thing that's changed from their position at the inception, at the genesis of this case, which was in September of '04 when the grand jury was convened by Mr. Sortino, and today is what occurred yesterday in court when the jury was brought in and the court had colloquy with the jury. That's the only thing that's changed, nothing else. And I'm suggesting that the reason that the government is now taking the tack that it is that we're hearing for the first time, because they've never taken this tack before. In fact, their position has been exactly the polar opposite of that. But now this morning they come in and they argue that they want this lesser instruction and they want it badly. And again, you know, we can read the tea leaves, but on the other hand, I don't think it takes a great leap of logic to understand why they weren't happy with what they heard yesterday. And what I think that maybe they're thinking about is that term that always sometimes crops up in jury trials that concerns all of us, which is compromise verdict. And that's of great concern because that is not a reason to go ahead and violate, as Mr. Brunon said, the very clear law, which is stated here in Jennings, because what it says is, and the court's read the papers, is if you look on page 12, the portion lifted from the opinion by Mr. Reardon placed in there, the quote, is very telling, and it's very concerning, and that's not where we want to go. And that's, Jennings, as we know, comes from this Court of Appeal for this appellate district, and it really speaks volumes about that problem. And I don't know how you address that problem. I don't know how you resolve that problem in the light of Jennings. So I just wanted to make those few remarks. Thank you.
Thank you. Do you want to add anything?
Very briefly. First of all, I don't think I misspoke. I did indicate that in Lee, the little girl saw the brandishing. She saw the gun come out. And I take no issue with that. That doesn't change the Lee's factual similarity to this particular case. With regard to Mr. Rosen's second point, that what changed from yesterday to today, what changed is the court asked us to take a look at Lee. That's what changed. If the court had taken the information from the jurors and we all walked out, then we'd do what we always do. The court specifically asked us to take a look at Lee. So I think it's a little bit unfair for Mr. Rosen or Mr. Brunon to attack us for bringing up Lee when the court asked me to bring up Lee. And what Lee says is very, very clear. And what I fear as a legal practitioner is I don't want to run afoul of the appellate district. If there were to be a conviction of second-degree murder and the jurors were not properly instructed on a necessarily lesser included, which Lee appears to mandate, then that is potentially reversible. And that's the last thing any of us want. So that's why I'm arguing the points. I'm arguing the points because from a legal standpoint, that's what it is. Like I said, I don't know how many more times I can say it to the court. I don't know how many more times I can say it in front of counsel. That doesn't change our theory of liability. Our theory of liability is exactly that. We're not having any aha moments. We're not having any changes. It's like any other case in which there are lesser included in the jury instructions, and you stand up and you argue for the greater offense. The lesser included is committed and the greater offense is committed, and that's what I would say to this jury. If they need to be re-instructed, it needs to be done now. Now is the time to do it. And that's why I distinguished Jennings. Mr. Brunon said there's no language in Jennings to indicate that dialogue or the colloquy between the court and the judge made any difference. That's the entire thing that made the difference. That's the whole holding of Jennings when it cites Souter, is that in that case, the judge was taking cues from the jury and guiding their verdict.
Do the MC Hammer
dance. That's what was found offensive.
That's very clear in the Souter case. Where is it so much in the Jennings case?
When they say a dialogue ensued which made it apparent to the court that the specific difficulty lay in reaching a unanimous determination of intent to murder. And then they go on for the next paragraph. We cannot see that the case at bench differs in any material factor from Stouter. I mean, it doesn't get any clearer than that. They had, in that case, the lower court had a dialogue that specifically guided the trial court as to what issue they were having a problem with, what specific issue they were having a problem with. In that case, it happened to be the issue of intent. Then the appellate court turns around and says, and we don't see any difference between that dialogue. And keep in mind, Judge, the appellate court had the full record in front of them. We don't see any material difference in the case at bench. It doesn't differ in any material factor from Stouter. Then they cite Stouter, which had this long colloquy about, between the judge and the jurors. And I think that's what this court has avoided, and that's why I bring it up. This court didn't do what happened in either one of these trial court cases.
Okay, thank you. Anything?
Just briefly, Your Honor, I'm not going to readdress Jennings.
Briefly.
If the
Briefly.
variety of instructing a jury after it had begun deliberations and reached an impasse by adding lesser offenses was dependent on what had been said, we would have some more explication on that. And there would be other cases in other circumstances saying that this is an approved procedure. There is not a single case that we were able to find that approved giving of lesser instructions after the jury had begun deliberations and reached an impasse. In regard to the argument that the brandishing is subsumed in the placing the gun in the mouth, the manslaughter, the homicide, so to speak, it simply isn't. Placing the gun in the mouth and pulling the trigger is not a brandishing. That's a post-brandishing act. There's no reasonable argument that this gun went off and in a brandishing moment and accidentally found itself in her mouth. That we're talking about separate acts, as if he sped to the location, illegally parked, and then committed a crime. Those are not subsumed. They're factually related. They're not subsumed.
Okay. Thank you. This is a good example. As I do in every case, not just this case, whenever I've made a decision that legally is interesting or challenging to me, once I make the decision, I don't stop, and that's how I got to Lee. I've been looking at this, as I said, weeks before you got to the point, because I could see that it was an issue, and I've discussed it with my colleagues, which of course is the only discussion I can have with anyone that is ethical in a case that is ongoing. Being concerned as to whether lessers were appropriate in this case, and even having made the decision, which we all concurred in, I still was somewhat troubled by it, kept looking, and found Lee just the other day. Now, Lee is problematical, or problematic. It's a decision by our Supreme Court. On its face, it seems to be an absolute, but the problem is it never explains its reasoning. And that is always difficult to a trial court. The absolute is, under the facts of that case, it says it was error for that trial judge not to have instructed on involuntary manslaughter on the basis of brandishing. Now, you can look at Lee a lot of ways.
Just fell right in there, nosy. Ain't never heard of that?
You can look at it factually. You can say it is different from this case because you did have a witness who saw at some point, which was a brandishing, and you could say that's all that Justice Baxter was talking about when he wrote the plurality opinion. But then you have to look at the other side. You look at the fact that there was a completed wound, that it was a contact wound to the head.
Bassett Page, thanks for that
which
share.
would seem to
Appreciate
indicate
that.
facts closer to our case. And then you have Justice Brown's dissent, or concurring opinion actually, but in the concurring opinion, she indicated she couldn't understand how the plurality was discussing brandishing because it appeared to her to be a completed act. So you have those problems tugging at each other, whether under Lee this court was mandated, despite the theories of the parties and the requests of the parties, to instruct on involuntary manslaughter. There's a case, although certainly any appellate case cannot overrule a Supreme Court case. It can explain it, but this is actually a case that I believe preceded the Lee case. And that's a case called People v. Lipscomb, Lipscomb. And although they are dealing with the issue of lesser relateds under Geiger, it's a very similar issue. And in that case, I'll just tell you what the facts are. The victim in this case, having heard gunshots, went from his backyard to his garage, intending to close the garage door. Before he could close the door, defendant ran into the garage with a gun in hand, pointed the gun at the victim, ordered the victim into the house, and warned him he didn't want to have to shoot. The victim complied because defendant was pointing a gun at him. At this point, the appellate court is explaining the law. Absent some unexplainable rejection of the prosecution evidence, the assault with a firearm was complete. I'm the one that raised Lee. I'm concerned about Lee, and there's still another issue I have to deal with. I am not sure that Lee mandates in this case, given the evidence that was presented, the theory of the prosecution, the facts that both sides have agreed upon, although the facts are somewhat unknown, but the ultimate, that Lee is applicable to this case. That's number one. Perhaps more importantly, although number one resolves the issue, under the Stouter and Jennings case, and I disagree when the defense says that Mr. Jackson is grasping at straws. I don't think he is. I noted that if you want to argue that there is a difference between Jennings and Stouter in this case, you certainly can point to the fact that there appeared to be a greater dialogue. But I don't think that's the importance of Stouter and Jennings. We'd all like this case to get resolved in this case, and especially have the jury arrive at a result, given the amount of time that has been spent on this case, both by us, by the jurors, by the families. I mean, this case has been ongoing since 2003. But rather than just looking at the particular facts of Stouter and Jennings, I think you take away from it something very specific, and that is at a certain point in deliberations, not at the beginning, after the jury has arrived at an impasse, to then give them a new offense, which in essence is what manslaughter is. It may be a lesser offense, but it is a new theory of culpability, if you will, is in essence saying to them, in my mind, well, if you can't find him guilty on what you have, try this. And I have a problem with that. And as I believe the Supreme Court and the appellate courts have had a problem with, it's not so much the words, it's basically the timing when they've reached an impasse, and to say, okay, if this doesn't work, we'll give you this, because it's basically indicating to the jury, we want you to come to a verdict, and we'll give you this other option. And the only option, the option is an acquittal. It's conviction of a lesser offense. And I think that falls within the prescription of what Stouter and Jennings say. So on two grounds, I don't accept the notice argument, but I do accept that it would be inappropriate at this time to instruct the jury with a new offense, that being the lesser offense of manslaughter, because I believe it's basically directing them, if at all possible, that's what they should find, and that is inappropriate. And number two, I'm not sure that Lee applies. It's problematic. It's sort of a 50-50 proposition. I'm not concerned in this case if there was if the jury is able to arrive at a verdict after we take other steps to assist them, that it's reversible. And it's not reversible because it's invited error. It can't be any clearer.
No, the court made a good
point.
Lou,
thanks for that share. Appreciate
that. If ultimately my concerns about Lee, which I'm sort of resolving against my initial concerns, if you will, are borne out if there ever were to be a conviction and an appeal, that's not going to result in a reversal. That has nothing to do with my opinion. I'm just basically commenting on your comments. Having resolved that issue, that I'm not going to instruct the jury on manslaughter, but there are now other issues we have to face. And that is, and I do want to hear argument on this, this is the issue of that instruction number 3. Special 3. Because, again, I'm going to reiterate, it is not a correct statement of the law, which sounds funny, but it is a correct statement of the people's theory, if you will. When I say it's not a correct statement of the law, it's a correct statement of the law based upon what they argue to the jury. But in general, there are other ways you can get to a second-degree murder conviction that are not, if you will, correctly stated by the instruction. That's why I rejected it on 2 different times until finally in the third version, and I asked the people, and they didn't have an objection. The actual language is we don't have a strong objection, and there was no specific objection. I want to talk about whether, and this is merely we are having an intellectual discussion at this point, the appropriateness of either changing instruction number 3 or withdrawing it, which is appropriate under the law if I determine it's improper.
Your Honor, since we're going to have an intellectual discussion, could we get the intellectual perhaps on the speakerphone? And this is Mr. Reardon's instruction. He's very familiar with this area of the law. I think it would be helpful for us if we...
If you want to, that's fine.
Could we take a minute to try to...
We'll take a short recess. All right.
Court reports again in session.
Can you hear us?
I can.
Judge, we have Professor Reardon on the phone here, so we're all set. He'll handle this.
The parties are present as heretofore, and the spirit of Mr. Reardon is with us. We are going to proceed with, in light of the fact that at least one of the jurors indicated a difficulty with instruction number 3, which may call for some further clarification. I'm not sure. We had that discussion and sort of went on to other things. About my concerns, whether that is a correct statement of the law as opposed to a correct statement of the facts as proposed by the people, and whether anything further should or could be done with it. So I'll hear any argument that anyone wishes to make.
Mr. Reardon, did you hear that?
Dennis?
Barely, but
Well, why do I have a feeling we're at a stand?
Lexi, the law nerd with the share. Man, she's been awesome. She shares me about every day. She's fucking sweet. Thank you, Lexi.
I mean,
There's no smoke.
all right.
Your Honor, I could just very briefly state our position.
All right. Go ahead, Mr. Reardon.
Well, which is simply this. We continue to believe that the instruction was completely appropriate. The Supreme Court has said that the defendant is entitled to a pinpoint instruction which states his theory of defense and relates it to reasonable doubt. We took the position articulated by the prosecution in opening, which is that Mr. Spector, they would prove Mr. Spector had placed the gun in Ms. Clarkson's mouth and shot her. And indeed, that was the position that they maintained at the very end of their closing argument when they incorporated that position into the animation. You'll recall that I objected to the animation because it didn't appear to me that the animation appeared to have the gun in Ms. Clarkson's mouth, which was their theory of the case. And Mr. Jackson assured us that those who had put the video together had placed the gun in the mouth. So it remained their theory of guilt right up through the final minutes of their rebuttal argument. So we think that the instruction was correct, but putting that aside, and certainly this was a case that was tried on the theory that as the animation showed, Mr. Spector has his hand on the gun and has it in Ms. Clarkson's mouth. It was tried on that theory. The instruction reflects that. But in any case, at this point, after a very strong deadlock has been declared, it would seem that it would be impossible to withdraw the instruction without sending to the jury a message that jurors, I gave you this instruction, and there are some of you clearly who have relied on it, whether it's the 7 or the 5. It seems clear that some side of the division has relied on the instruction in articulating their position and holding to it. I am now informing those of you who relied on the instruction that I gave you that I disapprove of the position that you are taking, and therefore you should withdraw and retreat from that position to the extent that it relied on the instruction that I gave you. I think it would be a very, very powerfully coercive message that the court disapproves of a particular position taken by some group of these jurors, and that this delicate state...
Oh shit, I think we just finished up a will because we got... Kathy just came through the Venmo machine, 420, and she said, put Simi Sharp on the wheel, and I did that. Thank you so much, Kathy. The kindest human, the best. So we got Pumpkin on here. Kathy's been being amazing this morning. So yeah, I've got Simi on here for you. And then Bluebird came in right after that with a $10 holler, and Bluebird just finished this thing up. So a lot of fun, folks. It has some extra chances here as well. And again, we're giving away some goodies here this morning. And we're going to do a wheel spin right now. Well, not right now, but very soon. Thank you so much, Bluebird and Kathy. Thank you, guys. Love you all.
Deliberations, I would submit that it would not be appropriate to inform the jury that you're withdrawing the instruction.
Thank you. I would indicate before I hear a reply from the people, there's a case, an appellate case, People versus Nelson at 58 Calap 4th 193, which answers Mr. Reardon's concerns and says that it is not inappropriate if the jury is confused by an instruction that is later the court determines to be not applicable or inappropriate. So I'm not concerned about sending a message. I'm concerned about whether the instruction is proper. Mr. Jackson or Mr. Dixon, I'll hear from you again, Mr. Brennan.
Yeah,
go ahead. It does make a difference what order.
I just wanted to expand a little bit. The record should be clear that one juror made an ambiguous comment about instruction number 3. And I don't recall exactly what it was, but it expressed some concern on some level.
Which is why I said that we may need further clarification.
Right. I would say that's certainly true because none of the other jurors acknowledge, yes, that they need elaboration on that. And the other thing is that the court has said that the instruction may be too narrow under the facts of this case. And
no, too narrow under the law, not necessarily on the theory that the people are putting forth. What I'm concerned about is that there are other possibilities when you talk in the abstract or generally, under certainly which second-degree murder could be
Let me get a wheel going.
Committed.
Yeah, well, that's where I was going with that. In general, there are numerous ways it could be committed, but when you tailor an instruction to the facts of the case, the applicable law to the facts of the case that have been presented to the jury, which is what happens in every Sears pinpoint instruction, in this particular case, there does not appear to be another way to get there. We have been trying to brainstorm what other theory consistent with the facts of this case would find Mr. Spector culpable of second-degree murder other than that he did the killing. And finally, Your Honor, just if I may.
Certainly.
There is a federal case that talks about the due process implications of changing instruction after a jury has been instructed that changes the emphasis of the overall instructions. And since this case, this instruction is at the heart of our defense, I'd ask the court to consider the case and the principle it stands for before doing anything that would change the emphasis of the instruction. In the case is United States versus Wander, W-A-N-D-E-R. It's found at 601 Fed 2nd, 1251, and the applicable language begins at page 1260 and goes to 1263 now.
What circuit would that be from?
That would be the Third Circuit, Your Honor. Okay. But if memory serves, it is talking about a due process analysis, so that would be applicable in the Ninth and everywhere else the Constitution applies.
Thank you. Mr. Jackson or Mr. Dixon?
Thank you, Your Honor. With regard, I think the best indication that the instruction should be seriously considered, or there should be serious consideration to having it withdrawn, is the fact that it's confusing. We objected to the special instruction to begin with.
Boom, got a wheel, baby.
It was inclined to give it and instructed.
We'll spin that after this video, which still has another
come to an agreement if we could.
Hour and 10 minutes.
We went back and forth and back and
of
forth.
The list of this argument.
Instruction that I was never comfortable
kind
with,
of
and I
zoning in
generally
and out.
objected to pretty consistently until Mr. Reardon finally, I think, drafted the last the last iteration of the instruction, which is the one that was presented to the jurors. And I was, like I said in my original arguments, I wasn't, it was my position, I wasn't convinced, I don't think Mr. Dixon was convinced that this was necessary. It's something, Sears does give, in certain circumstances, it does give the trial court the authority to give a pinpoint instruction based on the defense theory that they wish to proffer. That's not what this instruction really does. It focuses on the prosecution's theory, and I've thought from the beginning that it heightens the burden on the prosecution. Now, Mr. Reardon focuses on what our theory of the case is. Our theory of the case is exactly that. It's a theory of liability. And our argument, our animation, et cetera, and the 4 hours that I argued and the hour and a half that Mr. Dixon argued, those are theories that we have proffered that we believe the evidence supports. That doesn't mean that any or all of the jurors have to buy that theory or adopt the exact theory that we proffer. And this is the problem with jury instruction, special instruction number 3, is it pigeonholes us, which is what it did to begin with. It pigeonholes us into a theory, and it then pigeonholes the jurors into a theory, which is why the defense wanted it so badly, because it narrows all the possibilities to this. And the jurors have just indicated this is unclear. I think it should just be withdrawn based on the fact that it's unnecessary. All of the other necessary instructions are included elsewhere in the packet. There's no requirement that the jurors be told what our theory of liability is. They can adopt whatever theory of liability they choose. They think the facts fit, be that of the defense, be that of the prosecution, or something in the middle that they believe that the facts support.
I think what needs to be done, let me interrupt you.
Okay.
I really think we need to bring the jury back out and find out what problem, if anyone perceives with that instruction, and see if there is a problem and whether anything can be done or should be done. So what I'm going to do is I'm going to bring the jurors back out, we'll bring the office back out, and I'm going to inquire. All right?
Your Honor?
Yes, Mr. Reardon.
One comment that would be very important, very brief. I can't be absolutely positive, but some quick research reveals that the Nelson case that the court cited, I believe, has been published by the California Supreme Court.
I'll certainly check on that, because if it has been, then it does cite other cases, but clearly it could not be cited. And let me do a quick check on that while we're bringing the jurors.
I could be wrong, but I believe that's the case, Your Honor.
I'll find out shortly. Thank you for bringing that to my attention. All right, let's get the jurors and the alternates together and see what we have. Thank you.
Like I said while I was out to McDonald's, imagine being an alternate in this trial, though. Holy crap! You've sit through this for 6 months, and right before you're about to go and deliberate, it's like, well, you can actually leave. And actually, I thought the alternate left before deliberations, and we've already been in some deliberations.
Court's again in session.
Yeah, welcome in. Morning. Welcome to the end of field.
Ladies and gentlemen, thank you for your patience. Yesterday, one of the jurors, I'm not sure who, I think it may have been juror number 3, indicated that they believe there was a problem, or that instruction number 3 was causing, or special instruction number 3 was causing a problem. Juror number 5? All right. Can you generally sort of indicate where you think the problem might be with that instruction?
Taking that instruction by itself, I think that's where some of us have had a problem, standing on that alone instead of the total picture.
Okay. Does anybody else agree that they're having problems? If you just raise your hand with instruction number 3, is it causing any problem or confusion? If not, don't raise your hand. If you think it is, raise your hand. All right, juror number 11 has raised his hand. We know juror number 5. Anybody else having any? Juror number 8 indicates a problem. Can anyone else articulate, and if you can't, you can't, what problem instruction number 3, besides what juror number 5 just indicated? Anybody else have anything to add to that? Juror number 2?
I think some jurors may have a question about whether every element of that instruction must be proved beyond a reasonable doubt.
Okay. Anything else, any of the language or anything else that's causing any problems with that instruction? Yes, juror number 6.
I think part of the challenge is determining a weighting of
That's a man's voice right there.
the instructions against the evidence to determine if the
I'm gonna miss him
totality
so
of the
much.
evidence is to be weighed more than specific instructions.
All right. Anybody? Yes, juror number 10.
One of the issues is that as a jury, the agreement on the totality of the facts and what is drawn from the totality, different jurors give different weighting to the individual facts. And the totality for some is not the totality for the others because of the weighting of how the juror sees the facts. And so that's causing some discussion about whether the totality of one is reasonable to the totality of the others. And that's where the real concern is coming in.
All right. Anybody else have anything they want to offer? All right, what I'm going to do, ladies and gentlemen, yes, sorry, juror number 12.
On a different issue, if I could bring up.
Yeah, go ahead.
I'm just asking.
Yes, sir.
I asked, one of these are wonderful, but I just asked on some of the clothing articles, if we could perhaps maybe have those on a mannequin to view. We have photos, but to see the actual article might help us. I mean, we have several different photos of the different pieces of evidence, but perhaps if we can actually see them. I'm not saying handle them, but just to view them with the bailiff there, that's possible. I just asked for different pieces, but they said they're not evidence. I understand that. I'm just wondering.
Just as an inquiry, without saying whether it's appropriate or inappropriate, would that assist any other juror? I see juror number 5 is nodding.
Sorry about that.
Okay.
Setting
Somebody
up
else,
my
juror number
promo.
9, you had your hand up? Yes.
Yeah, back to my, yesterday when you asked me what it was that we're having, some of us having.
Yes.
problems. Yes, not necessarily me. Was doubt and reasonable doubt.
Right.
And I think some of the jurors are still struggling with that part. I think it's pretty clear to some of us and others not. And maybe some clarification and read back. What is this?
Read back of the instruction, or read back, since you have the instruction in the jury room, or read back of certain testimony?
I think just you reading it. I think what sort of, I don't know. I mean, we're at that point where.
Okay. All right. Anything else? Yes, juror number 10.
I think the clarification is the reasonableness. Is it appropriate for one side to feel, for one juror to feel that it's reasonable, and for another juror to feel that it's not reasonable?
Okay.
From the same facts that were presented in the case, is it, if one juror draws a conclusion that some of the other jurors may not feel is reasonable, is that one juror unreasonable?
Okay.
That's the distinction I think that we're struggling with.
Okay. Anything else? What we're going to do is we're going to discuss all your concerns and see if we can help you in any way. And since you're going to be eating in, if you will, I will tell you that why don't you hold off on it? I don't know if you are deliberating or not. At this point, you're not. Okay, don't. I don't want you to deliberate. Just stay together. We'll have lunch as soon as we can. These are issues that counsel and myself have to discuss, and it may take some time before we resolve them. When we do, we will bring you out, and what questions we can't answer, we will. If there's any other instructions or something else that we're going to give you, we will. And those questions that can't be answered or should not be answered, we'll let you know. That's the best. Yes, juror number 11.
On instructions, I believe number 3, the concerns that we face are decisions strictly on the wording of that instruction only.
Okay.
Or do we take all the evidence and make a decision other than the wording on it?
All All right, there's questions. I don't want to ask any questions of you before I discuss them with counsel. So thank you for sharing all that with us. That gives us some guidance that we may be able to assist you in your deliberations. So go ahead, keep in mind the admonition. If the jurors will return to the jury room, if the alternates will return to their secret room, and then we'll, at noontime, we'll get you together, and, you'll each have your lunches, and as soon as we can, after 1:30, we'll try to help you with these issues. I doubt it will be right at 1:30, but we'll try to do what we can today. All right, thank you. All right. All right, the jurors and the alternates have left. First of all, Mr. Reardon was correct, and I do apologize. I was given a case that hadn't been properly shepherdized, and the Nelson case itself has been depublished. There are other cases cited within Nelson that I want to read, and if you want, I'll give you the citations that are in Nelson. Perhaps you're aware of them. I don't know. People versus Beardsley, B-E-A-R-D-S-L-E-E, 53 Cal 3rd, 68. There's also a case that I don't think is directly on point. It just talks about the court having not just sitting there when the jury is confused and having the right to do certain things, but that's People versus Fry, F-R-Y-E, 7 Calat 4th, 1148.
I'm sorry, Calat 4th?
Yes. Let me see.
And the page?
1148. Thank you.
There's also, again, these are more general. Let me just see that. I don't. I think some of the others are just sort of general law. So let's take a look at that and see if they're helpful. We can all take a look at that. And then make a determination as to whether 3 needs to be modified, withdrawn, or whatever. I'm going to take a look at it. Obviously, it is causing some of the jurors a problem. That doesn't mean just because an instruction causes jurors a problem that it should be withdrawn or modified in any way. It just clearly it is a problem. Given the fact that it is a pinpoint instruction, I think we do need to look at it. I'm happy, as indicated, to read the jurors at the appropriate time, reread the reasonable doubt instruction if they want to hear it from me. I don't have a problem with that. The answer to the question about if one juror thinks it's unreasonable and the other jurors think it's reasonable, obviously it's an individual determination in consultation with the other jurors as to whether a doubt they have is reasonable, and that's about all I can tell them and will. And something to look at. And I think now would be a good time, we have a little time this morning, to address the giving of the more instruction. Okay?
Does the court have our modified more?
I'd have to ask Wendy.
Oh, man.
Yes, if you have something to show me, that's fine. Thank you.
Mr. Reardon is asking.
All right. Is he, perhaps we should join hands and see if we can summon Mr. Reardon forth. All right, you with us, Mr. Reardon?
Good morning, Your Honor.
Good morning. The jurors, several jurors have indicated a confusion or problems with instruction number 3. You are correct, and I thank you again for pointing out that the Nelson case was depublished. We're going to look at the other cases that are cited in Nelson and see if they have anything to offer us. And now we're talking about the propriety of giving the more instruction. So, Mr. Dixon or Mr. Jackson?
Oh,
Sorry?
Sorry. Judge, this doesn't bear a whole lot of argument. This is, I think it's pretty much verbatim, right out of Moore. And Judge...
Been here for a while this morning.
Hang on.
We did
through this thing
make some
today.
modifications to it with respect to the CalCrim
Hate you're feeling sick.
CalChig instructions, and I think that's pretty clear where they're made.
Right. I was going to cite his name. The appellate courts are loath to cite trial court judges' names, but in fact, when this judge formulated and fashioned this particular instruction, the appellate court took the exceptional step of actually citing the trial judge and said, you did a great job, and that's a great instruction to give. So all we did was go in and modify where, for instance, originally the trial judge had cited CalJIC 17.40. We changed it to CalCrim Instruction 200, which is the concomitant instruction. The same for 17.41, which I don't think exists anymore. We substituted CalCrim Instruction 3550, which is the admonition to the jurors just before they begin deliberations. Other than that, it's straight out of the opinion.
Okay. Does the defense wish to be heard?
I think Mr. Reardon wants to address
Mr. Reardon, do you wish to be heard?
Just this on the Moore instruction, Your Honor, you know, the facts in Moore were that the jury had deliberated only a day, and a division had not been revealed to the court.
It's only been a day of deliberations.
Certainly after only a day, there was no likelihood, without knowing the division, that the instruction would have a coercive effect. It has been criticized recently by the 6th Appellate District on the grounds, particularly on the grounds that the phrase that you have a duty to deliberate as long as it takes is certainly suggestive of coercive, and they've said that the court should simply give 1740, which was approved in Gaynor, or give the equivalent language in CalCrim, and said that one should be extraordinarily cautious of giving a Moore instruction. A Moore instruction has never been given after 5.5 days of deliberation. We think that if the court's going to say anything, it ought to use the language that was in CalJIC 1740 and is now in the general CalCrim instruction on try and reach a verdict, but maintain, your opinion as well if it's conscientiously held. So we oppose anything other than what's in CalCrim or CalJIC.
What, do you have a citation on that case?
The case that I referred to, Your Honor, is admittedly, it's a Cal Reporter opinion. Defense counsel, I believe, has it in court, Worsley or Wansley. It's an unpublished opinion, Your Honor. We're not citing it as a published opinion, but the discussion in both the majority and the concurring opinion of the caution to be used in approaching Moore, I think is useful language, Your Honor.
All right, thank you. I appreciate it. All right, we're going to be in recess until 1:30. We can discuss these issues at 1:30. All right, thank you. No, because it's an unpublished opinion. Thank you. There may be, in any event. Thank you. I have lots of unpublished opinions that I can't rely on. Further?
Mr. Reardon's going to handle the argument, Your Honor.
Okay, Mr. Reardon?
Your Honor, correct me if I'm wrong. As I understand it, the question that remains to be decided is whether the court is going to withdraw special instruction number 3, and then if the court made that decision, what other consequences that might have in terms of instructions that need to be given.
That's correct.
And Your Honor, again, I would just reiterate that we are in a situation in which the jury has deliberated for a week within the instruction. There is, both in federal court and state court, a statute that says the instructions are to be determined before the case is argued. Obviously, we in our closing relied on...
The new defense guy that popped up, somebody in the chat had the name, I think Nosy Rosie. What's this guy's name?
Special instruction number 3 heavily. It's our theory of the defense, that's why we asked for the instruction. And I do think that even if the court could have correctly rejected the instruction at the time, and I do think we were entitled to it under Sears, if it were to withdraw it now, two things would occur. One, it would be sending a message that jurors who have relied on it, discussed it, and then there certainly seems to be some jurors who used it to buttress their position, that the court is directing them that they were wrong to do so and should reconsider. And secondly, and correct me if I'm wrong on this, the point of withdrawing it would be to say to the jury that I told you that there was one theory of the prosecution here, gun in the mouth with Mr. Spector's hand on it, which was the theory that they expressed in their animation. And the court is now saying, by withdrawing it, I'm suggesting to you that there are other factual scenarios which might support a murder verdict. And I don't know what those are, but to inject them at this late point in the proceeding, I suggest, Your Honor, would simply not be fair in terms of changing the focus of the trial after all of the evidence and argument is in. And that's I submit it both as under state and federal constitutional law that it would be improper. I do have comments if the court should decide that it is going to proceed in that direction as to what other instructions might need to be given.
Thank you. People wish to be heard.
Your Honor, I think Mr. Reardon said it exactly. This instruction pigeonholes the prosecution in a position that it shouldn't be in. Ultimately, it was the reason for our objection to the instruction to begin with, that it requires the jurors to find something that legally they are not required to find. This heightens our burden and narrows the theories of liability, within which they are, the framework within which they are allowed to work. They're allowed to determine what theory of liability they think is most appropriate based on the facts that have been presented. They don't have to follow our theory of liability. They can reject it outright or wholesale. They don't have to follow the defense's theory of liability or their theory of defense. They can reject that outright or wholesale. And they can garner the facts or corral the facts as they see fit and apply them to the rest of the law as it applies. The problem with Special Instruction 3 as it was originally drafted is it doesn't give the jurors that ability. And the best proof is in that pudding sitting in the jury box when 2 or 3 or 4 of them said, boy, that sure is a problem with jury instruction number 3. As a matter of fact, our Special Instruction number 3. As a matter of fact, one of the jurors said, do we have to follow, or do we have to, does the prosecution have to prove each element of Special Instruction number 3 beyond a reasonable doubt? There are no elements in Special Instruction number 3. The only elements that we have to prove, and we'll get to this discussion and the discussion of the jurors' questions in a minute, the only elements we have to prove are the elements of murder, second-degree murder, beyond a reasonable doubt. And the only other thing they have to find beyond a reasonable doubt is the defendant's guilt. They can use the facts in any way they deem appropriate. And there are several different theories that they could use that are not consistent with or are variations of the theory that we presented. That's why we think that Special Instruction 3 shouldn't have been given to begin with. And there is reason, there is logic in withdrawing it to remove the confusion that it has obviously exercised over these jurors. We have also drafted, if the court is not inclined to withdraw it outright, we have drafted what we believe is an appropriate modification of Special Instruction number 3. I have a copy here if the court wants to see it now, or if you want to wait until further arguments.
I'm prepared to rule without seeing that instruction.
Okay.
Anything further, Mr. Reardon?
Not on this issue, Your Honor.
All right. The court has spent a great deal of time rereading Special Instruction number 3. It is clear to me, at least in part, and I mean nothing negative about this, it's an observation, and it's why the defense fought so hard to get this in, because it misstates the law. And the misstatement of the law is in the final sentence. If you do not find that the prosecution has proved beyond a reasonable doubt that the defendant committed that act, which refers to the theory that the people have used, that you must return a verdict of not guilty, is not the law. That is simply not a statement of the law of second-degree murder. And it is absolute error. It is just wrong. And it's no doubt, I can see why the jury is confused. So I am going to withdraw Special Instruction number 3. I will inform the jurors that it is being withdrawn because I believe it is better covered in language in other instructions without highlighting it to any degree or telling them I disagree with it.
Name of this trial.
Specific problems with it are, because I think that would be inappropriate. However, because the defense has relied on Special Instruction number 3, I will allow the parties to re-argue as to that instruction. And anything that covers it covered by that instruction. And you may now re-argue the case to the jury as appropriate. It's that simple. As simple as anything can be. Now further, so I don't know that we're going to do that today. I think you're probably going to have to rethink how you want to do that, and I think that's appropriate that we probably do that first thing tomorrow. There are other issues that we need to deal with. The defense, Mr. Reardon, you have submitted a unanimity instruction, which I have, I don't know if the prosecution has received it?
No, we have not.
Okay.
Your Honor, nor with that.
Okay, this came, Wendy supplied a fax number where I could be reached.
We went through the lunch hour and tried to articulate what we heard the jurors say in their questions and came up with some suggested ideas.
Have you shown that to the defense?
We'll give it to them right now.
Okay. Oh, yes. And the problem I have without, and certainly I'd be glad to hear argument, Mr. Reardon, is that it seems to contravene the law. I suggest that you look at the use note under 3500 of CalCrim, and which is the unanimity instruction, and it specifically states, let's see, or at least it's stated in one version I have to take a look at, I have a different volume on the bench. In any event, I can see that the use note has changed to some degree. It's the difference between different theories and different acts. So I would like you to address that if you would.
Yes, Your Honor. And let me anticipate, perhaps correctly or incorrectly, some of the court's thinking, because this unanimity issue in the context of murder charges has been quite sticky. The constitutional case that has controlled everything since it was decided is a case called Shad versus Arizona, in which the United States Supreme Court had to decide whether you could go to a jury in a murder case on two theories, one being that the defendant was a direct participant and the other a felony murder theory. The decision came out 5-4, saying that you could both go on felony murder and on a direct killer, direct participant theory. But the vote was split 4-4, except for Justice Scalia, who wrote and said, frankly, it wouldn't make a lot of sense to say that you could have those two different theories, and you could say that it's unanimous if the jurors split on them, except that's the way it was given felony murder when the Constitution was enacted in 1789. So since then, courts have been trying to figure out the implications of Shad, and we would simply say this, that the original instructions, the one that the court is going to withdraw, said that there has to be a situation, the prosecution has to prove that the gun was in the mouth with Mr. Spector's hand on it. By withdrawing that, the court is necessarily saying that on this evidence, you could find some conduct on Mr. Spector's part other than having the gun in the mouth and being when the fatal shot is fired, that could result in conviction of second-degree murder, which opens it up to theories such as he brandished the gun, which was a misdemeanor, and somehow that brandishing led to a fatal shot in the mouth, even though Mr. Spector didn't have his hand on the gun, because of course if he did, we wouldn't be having this discussion to begin with. Or, a particularly ill-informed law publication article said, well, maybe he gave the gun and encouraged her to commit suicide for which there's not a shred of evidence in this record as a possible theory of liability. But the point is that we are now talking about very, very different acts, one of which is the one the prosecution has always maintained and of which some jurors are convinced. That is to say, the gun is in the mouth and Mr. Spector is holding it. To say that there is a unanimous finding of guilt if some jurors thought that Mr. Spector never even brandished the gun but might have put it in the vicinity of Ms. Clarkson when she was intoxicated,
as am I and all of us.
should be criminally liable on that theory, or brandished the gun and somehow it got into her mouth without his placing it there. You just have very, very different factual predicates. The cases that we've cited, Gonzalez and so forth says, and I think the court has these citations, a unanimity instruction is required if jurors could otherwise disagree which act the defendant committed and yet convict him of the crime charged. And on that basis, Your Honor, we do submit that the jury would have to be unanimous on what act of Mr. Spector caused the death of Ms. Clarkson, because there is no question. Mr. Jackson just said that, that special instruction number 3 doesn't contain elements. There's no question that an element of the crime is that he committed an act that caused the death of Ms. Clarkson, and there would have to be unanimity on that factual predicate, or else we just don't have the kind of unanimous verdict that the Constitution demands.
All right, thank you. Thank you, Mr. Reardon.
Your Honor, that, once again, the wording of the proposed unanimity instruction has exactly the same flaws that the last sentence of special instruction number 3 has. It's not the correct statement of the law. If Mr. Reardon's concern is that Mr. Spector could be convicted because he just, I don't know what he said, something about placing the gun on a table or something, and some juror found fault with that, he forgets that the jurors were instructed on and can be re-instructed on Calcrim 520. The defendant acted with implied malice if he did the following things: intentionally committed an act, the natural consequences of which were dangerous to human life. At the time, he knew his act was dangerous, and he deliberately acted with conscious disregard for human life. There are the elements. That's what we have to prove, and they're told in the instructions they must be unanimous when they come to their decision that these elements have been proven, and they must be unanimous about the defendant's guilt ultimately. That's the only thing that has to be proved beyond a reasonable doubt. The facts do not have to be proved beyond a reasonable doubt in and of themselves, only the elements of the crime, and ultimately the jurors need to make a determination that the defendant is guilty beyond a reasonable doubt. They can, and often do, use different theories among themselves to come to these conclusions. This unanimity instruction takes away their ability to utilize different theories if they see that different facts fit different scenarios in different ways, and that's simply not the law.
I have a couple of questions. First of all, does the defense wish to re-argue the case in light of if the court withdraws special instruction number 3?
I think we need, maybe have a moment.
Yes, you can have more than a moment if you need it, because that raises other issues as to what the people may then argue.
Okay.
Yes.
We need to know how the rest of these issues are going to play out. There are some quasi-questions pending by the jury, and we need to know whether that unanimity instruction or some other unanimity instruction is going to be given. So could we not answer that question?
Yes, and I need some time to think about the unanimity instruction. I want to take a look at some of the cases. Another issue, which I just alluded to while you were having your discussion, is if the argument is reopened, it then raises a question, and Mr. Jackson, I mean, people have been throwing around the term brandishing. We're not going there. If we get into brandishing, then the court's going to instruct on manslaughter. I can tell you that right now, despite my earlier ruling. You can't go there. Right. And the people, therefore, when we talk about if you choose to argue, and of course the people argue, you have to be very careful about what acts you allege can suffice to support the murder charge, because depending upon what you argue, you may well open up lesser. And that's just a fact.
And I've known that. Mr. Dixon has known that since the time immemorial.
Okay.
Since we started this case.
By the way, to send the jury home now rather than keep...
I don't mind because we're not going to get to them today. I tend to agree. We need a lot of things. We need to discuss a lot of things. I need to look at some cases. So yeah, the chances of reaching them today are practically nil, and I think it's a good idea. So we'll get the jurors and the alternates out, and as soon as they're out, I'll send them home, and then we'll continue our discussion. Okay?
Court's again in session.
All right, back on the record, all parties, jurors, and alternates are present as heretofore. Ladies and gentlemen, I think there's some good news here is tomorrow, and we're not going to be able to do it till tomorrow because counsel and I have to go over it, we're going to give you some new instructions and perhaps redefine some of your older instructions and clarify some things which I think may benefit you in your deliberations and may greatly help you. They may not, but hopefully they will. And we're going to need the rest of the afternoon to go over these matters. So keeping in mind the admonition, very important because at this point the media is showing great interest in the case, and I want to make sure you don't read or hear anything, so just don't. It's real simple. Keep in mind the rest of the admonition, and we will see you tomorrow morning at 10 o'clock. All right? Thank you. All right, the jurors and the alternates have left. Let's pick up on the unanimity instruction. I'm sorry.
We never had a copy of it because we had submitted it to the government, so I've asked Chandra if she would just cut us some copies so we can all have our own copy. And she's doing that right now, so if you just give us a second, please.
While we're doing that, I can tell you the problem I was having. I was trying to quote the use note. For some reason, the 2006 version of CalCrim had it, the quote I was looking for in the use note, the 2006/2007 version omitted it. I just got literally hot off the press the 2008 CalCrim version, and it's back in. And I'll talk to you about what's in there, and it cites some cases, and I have one of the cases, and I think the language makes very clear what the court should do as far as a unanimity instruction, but I'll wait.
Which instruction are you looking at?
3500.
And you don't think it's not in the one that, I've got 2006, 2007, I'm not going to find it?
No.
Okay.
For some reason, it was, whether it was by accident, because it's back, the same quote is back in the new version. But it's the case law that's important, and I've got the case for you.
The language has not changed then?
No. It's not the instruction. It was the use note for some reason that appears to have been omitted. But while we're waiting for the actual instruction, let me read you. It's not even important to read the use note because the use note refers to a case. I'm going to read to you from that case. It cites more than one case. People versus Russo, 25 Cal 4th, 1124, which is our California Supreme Court. The key to, and this is from page 1134, the key to deciding whether to give the unanimity instruction lies in considering its purpose. The jury must agree on, quote, a particular crime, close quote, and I'll eliminate the citation. It would be unacceptable if some jurors believe the defendant guilty of one crime and other jurors believe her guilty of another. But unanimity as to exactly how the crime was committed is not required. Thus, the unanimity instructions is appropriate when conviction on a single count could be based on two or more discrete criminal events, but not where multiple theories or acts may form the basis of a guilty verdict on one discrete criminal event. That seems to be exactly the situation we're talking about. So I would say, and certainly I'm open to further discussion or further cases, that based upon this, the unanimity instruction would not be given. It's not required.
We submit it, Your Honor.
All right, thank you, Mr. Reardon. Based upon what the court has just read, the request for 3500 or a version of 3500 is denied. Now, I don't know if you still need more time to consider whether you wish to argue, because then we have to go into a whole, or do you want to still talk about the other jury issues first?
We do, Your Honor.
Okay, that's fine.
Yeah, let's talk about it.
Since we have not read any of the other cases cited, and Gonzalez seems to be inconsistent with Russo, at least insofar as a little...
What's your cite on Gonzalez?
It's in the use note as well, I believe. It's 141 Cal App 3rd,
786. So-
Given that you have a recent statement of the California Supreme Court versus an old statement from an appellate court, it's pretty clear which one controls.
Well, if they're talking about the same thing, I'm just saying.
I understand.
Don't carve it in concrete.
It's nothing is carved in concrete. It's all quicksand.
Your Honor, I think that we would ask, and perhaps we can, we'll move out of the courtroom and do it relatively quickly. We do need to have a discussion on our position on reopening argument.
Okay.
Prior to that, and in order that the record be complete, we would submit a formal motion for mistrial based on two factors. One, our disagreement with the court's decision to withdraw the special instruction which it previously gave, and the second, which we argue in tandem and as both a separate ground and one which reinforces the first, is that but is different from what we've discussed, is that the discussion that occurred with the jurors, the colloquy based on their reaction to special number 3 and the remarks that the jurors volunteered were really quite extraordinary, and they were a tremendous window into the jury's deliberation. Some said what somebody feels is reasonable and others doesn't. Some look at specific acts, some look at totality, and relying on the language in People versus Cleveland, which is a case about an erroneous discharge of a juror, which obviously the holding isn't what we're citing it for. But at 25 Cal 4th, at 481 and 482, the court talks about the need to protect juror privacy. Notes, and I quote, "The mere suggestion that the views of jurors may be conveyed to the parties and the public understandably may cause anxiety and fear in jurors and distort the process by which a verdict is reached. I realize that when you get a hung jury and you're trying to make an inquiry which allows the court to determine whether further deliberations would be productive, that there's always a grave danger of stepping over the line. I think it's unavoidable, and it isn't anything the court is necessarily responsible for. I think quite a discussion and dialogue broke out between the jurors, but I think that the level of exposure of their deliberations at this point is what Cleveland counseled against. We are in a situation where after that level of exposure, virtually any direction to go back and further consider the case would be coercive. So on that ground, the language in Cleveland, as well as our objecting to the withdrawing of number 3, we do formally submit a motion for a mistrial.
All right, that motion is denied. I just read the Cleveland case. I happen to have the volume here on the bench, and the language is completely an opposite, and it does not control what took place in this case. There are any number of cases, numerous cases, wherein, because of the situation where a jury, and by the way, this jury is not hung, they're at an impasse. The jury is hung when they cannot come to a conclusion after everything is done. We're not there yet. They're at an impasse. And where a judge inquiring into what is the problem or what concerns the jurors have is able to have a conversation with the jury in open court in front of the parties, and I don't find anything inappropriate in that, and just the opposite as a matter of fact. So the motion for a mistrial is denied on both grounds.
Thank you, Your Honor.
Thank you. Do you want to go over at this point how to answer some of the other concerns of the jurors?
I think we would, Your Honor. That'll
Okay.
give us guidance and make a global decision as to the remaining questions.
Well, the easiest one, and I know the people have submitted certain items here, but where they asked if one juror has a doubt, does the other jurors outweigh it? Of course not. Each juror has to act on their own. If their view of the evidence is a reasonable doubt after discussion with other jurors, then it's a reasonable doubt. And for that juror, that's what reasonable doubt means. It's not that other jurors disagree with he or she. Him or her, pardon me.
Was that number 7, Your Honor?
That would be on the people's list.
That would be number 7.
Right.
What I did, Judge, is I literally scribed down in the order in which the questions, the dialogue took place. I think there were 8 statements and/or questions by the jurors indicating that they needed further clarification. There was one that was actually just a comment that needs no further clarification.
Well, we can take them in the order you've listed them. Let's just do it that way.
Can we do this, Your Honor?
Sure.
Because Mr. Reardon doesn't have
It's
this.
very,
Can we
very
read the question
confusing.
so
It's
that-
a
Okay,
lot
I'll
for
be happy to.
a
Question.
layperson and
Whether
all
the
this shit.
instruction
like a
should be
juror.
taken by itself, and it should be instruction should be
It's a
taken
lot.
by itself instead of taking all the instructions as a whole. Since 3 is being withdrawn, this no longer applies.
Well, no,
That
it may apply. Your
How
Honor.
so?
Well, we're assuming that only 3, that question applied only to 3. As a general proposition, all of the instructions should be taken in light of the others, depending on what the facts are.
But that's already, they've already been instructed on that.
All I was going to suggest is that we remind them of that.
No, I don't have any problem with that.
That's fine. That's fine. And when we indicate the more
Pumpkin's
instruction
like, I'm
we are,
out of here.
has the court
Pumpkin
made a
might win that
determination?
wheel.
Do
You gotta
want
wait
to
Pumpkin up
discuss
for
this
that.
After we talk, it doesn't make a lot of sense because I
Will be spun in about 5
think
minutes?
the more instruction does answer several of the questions that are posed.
I am leaning strongly towards giving them more instruction.
Okay, assuming that that's the case, when I reference more instruction, all I'm saying is I think there is language in the more instruction that answers that question, and Mr. Brunon would probably be satisfied with that as well, because it does specifically state that all the instructions are to be taken as a whole as well.
But actually, I don't think that we're at the point where the more instruction is necessary or appropriate.
It may be if the instructions, and that's, I said, I'm leaning, and we have to wait and see. We haven't had arguments. So in any event, as to number 1, I will definitely see that they are instructed on that.
Number 2 is no longer applicable.
Okay? That had to do with special instruction 3, which is now out. Question 3 is whether in determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction that is contained within the jury instructions.
Right.
Again, but...
I think 1 will answer, the answer to 1 will answer that.
Okay.
We agree.
All right. Question number 4, different jurors are giving different weight to different facts because the totality for some is not the totality for others. Well, they may do that.
And that was just a comment, I think.
Existential. The reality for some is not the reality for others, and I think that that's probably, we should say that's true.
It's okay.
Your Honor, I don't think you should touch that one with a 10-foot pole.
Mr. Reardon has raised the defense of 10-foot pole. Does anybody wish to be heard on that?
We agree.
Okay, so just don't respond. All right, that's fine. What about a 9-foot pole? Any? No.
Not even a 1-foot pole.
All right.
Leave it alone.
Number 5, question whether the jurors can view the clothing articles on a mannequin. That's something we had not yet discussed.
I think we just need to say no.
They're not in evidence.
Right.
There's
They've got the
a number of
pictures, they can refer to the pictures.
I think that's appropriate. I think everybody agrees that the evidence is not in the same condition it was when either it was on the day of the event or when it was, or they were reviewed by either any of the experts.
Would you like me to comment? Because I think the jury, well, you might want to think about this. The defense is rapidly shaking its head. I think what you're liable to find is that jurors are liable to make some inferences. Oh, somebody's trying to hide this from us. If you make a comment as to why it's not being shown, I think you'll find that both sides are in much better shape.
What did you have in mind? Something along the lines?
Something like, you've asked to see the evidence. Incorporating the evidence is no longer in the same condition as it was originally, plus which those items have not, the items are not in the same condition, and they are not in evidence, and the law does not permit you to view things that are not in evidence.
That would be our request.
Okay, all right. Question number 6, jurors are having problems with concepts of doubt and reasonable doubt.
Our position is we'd like to open argument for that.
Well, we're going to see whether, because both sides, obviously, that's an issue. The court,
Your Honor, the only temperate view as to that would be simply to reread the reasonable doubt instruction.
which I intend.
Nobody wants to try and improve it or elaborate on it.
Oh, you can take your 10-foot pole, your 20-foot pole, and your 30-foot pole, because the bottom line is any judge who tries to reword the reasonable doubt instruction is really looking for trouble. I'll try to be in very temperate terms. I have a lot of other things I could say, but the bottom line is that is not to be done, and since one of the jurors at least has asked that I reread reasonable doubt, I will do that.
But you're going to hold in abeyance any decision about allowing us to reopen,
Yes.
re-argue that particular issue?
Yes.
Okay.
Yes.
Is that the only question that we would re-argue?
Well, we'll talk about that. We can get to that when we go through the questions here.
We have 7 and 8.
Number 7, whether it's appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable. If such is the case, would the situation make the juror unreasonable?
It's really a lot like 4. I mean, it's just...
Okay.
That's how we started our discussion.
Right.
That's the first one that you thought of. I think that's answered by the more instruction and no specific pinpoint to this
Okay.
juror. This question needs to be asked or answered.
And question number 8
Is not applicable.
is not applicable because it dealt with the wording of special instruction 3.
Correct.
All right, now you want to discuss how far argument could go if a case is re-argued? Is that where we're at now?
If you could give us some parameters before we present our position.
Roger?
Yes.
I think that we ought to formulate our position on this and articulate it to the court before I think let's convene and take a position on whether there should be argument.
Could we
Would you like to take a break and convene and see if there's a position on argument?
I think that would be appropriate, yeah.
Okay, why don't we take a recess and you make a phone call to Mr. Reardon, not shared in by the rest of the world. All right, we'll take a recess.
Thank you.
Thank you. Okay. Let me just say this before you convene. If the parties come to some agreement as to how much they want to re-argue, I'm fine with it. Doesn't make any, I mean, if you come to an agreement, you're going to get it. If it comes to where we don't agree and we think it should be limited to this or this and that, then I'll make a decision. But the bottom line is, if you can come to some agreement, we need to argue A, B, C, D, and E, and we think that includes now, X, Y, and Z, I don't have a problem with it.
Your Honor, could the court mark the little summary of the questions as a court's exhibit, make it part of the record, please?
Can someone give us maybe an unmarked version of that? Supply the clerk with that. I have notes on mine.
I've got one ready.
All right, we'll be in recess till I hear from the parties. Thank you. And alternates are not present.
We're just waiting for Mr. Reardon.
Okay.
I'm on the line.
All right. And who would like to proceed? Mr. Reardon?
Yes, Your Honor. We discussed this among counsel and with the defendant, and our position is as follows. The court has made the decision to withdraw special instruction number 3. We've made our mistrial motion on that. We consider that matter submitted and closed. But the court, in doing so, said some things that I think are relevant to the present question. I said, Your Honor, I think that if you withdraw that instruction, you're clearly sending a signal to the jury that those who have relied on it must now reconsider their position. You're essentially telling them that their reliance on the prosecution's failure to prove that specific fact must be reconsidered, and you're directing them to do so. And the court said, no, to the contrary, the way I'm going to frame this is simply that the addition of special number 3 was unnecessary. This case is controlled by the general principles that I've given the jury, the general instructions generally drawn from CalCrim, and I will not in any way draw special attention to it or do anything to suggest that those who relied on it are wrong or should reconsider their position. So the court is essentially saying that once I withdraw it, they'll have the law under the same legal principles that they had it, the same general legal principles which are appropriate. The evidence hasn't changed and the law in essence hasn't changed. And given that that is the case, we absolutely and strongly feel that there is no basis whatsoever to reopen argument, and that the reopening of argument can only result in the complete perversion, if you will, of the instruction that the court is going to give them, which is essentially ignore that, it's unneeded, no big deal, controlling principles apply. Because this is a situation, and Mr. Jackson said something extraordinarily important this morning when the court put the question to him, why didn't you ask me for lesser included? And he said, we made a tactical decision, and I think that we now regret it. They made a tactical decision to present their case on a particular theory. They presented it and quite ably, and did so in a very powerful piece of animation at the closing of their argument. And there the matters lie. Without any significant change of law, they would now be saying, wait a minute, we're a week into this. We have just heard the jury give this extraordinary explication of what they're thinking. We sort of have a sense of where the fault lines may lie. We have a sense of what the division is, and we now know that the theory we propounded tactically isn't working. And my God, for the first time in the annals of American jurisprudence, we are going to get a chance to take all that information from the jury and argue our case all over again. Now, the court may feel that it was out of consideration of the defense, which submitted an instruction that it relied on in closing, that it ought to, in fairness, extend to the defense the chance to explain or deal with the fact that the special instruction is not there. But we don't see any way that this case could be re-argued without the prosecution saying, my God, ladies and gentlemen of the jury, let me explain the tremendous importance of what the judge did. He's thrown this case open to new theories. I'm now going to explain the new theories. You've got to start your deliberations all over again. You've got to abandon your positions because the court has given you a tremendous signal by the withdrawal of this. So we adamantly oppose the reopening of argument in this case.
All right. I just want to point, and I'll hear from the people momentarily, that by doing that, based on all the cases I've read where this has been presented to the defense, it's not the first case where there's been an opportunity or an offer to re-argue. By not accepting it, you basically waive that issue.
Yeah, Your Honor, and let me be clear on this because I fully expected the court to raise this question. And the court would agree, we've made our mistrial motion on the grounds that the instruction should not be withdrawn. But we have very explicitly and on this record stated that the court has offered an opportunity to the parties to re-argue the case in the absence of the instruction. We appreciate that. We feel that it would compound it either would have compounded an error if an error has been committed. If an error hasn't been committed, it lays open the possibility of one now being committed. And on that basis, yes, we state on the record we are declining the opportunity the court extended to us.
All right. Thank you. People?
The only thing I would clarify is I never said, contrary to Mr. Reardon's statements, I never said that we regretted the tactical decision we made. We made the tactical decision to go with a charge to the jury of second-degree murder, and that's a tactical decision that we stuck with. The whole reason that we argued this morning under Lee is because the court specifically invited us to submit arguments on Lee. We read Lee in a way, and I think the court stated it this morning, that it's somewhat ambiguous and could go either way. We read it one way. The court ultimately decided it went another way. We did not, nor have we ever regretted any decision we have made tactically in this case. If Mr. Reardon's position is that he is waiving, on the behalf of the defense team, is waiving any argument on appeal on this issue and wishes not to re-argue, the people submit it. That's fine. I'm assuming that takes into consideration the fact that it sounds like there's 2 or 3 things that are going to be done. The court's going to re-instruct based on the question and proposition thing that we went through. The court's indicated earlier that it was leaning toward, and I'm assuming
we haven't decided that yet.
Okay, on more. That's something that we still need to litigate, and that would have some impact in our decision and our argument. But insofar as the withdrawal of special instruction number 3, that is a hiccup, if you will, for several of the jurors. As the court has stated on the record, it is not an accurate statement of the law. With the withdrawal of that, we're fine.
Okay. The parties may wish to give me some proposed language they want me to use to the jury in the withdrawal of 3, or I can just do it on my own. If you want to get together and perhaps work on something, I'm happy to take a look at whatever you come up with. If not, I'll just have to do it on my own. Okay. Is there anything else we need to discuss?
Your Honor, what's going to be the determination on whether or not you get more and in what form?
Let me give it some thought. I want to reread it, I'll do it right here, and then I want to think of it in light of whether it's necessary with, if we take the other remedial paths that we possibly can, whether it's necessary at this point. I might withhold more until, if there's further disagreement, I'll have to wait and see.
Your Honor, we do have some specific objections to the instruction that's proposed.
Well, here's what I'm suggest. Given the fact that the jury indicated certain concerns that I can remedy without resorting to the so-called more instruction, and the fact that it may be necessary later on to go to that instruction, or that's a possibility, I don't think I need to go there at this point. I think the better thing to do is take it in steps, see if what we're doing at this point assists the jury, and then if it doesn't, worry about it when we get there.
It's purgatory, man.
I don't want to argue with the court. I would simply pose, I think, more answers some of the questions on the, I don't know what to call this, the jury questions, if you will. More specifically answer several of those questions. Now, there were several jurors who had a problem with special instruction number 3. The court is going to address that. But there are several other jurors who had issues that are specifically addressed with more insofar as how the deliberative process is to be undertaken, that dealing with reasonable doubt, that dealing with whether or not everybody has to agree on certain things, that dealing with whether one person's opinion or one person's view of the facts is in opposite of others, and where that leaves them. More answers all of those questions, and it's not prejudicial to the defense in the least.
All right, let me say this. I think what I need to do is, why don't you tell me what your objections are? I'll give it some thought, and we'll come in earlier tomorrow, and I'll let you know.
Okay. Should I do it right now?
Yes, please.
All right. Your Honor, in the second full paragraph, beginning, it has been my experience. That first sentence we would object to wit, it has been my experience on more than one occasion that a jury which initially reported it was unable to reach a verdict was ultimately able to arrive at verdicts on one or more of the counts before it. First of all, that sounds like it's been particularized to this court and this case, which all of the other instructions are written in a broader, more neutral sense. More significantly, it sounds coercive that other juries are able to reach a verdict. If you guys were up to snuff, you'd be able to reach a verdict yourself. So we object to that. In the last portion of the last sentence of that same paragraph, the phrase is, regardless of how long it takes to do so. We want you to, reach a verdict regardless of how long it takes to do so. I think that's a direct violation of Gaynor. Basically, you're telling them you'll be here until the bricks fall down, which with this building may not be that long. But
that takes nothing. A bad sneeze might bring this place down.
But that threatens them with being here for as long as it takes. And I think that Gaynor has precluded that type of instruction. Going down the page, the second full paragraph from the bottom that starts, as I previously instructed you.
Yes.
The first sentence says they can deliberate in any way they want, and then the court tells them how to deliberate, and then says, well, you don't really have to pay attention. I mean, to tell the jury, I suggest that since you've not been able to arrive at a verdict, you do these other role-playing, game-playing, touchy-feely 21st century concepts.
This is Southern California, Mr.
I just have never been able to get there. But what it does is it says, we don't care, you can deliberate any way you want to, but here's how I suggest you do it. Besides being logically inconsistent, it is impermissible to tell the jury how to go about its deliberations, and whether or not it's new age or not, I just think it's inappropriate.
You mean you want us to take the hot tub out of the jury room?
I will miss the jokes.
Just send in towels.
Leave the bongs, but take the hot tub. And then that goes on to first sentence. That concept continues on to the second page.
Okay.
And that's it. Those are my objections.
Okay. Thank you. I'll hear from the people.
Your Honor, with regard to the, I don't know what your experience is, quite frankly, but I'll bet you this isn't the first time that you've had to send a jury back after they've indicated that they've had an impasse.
Very few, actually. Very few.
That says a lot about the trials you preside over. I'm not married to that particular language. I mean, that is whatever the court wants to do with that language. And with regard to the regardless of how long it takes to do so, we can strike that, and it doesn't change anything one way or the other.
Well, in light of that, let me just take these things out.
Okay. With regard to is the court...
I'm done.
With regard to the third objection, beginning with the sentence, may I suggest, that's exactly what it is. It's a court suggestion, and I think it's an appropriate one. The court is in a unique position to help guide and give guidance to jurors as they deliberate. The previous sentence indicates you can take it or leave it. I'm just making a suggestion, and you may consider changing the methods that you've been following. The jurors may not know that they're entitled to change the methods that they've been following. I mean, there are cases that indicate that the jurors can and have changed forepersons, changed the way that they have conducted their deliberations, changed sides that they've taken. There are any number of ways that they can conduct their deliberations, and it's completely up to them. This is simply the court informing them that it is up to them and making some suggestions that may or may not be helpful. I don't think that's in any way prejudicial, and I'll submit on the rest.
What I'm going to do, thank you both. I'm going to start with the second full paragraph from the bottom. I'll take out the language, may I suggest that since you have not been able to arrive at a verdict using the methods that you have chosen, because that may be deemed a criticism, which I agree might not be appropriate. I'll simply indicate to them you may wish to consider changing the methods you've been following, at least temporarily, and try new methods, and then just give them the different things they can consider, which is merely, you might want to try it. Maybe you don't.
We're fine with that.
Okay. Anything?
No, Your Honor, but what we will do is if we do have suggested language vis-a-vis the withdrawal of number 3.
Right, I'd like to see it, quite frankly.
We will, if it's agreeable to you, fax it to you by 9 o'clock in the morning.
That's fine.
All right, thank you.
And why don't you come in at 9:30 tomorrow? The jury's coming in at 10. That'll give us time to discuss anything that we need to do. Okay? Thank you.
I wonder, too, could we, for some reason, I know that Mr. Jackson, when we got to the final packet, the final redacted, modified change back in the jury instructions, he did give us one, but for some reason, no one on the defense team has it. I wonder if we could get an extra copy. I don't know if the government may.
Okay.
Okay.
All right.
And,
Tomorrow morning,
yes. Okay.
And we also would like to get a copy of the note from the jury, if possible, for our record.
Oh, you mean this one here? Sure. Well, actually, here it is. The jury has reached an impasse? Yes. Okay. Wendy will have it. You can copy that.
We can get it tomorrow morning.
Okay.
Can we do a couple of housekeeping things?
Sure.
Counsel expressed a desire to mark this juror's question thing that they've been referring to this afternoon as a court's exhibit.
Fine.
Yes.
And the next in order would be Court 66.
Okay.
We talked about, but I don't think we ever put on the record,
New voice.
marking also the PowerPoint presentations for closing argument.
God, we've almost
So if
made
I
it.
could put on the record,
We'll spin it
people's
into-
closing argument.
it's happening in 1 second.
PowerPoint presentation on CD is Court 62. People's rebuttal argument PowerPoint presentation on CD is Court 63. Defense closing argument PowerPoint presentation is Court 64, and People's rebuttal animation
Bonnie!
presentation is Court 65.
Doing, Bonnie?
All right. And they'll be
Good
available in the
afternoon.
lobby for purchase.
Hope you're doing well.
We want
Yes.
to note that the jurors sent out about the impasse.
It's going to be filed. It's part of
It'll be filed as part of it.
Right.
Thank you.
Judge, we'll modify to special instruction 4 and have it available to you tomorrow morning.
Thank you.
I think he now needs to redact the juror's name, and he wrote his full name.
Yes, he did write his full name, so. Yeah.
Extra long episode today. We're getting ready to get hit
Okay.
4-hour mark.
Thank you, Your Honor.
Thank you, Mr. Reardon. All right, we'll see you tomorrow morning. Thank you. We're in recess.
Let's get ready to do a will. Let's have a break with a will. Give away some goodies here. Getting ready to go into an hour 45. Jesus fucking Christ. The judge and counsel discuss how to proceed after the jury says they cannot reach a unanimous verdict. So really just more of this shit. All right. Let's spin a wheel before we get into this. We're getting close, guys. Looks like we're going to be going more into about the 2 o'clock range here. All right. Let's go. Good luck, everyone. Ooh, who's that? I can't even read my own writing. Bluebird! Holy shit, Bluebird won! Bluebird is lucky. Bluebird, you need to go buy a lottery ticket, because the 2 times she's been on this wheel, she has pulled out a victory, and I just now sent her a shirt out last week. Bluebird, congratulations. Well deserved. Also took the #1 top in chat earlier. Bluebird is awesome. Fuck yeah, Bluebird. I appreciate the hell out of the support, and you have been a real one since I've met you. Love it. The hell yeah. All right, let's keep rolling. An hour 45 of this fucking shit.
Back on the record, the defendant is present with his counsel.
Jesus
the district attorneys are present. The jurors are not.
Mr. Reardon on the speaker.
Mr. Reardon is here in spirit on the speakerphone.
Oh my God.
We met informally this morning in chambers to discuss
We're so close.
finalizing the instructions, and I went over with counsel some of the problems I saw after considering some of the discussions yesterday. So where are we at this point?
I think it's probably best addressed by the defense. They have proposed
so we have
an amended
about 2 hours left. The
and
last video is like 11 minutes. This one's 1:45. So we got about 2 hours left. So we're going to go over 2
I believe
o'clock.
what you'll hear is
and
an
we will be
objection,
done with this shit.
by the defense.
Done, Phil Spector.
The reading of any portion of 875. I'll let Mr. Rosen or Mr. Brown speak to that.
Well, I think that Mr. Reardon is going to handle that.
Mr. Reardon?
Congrats, Bluebird.
Mr. Reardon?
Your Honor?
Yes.
Morning, life artist. I'm good, Bonnie.
Right now, we are proposing, and Mr. Reardon will argue this, that no instruction based on 875 be given because it's going to invite Ireland error. We can't think of a way to avoid it. Mr. Reardon will more fully articulate that. We have proposed an instruction that I think addresses the concerns the court has expressed, and Mr. Reardon is going to tell us more about that.
Go ahead, Mr. Reardon.
Thank you, Your Honor. Your Honor, in chambers, we discussed various matters. We renewed our objection to withdrawal of special instruction number 3. The court indicated that objection would be overruled. We objected to any supplemental instruction on murder or implied malice murder because that would only be appropriate if 3 was withdrawn. The court indicated that since it was going to withdraw 3, it would give a supplemental instruction on murder. And the court expressed the concern that unless it gave some instruction to the jury, they might be completely untethered as to what acts they might consider as the basis for implied malice murder. Under Special 3, they were limited to the act of having the gun enter the mouth of Miss Clarkson with Mr. Spector's hand on it. If the court is withdrawing that, the court expressed concerns that, and these are concerns that certainly would be those of the defense as well, that the jury might simply focus on something like brandishing, which might be the appropriate basis for a misdemeanor manslaughter charge, but would not be appropriate for a charge of implied malice murder. So it felt that the jury needed some direction and limitation, and it felt that the limitation ought to come in the form of informing them that the act that they can consider, the actus reus, has to at least have the gravity of an assault with a deadly weapon, which of course is a serious felony. And so where we left it was that we were going to look at some way to integrate that limitation to assault with a deadly weapon into a supplemental instruction on implied malice murder. And with, of course, having reserved our objections to any instruction, we think that the solution for the court is an extremely simple one. And on the other hand, anything but a very simple one poses grave dangers. What we have proposed is that the court take the implied malice murder instruction that it has already given, and hopefully the court has a written version of this in front of it, and simply say where it would normally say the defendant committed an act that caused the death of Lana Clarkson, the defendant committed an act with a deadly weapon that directly caused the death of Lana Clarkson. And again, when we get down to implied malice, number one under that, the defendant intentionally committed an act with a deadly weapon that directly caused the death of Lana Clarkson. And so the court then has given the prosecution the benefit that it has ruled that it felt it unfairly took away from it by specifying a single act, the act of the gun entering the mouth with Mr. Spector's hand on it. The court is saying that if the jury finds another act with the gravity of assault with a deadly weapon that caused the death of Lana Clarkson, they can rest a conviction on it. We have already preserved our objection that we don't believe that the evidence supports any other act other than the one now before the jury. But it's a very simple change. It just adds with a deadly weapon to the instructions and does add the word directly. And the reason for that is that there are no proximate cause theories in the case. In fact, the people excised the proximate cause language from the implied malice murder instruction when the court originally instructed on it. So this is a direct causation case and not a proximate causation case. And the one thing that we feel very strongly about is that if the court were to lift any more language from the ADW instruction, the assault with a deadly weapon instruction, and if it were to lift any language that talked about great bodily injury, which of course is the normal ADW instruction, that is that one does something with a gun that could reasonably cause great bodily injury to a victim, then the court, that term great bodily injury in any form would walk right into the Supreme Court's decision only 3 months ago in the Nolan case, in which a appellate court had written an opinion that...
Get it, Jersey Jan. I'll see you Tuesday night. Thanks for all the support and coming through here and getting some more folks. I appreciate it. Have a good Sunday.
Great bodily injury into the implied malice formulation in California, and the California Supreme Court reversed the First District Court of Appeals 7-0, saying that the great bodily injury language has no place in an implied malice murder case. So with having preserved our objections, we propose some simple additions to 520 that would expand the scope for the prosecution in the way that the court felt that to the extent that the court felt they should have that expanded version by not limiting them to the specific act listed in special number 3.
All right, thank you, Mr. Reardon. People wish to be heard.
Your Honor, with regard to, I guess I would ask for guidance from the court. Do I need to get to the amended 520 that Mr. Reardon just talked about, or is the court's intention to include the language of 875 as we talked about informally in chambers?
I'm looking for options here, so I think you need to address it.
Okay. The only problem, I wouldn't have any, and I don't think Mr. Dixon would have any problem with the amendment to the malice aforethought, I'm sorry, the 520 CalCrim, except for the word directly. The word directly puts us right back into the same category that special instruction number 3 did to begin with. I think more appropriately, I think it could be tailored a little bit more finely. The defendant committed an act with a firearm that caused the death of Lana Clarkson. The word directly in both paragraph 1 and the subsequent paragraph 1 under implied malice imposes a burden on the prosecution that simply doesn't exist. We don't have to prove, and the jurors don't have to find, that Mr. Spector directly caused, quote unquote, directly caused the death of Lana Clarkson. We just have to prove that he committed an act, that being assault with a deadly weapon or assault with a firearm, that ultimately resulted in her death. It would limit, and I think that's the reason that the defense so badly wants the word directly in there, because it puts us back into special instruction number 3. It limits the options of the jurors to make a determination that he was assaulting her with a firearm and she reached up and grabbed the gun, that he was assaulting her with a firearm and she reached up and slapped the gun, that he was assaulting her with a firearm and a struggle ensued and the gun ended up in her mouth and went off. Any of those options, which are available to the jury factually, and it's up to them to make a determination factually what happened, would confuse them if the word directly is here. I can see a juror certainly saying, well, that's not directly caused. He would have to have pulled the trigger himself intentionally for it to be a direct causation. That one word simply doesn't need to be there, and that's not the law. It imposes a higher burden than is necessary. So if the court is considering the amended CalCrim 520, I actually appreciate Mr. Reardon's addition of the specifics of this case. I think it does do it is in line with the facts of the case if we amend it to say the defendant committed an act with a deadly weapon or with a firearm, more appropriately, that caused the death of Lana Clarkson, and with regard to the other paragraph, he intentionally committed an act with a firearm that caused the death of Lana Clarkson. We have no problems with that whatsoever.
Are you saying you object to the word he intentionally committed an act?
Shaking it up, baby.
Put
a shaker in his hand, play some tunes.
That's what.
So that's what's required.
Correct. That's.
Okay.
I'm not objecting to that at all.
Perhaps
I'm objecting to the word directly.
I misheard you then. Okay.
No.
Your Honor, I would agree with Mr. Jackson, and I apologize for the oversight. I think firearm is correct in this case as opposed to deadly weapon. So we'd agree to that amendment. And all I can say on the other is that there's two kinds of causation in the law: direct causation and proximate causation. If the word direct is not in there, it would leave the jury open to a proximate cause theory on which it hasn't been instructed. The proximate cause instructions were struck, and certainly the proximate cause instructions can't be injected into the deliberations at this point. So we'll submit it, but we would stand by the word direct.
All right. Thank you, Mr. Reardon.
Your Honor, just
yes, Mr. Bruno.
Point, if I may. None of the three scenarios posited by Mr. Jackson would be excluded by the inclusion of the word directly. Each of those acts would be in response to the direct act and would be part of the direct act of Mr. Spector had that been proven. So I don't think that this instruction limits the people the way they argued it to the court.
Thank you. Mr. Jackson.
I think it absolutely does. I don't need to restate it. I think it absolutely does. Those three scenarios, a juror could go back and say, well, that's not directly. I mean, if she slapped the gun, the slap directly caused the death of Lana Clarkson. I think the defense is playing fast and loose with semantics, which are very important to the jurors. The jurors have shown how important it is to them with regard to special instruction number 3, which is now going to be withdrawn.
Well, without ruling one way or the other at this point, I'm going to have to give it some thought. We know that they're confused by it. We know that there's a problem, and the problem, I'm going to when we're done talking here, I'm going to restate exactly what's brought us to this. I'm going to summarize everything because I think it's becoming extremely confusing, not so much to the lawyers, and myself, we know where we're at, but I think we've managed to make it so dense that the general public doesn't know what we're doing, and it's very important to me that they understand why we're here and what we're doing, and I'll summarize it and try to explain the problems. We don't know what the problem with Special Instruction 3 was. We know that the jurors were confused by it, which doesn't mean that's why it's being taken out. It's being taken out because the language that was employed unduly limited the possibilities that the jury could consider, because the language that was used was this particular act, which was placing the gun in the mouth of Lana Clarkson in the hand of Mr. Spector. That is unduly limited on what the law of second-degree implied malice murder is. It was given because that was the only theory that the people posited during the trial, but the jury is not limited just to that theory as long as they limit themselves to reasonable inferences that can be drawn from the evidence and do not speculate. That's what at the time it was given, we all thought it was correct. However, when the jury indicated a confusion, it then gave us me a chance to reconsider it and realize that there was a problem with it. That may or may not solve their confusion. We don't know what their confusion is. We don't know whether all or some. We know that some individuals have indicated they have a problem with that, but we don't know how they have a problem with it. So to speculate that specific language in 3 is what's causing the problem, we don't know. I want to take a look at the proximate cause instruction and see if I believe any impermissible language is being used if we don't include that in the revised 520.
Bluebird, you won that wheel. Go buy a lottery ticket.
Well, Mr. Reardon, are you still with us?
Yes, Your Honor.
Thank you. I would ask you, in light of number 4 in the instruction, whether it's the amended or the original 520 we gave, where the last, that sentence is, he deliberately acted with conscious disregard for human life. There's your deliberate. And why does it have to be re-expressed as you have done in your proposed instruction?
I'm sorry, which part of the proposed instruction is the court questioning? Number 4?
No, number 4 is a correct statement of the law. He deliberately acted with conscious disregard for human life. That's clearly the correct statement. In light of that, and what the language that the people are complaining about in your proposed instruction, which is that I believe it's he intentionally committed an act. Directly.
As I understood it, Your Honor, they were simply objecting to the word directly.
Exactly, and I'm saying, in light of number 4, which uses the term with the correct term, deliberately, why is that any different? What is added by your term of directly?
Well, Your Honor, as I say, this has always been a direct causation case.
Yes.
The people's theory was that has been that Mr. As evidenced in their animation, that he had the gun in his hand, and when it went off, I mean, we are. I don't think there's any question that the jury is going to assume that pulling Special 3 and adding this means something. And it does. The court intended to expand the language beyond the very specific detailed language of Special 3, and I think the word directly ensures that we don't have somebody in there speculating about theories that Mr. Spector made deprecating remarks to Miss Clarkson that led her to shoot herself. There's no evidence in the record for that. That would get into, manslaughter and so forth. Directly, while the language is expanded, it's not just the details of Special 1. It continues to be limited to a firearm that directly caused the death. I think it maintains the court expressed the greatest concern, and we're grateful for it, that they not just go off on a brandishing theory. Well, brandishings aren't implied malice murders unless they directly result. They can be if they directly result in the death of someone and they're done with implied malice. So I think directly helps impose the limitations. The court wanted to expand
Amber, thanks for popping in.
The instructions to the jury. Withdrawing 3 expands and directly limits.
Your Honor,
yes,
to directly answer the court's question.
Holly Berry making it the murder church. Only because I've been going forever.
Acted in 4 goes to the mental state and knowledge. The act that directly goes to the act that causes the death. That's the distinction.
I don't disagree, but then I think the question that has to be answered is, if you look at 520 in its original state, and all we're doing with 520 is taking the specific acts of this case, putting them in 520 so the jury doesn't stray into brandishing. I'll explain that at length later. But the bottom line is, if you look at number 1, the defendant committed an act. It doesn't say the defendant directly committed an act. It says the defendant committed an act. And if the concern is that they're going to, that's not my concern. That's the concern is that it be an act with a deadly weapon and not merely waving it around. I have to take out any possibility of brandishing. The parties originally, I'll go into that, originally all agreed that was not an issue in this case. And if we get into that issue, then it's going to cause the problems with giving manslaughter instructions, which can't be done at this case at this time. And that's where we're at.
The elegance of this simple instruction, it requires the jury to find that Mr. Spector's act directly caused the death. It eliminates waving the gun around and something happening. It has to be an intentional act done with conscious disregard that directly led to her death. That is what the law under these facts requires, and that's all that this instruction requires.
And actually, I would direct the court's attention to subparagraph 2 under implied malice. That's not what it requires. The law requires that the natural consequences of the act were dangerous to human life and ultimately led to the death. It's directly in opposite of directly caused the death. It just has to be an act, the natural consequences of which were dangerous to human life. And that's the assault with a deadly weapon or assault with a firearm.
I see another problem with this instruction. And my problem is it doesn't address the court's concerns that if we don't get very specific, that the jury might consider what is an act of brandishing and decide this case. And brandishing can be a theory for second-degree murder, but the problem is it can also be a theory for manslaughter, and the jury has to be given the choice.
Look, it'd be gross, but
even with this language that has been proposed by the defense, it doesn't, as I see it, rule out the possibility of brandishing. That's why I said that the elements of an assault with a firearm have to be given, because that's the completed act. That rules out brandishing because it goes beyond. The way you've written this instruction, it doesn't. It doesn't. It leaves the possibility open. It's too broad.
Well, Your Honor, the problem is that if you give the elements of assault with a deadly weapon, they include statements that it's an act that would might reasonably result in the application of force to a person likely to produce great bodily injury. Great bodily injury after Knoller is just absolutely verboten in an implied malice instruction, Your Honor. And what we have to do is ensure that the jury knows that it's got to be implied malice, conscious disregard for life, which is completely inconsistent with the elements of assault with a deadly weapon, which is a general intent crime.
Give me, well, I'm not worried about, certainly we can word it to take out the concern about general intent, which obviously is not applicable. Give me the case site on Knoller. Yes.
Thanks for coming in. I'll be the judge.
Knoller is the dog mauling case. That was...
I'm familiar with the case.
The site
it was interesting.
3 or 4 months ago, 41 Cal 4th, 139.
All right. I'm going to need to take a look at that case.
And it was the case in which
I'm very familiar.
The Court of Appeal in reviewing a murder
Mr. Reardon.
conviction, the grant of a new trial.
Shut the fuck up!
A conscious disregard of the great likelihood or probability of great bodily injury would support an implied malice conviction, and it was reversed 7-0.
How does he not hear any of that?
Supreme Court.
Thank you. All right, let me. I'm going to go read it. Where's your off button, Mr. Reardon? Thank you. I'm going to go take a look at the case. I want to look at the specific language that you're concerned with and see how it applies to the fact situation we have. So I'm going to take a short recess and we'll get back. Thank you. Yes, sure. But you have to set the phone so it only gives very short replies.
He's been spoken to.
You can't hear on the speaker list.
I know.
Speaker's on.
He's on?
He's calling.
Oh, he's calling, okay.
Sean gets it, then she has to put it on.
Okay. Mr. Reardon? Mr. Reardon?
Maybe you asked for too much.
Mr. Reardon?
Yes.
There. Can you hear me, Mr. Reardon?
I can, Your Honor. I've got my finger on the off button.
All right, thank you. All right, I have taken a look at the Knoller case, and it is instructive, and it does have some bearing on what we end up doing. That's Knoller, K-N-O-L-L-E-R. Okay. And I agree, Mr. Reardon, with the defense contention that if I were to instruct with the language of ADW, that would be a problem, because the language that is in the instruction, as the Supreme Court pointed out in Knoller, by allowing a conviction on an ADW without the language that it would lead, knowing the risk of death, I'm paraphrasing, is impermissible. And that's what the court said. However, your instruction still does not answer my concerns, and that's where, and let me try to summarize what the concern is. This case was presented to the jury, presented to the court on a very specific theory, and that theory was that Mr. Spector either basically placed the gun in Ms. Clarkson's mouth, causing her death. The people are correct in pointing out that although that is their theory, that as long as the jury relies on evidence that was presented and the instructions that the court gives it, they're not bound by that theory as long as it's a reasonable inference drawn from the facts, and that's their concern in these instructions. One of the problems is that from the facts presented is that the jury, because this is a murder case, was presented only on the theory of murder and not on the theory of manslaughter, which both sides were adamant that manslaughter did not apply to the facts as presented, because if indeed Mr. Spector placed the gun in Ms. Clarkson's mouth, that goes beyond the crime of brandishing, which is a misdemeanor. Brandishing, however, can serve as a basis for both manslaughter and murder. It depends on whether the jury finds that there is a implied malice theory, and if they don't find the implied malice, they can convict on manslaughter. If they find the implied malice under the same set of facts, they can convict of a murder. The jury has not been instructed on manslaughter because of the fact that both sides agreed that under the facts presented there really wasn't a brandishing, that if anything, there was a completed act with the firearm, whether we call it an assault with the firearm, but it went beyond merely brandishing, which is exhibiting, and again I'll paraphrase, exhibiting a gun in a rude, threatening manner. That's one possibility for brandishing. Because of the timing of this case, if we went back, and one of the things the court had considered, and I considered it because I thought the Lee case that I cited might make it mandatory in all cases, even where it goes beyond a brandishing, that it still be given as an option to the jury as a lesser related offense. It is not an included offense, it's a lesser related offense. I think Lee, and we've talked about whether Lee can be distinguished, we talked about it yesterday, although it was a concern of the court originally, I think Lee is limited to its facts. Under the facts of that case, there was a possibility there was only a brandishing that led to the death, even though there was a contact wound. So I'm not concerned that Lee is the controlling factor. But one thing we have to be sure of, I have to be sure of, and the law has to be sure of, is that because brandishing, if you give brandishing, if the jury is considering brandishing, they would have to be instructed on manslaughter. We can't instruct them on manslaughter under the Stoddard case and the Jennings case because of the time we now realize The jury has indicated a problem by doing so would tend to direct that they find a manslaughter. That's the reason I'm not going to do that, and I stated that yesterday. I have to be sure, and this problem sort of became apparent when Mr. Jackson was talking about the theories that the jury could consider, and while I'm in total agreement, and the reason that we're withdrawing instruction number 3 is although the jury may consider certain acts other than directly placing the gun in her mouth, and we've posited some of the possibilities, they cannot consider the act of brandishing. If they do that, they're going on an improper theory under the way this case must be instructed. And I have to be certain by the instructions they're given. And when we had instruction number 3, that wasn't a concern, because it specifically stated, you must find this, which clearly had nothing to do with brandishing and went way beyond that. I have to be satisfied that however we state the instruction, whether we modify 520 or whatever, that the jury needs to know they cannot consider the mere act of exhibiting the gun or something like that. In other words, if they start to think and get together, oh, Mr. Spector was waving the gun and somehow the gun went off and that killed Miss Clarkson, that would be possibly murder, but it also would be possibly manslaughter. So we have to take away that consideration. This instruction as drafted by Mr. Reardon doesn't do that.
Well, Your Honor, why don't you just include that language that you just stated in this instruction? I further instruct you that the mere act of displaying or waving the gun around would not be the basis for a finding of implied malice.
I thought of that, and that's one thing I want to broach to you at this time, whether that we can incorporate that, but they also have to understand what can be used. I mean, that's fine, but they have to understand, without using the specific language from assault with a deadly weapon, because it has that fatal flaw, if you will, in the language that gets it out of implied malice, we have to find a way of stating, and it may be very specific acts. If you find A, B, and C, that's acceptable, but if you merely find D, E, or F, that is not. This is the problem I'm facing, because otherwise we're not going to go, this case basically can't go forward with the way the instructions are written now. So you may want to spend, we're already at 11:45, spend the lunch hour trying to draft, and I'm going to try to do it as well, but I think we all need to try to draft some appropriate language that addresses my concerns, that allows the case to go forward on the appropriate theories, that the people are not cut off from correct theories that the jury can consider, not limited to the one that the people posited in instruction number 3, but at the same time the jury doesn't go beyond what they may. That's what we have to do. So put your heads together, see what you come up with. I'm going to work on it over the noon hour, and we will resume at 1:30 this afternoon.
Could we let the jury know sort of how this is going? So
Well, we're working on the instructions. They've been told that we were going to give them new instructions, and Wendy will send.
told them that their day's planning to be like this, so they're
Yeah, so they're fine. Okay? All right, we're in recess till 1:30. Cal 4th, 1083 at page 1145. And go down to head note 27. That was a case where the court didn't have to instruct on brandishing because of the acts they found, and if we can use that language somehow, that may prove useful. 20, that's page 1145. That's the page, and that's important. All right? 28 Cal 4th, 1083 at page 1145. Okay? Thank you. No, I've read it, I'm familiar with it, and actually don't need it. There's problems with it that I'd be happy to express to you. All right, take a moment, take a look at it. All right, the parties are present as heretofore. Jurors and alternates are not present. Mr. Reardon is also present by speakerphone. The parties are looking at a proposed instruction that was submitted by Mr. Reardon. I have some very specific problems with it, and the parties are free to look at it and comment as they wish.
Is that one that the court drafted, or did the defense draft?
No, I certainly did not draft that.
Okay. I was looking at the title. It says court supplemental instruction. I'm assuming that's just a title. Okay.
And I have taken the liberty of drafting, which I will have to read because I only have a handwritten copy of what I believe now that the proposed instruction should read, and then I sort of want to move along after we discuss it so we can get to the jury.
Okay, there's something that I would like to bring up, and I think we'd like to address with the court. All of this kind of hit us relatively quickly with the court's conference call last night with Mr. Rosen and myself. And then the discussion.
I should state, we had, in anticipation of some of the difficulties we've been discussing, I did have a conference call last night with Mr. Rosen and Mr. Jackson. Mr. Dixon got cut off in the middle of it, simply to give the parties a heads up that I had some concerns about the instructions that we've dealt with today or are dealing with, and that was the content of the phone call.
Over the lunch hour, we all got together, had a chance to kind of take a deep breath and take a look at what it is that the court expressed some concern about. And the court synthesized its concerns, both in chambers and out on the record, as basically as follows. The court feels as though if it were to allow the jurors to continue to deliberate based on an act, let's just call it an act, whatever act that is.
Oh my God, sorry. My bad. Fajitas sneaking up on us today.
The court indicated, waving a gun around, etc., or any act between that and actual assault with a deadly weapon or assault
Morning,
with a
Adam. What's
firearm,
up, dude?
that the court would be compelled to give the lesser charge.
We're going long
of
today.
involuntary
We are
manslaughter.
finishing this
The
thing
reason
up.
The court gave is because the court indicated that with that particular act, that could also constitute an involuntary manslaughter, and if that instruction isn't given,
4.5 hours
then we run afoul
today,
of the lesser included
in the
offenses obligations. And given the fact that the court doesn't feel that it can give the lesser included offense because of Jennings and its progeny, it's in a bind.
An hour 20 to hour 25 left in this
at
entire trial.
In absolutely, I think all of us have been looking at this in absolutely the wrong way.
Okay.
It dawned on us, and literally, well, not literally, figuratively as it can get, a light bulb went off as we sat and discussed this. And I looked at a case called Benitez, and I think
I am very familiar with Benitez.
Okay, and I don't think any of us are in disagreement about what Benitez says, and the court has made this sort of finding, if you will, acknowledged the finding of Benitez several times that, for instance, a brandishing can be, a 417 can be the basis for a second-degree murder conviction, but it has to be brandishing plus something, and that something is malice. And that's what we have not been focusing on. And this is actually an extremely simple resolution. I think the court's concerns are covered by the recognition that we instruct and continue to instruct and maybe re-instruct on the necessity for the jurors to find malice. Brandishing alone, or any waving or an act like that alone, will not support a conviction for second-degree murder unless it's accompanied by malice. Since the jurors have been instructed and will continue to be instructed on the necessity to find malice, any act that they determine is accompanied by malice will legally support the second-degree murder conviction. Now, the court indicated, what if, Mr. Jackson, we were talking back in chambers, what if, Mr. Jackson, they decided that they wanted to use a 417 as the basis for their opinions, one of them or six of them or all of them, and they don't have an involuntary manslaughter to fall back on, which is what the court was understandably concerned with. The answer is very simple. If they utilize that act and say that it is not accompanied by malice, if the court had given the involuntary instruction, the fallback would be involuntary manslaughter. Without the instruction, the fallback is not guilty. The defense had an opportunity to ask for the subordinate crime, the lesser included offense of involuntary manslaughter. We had an opportunity. We all decided amongst ourselves, strategically and tactically, that was not the direction we were going to go. So now the choices are simple. They have to find that an act was committed, and they have to find that that act is accompanied by malice. If they find that the act was committed and it's not accompanied by malice, then the defendant gets the advantage of a not guilty verdict from that particular juror, and if all of them agree, from that entire jury panel. I don't think the court has any concern, there shouldn't be any concern on the court's part that it isn't instructing on involuntary manslaughter, because that's what the consequence is. A not guilty verdict instead of a lesser included offense. Does that make sense?
Well, I understand exactly what you're saying, but it doesn't solve the problem.
How so?
It doesn't solve the problem because it follows. In the very case you cite, you realize that the court gave both manslaughter and murder instructions because
Absolutely.
the court is required to give instructions on anything that is within the evidence presented. It's not limited to the theories, and that's why we spent so much time originally talking about what the possibilities were, whether there was any possibility to base a manslaughter conviction on, and then, and I mentioned at the time, and I have mentioned several times, and all the parties recognize it, that even if you both came to me at the conclusion of evidence, and if there had been evidence that would support a manslaughter charge, and you said, we don't want you to give it, tactically, from both sides, whatever, we just don't want it. The defense says to me, we don't want it. We accept that, if we don't, you don't give it and there's a conviction, we can't go to the Court of Appeal or the Supreme Court later and say, judge made a mistake because the evidence supported it, because in essence we've waived it by making a tactical decision, so-called invited error. And you had said, we don't want it for tactical reasons. We like all or nothing as well. We just, manslaughter to us for whatever reason is not acceptable. That doesn't control what I do. The sole reason I did not give manslaughter instructions in this case originally was because we did not have a theory. I specifically asked, is there any theory upon which a manslaughter conviction can rest? I said, I can't think of one because we did not see a brandishing. And the reason we did not see a brandishing was that everyone was in agreement that whatever happened in this case, it was a completed assault. It had to go beyond brandishing, which took brandishing away from the jury, took it away from any possible consideration. What you are asking me to do at this time is to say, there's no theory upon which manslaughter conviction can rest. There's beyond the brandishing. There is no brandishing, but it's something that does support a murder conviction, which is true. We all agree that if you have a mere brandishing, it can support a manslaughter. It can also support a second-degree implied malice murder conviction. It depends on whether the jury finds malice is present or malice is absent. My concern, and what your argument does not address, is if that jury goes in without proper instruction, and for instance, on an act just says, well, he waved the gun around, we think that's dangerous, that's great. Well, all of a sudden, there's a theory that supports manslaughter instructions, which I can't give at this point, if that's what you thought, because of the timing in the case. I agree with you that brandishing, if it's there, can support the murder charge. The problem is, you're telling me, and you have told me consistently, both sides have told me consistently, and I have agreed with you, there is no brandishing because it's gone beyond it in this case. And my concern is to let the jury consider something that isn't there.
I understand, and I guess what I'm trying to point the court to
And I realize when you say, well, if they come back with a murder conviction, by necessity they found malice. That's fine when they also have a manslaughter conviction because they tell you which way they're going. But you're telling me now it's okay for them to consider it. It's fine because if they do so, it's clear that they found malice, but you've also told me that that theory doesn't apply, that there is no brandishing.
Except there is, that's up to the jurors to figure out. We obviously had a theory that we were proffering and that we continue to proffer. It's up for the jurors, or up to the jurors, to make a determination as to which facts fit which law.
Oh,
if in fact, and this speaks directly to the
As
court's
mentioned earlier, if it's anything like where I live, you get paid jack shit. How can you even function normally without getting paid a proper wage?
concern that if in fact a juror goes back and says, well, I think he was waving a gun around, it was dangerous, et cetera, And you just said that
Jesus
supports a
Christ,
manslaughter.
CH bringing out the numbers. May 5th, 2024, all the way to August 17, 25. Holy cow, dude.
Conclusion.
It also supports a murder conclusion.
Only if there's
What a
malice.
long straight trip
I
it's
agree,
been.
but
It's
you
absolutely
keep telling me it's not there. The facts are not there. Not that you just, it's not a theory you proffered. We have all agreed, all the parties, that there is not a brandishing in this case because it has gone beyond a brandishing. I understand perfectly your theory. You keep telling me on one hand it doesn't exist, and then say, but that theory does support it.
What I'm saying is to address the court's concern that if in fact a juror were to find that, and if in fact the juror says, hey, look, it's dangerous, what he was doing was dangerous, et cetera, you haven't instructed on a manslaughter, and that would be consistent with manslaughter. Okay, fine. So the alternative is not guilty. That would be their alternative. I mean, am I?
You're not obtuse, Mr. Jackson. I understand it, but you're asking me to ignore. And I know I don't mean this in a derogatory fashion. You're speaking out of both sides of your mouth. On one hand, you say the theory's not there. No juror could come to that conclusion. That's what you're telling me when you say, Judge, there's no basis for manslaughter. When we started out in this case, there's no
Coming after
basis
Jackson
for it.
now.
There's no brandishing. And now you're saying, but it's okay for the jurors to think there is, or to use that as a conclusion. You can't do that.
Our theory had been that this is what
little
ended
spicy.
a completed crime ended up being a completed second-degree murder. That is clearly our theory. And I don't want the court to think that I'm intentionally speaking out of both sides.
No,
of my mouth.
and I want to make clear that when I use that term, I'm not being cute or anything else.
I don't
I'm
take
saying you're making two arguments, one which goes one way, one which goes the other, and they're not compatible.
I guess I'm saying what the compatibility is, we make certain determinations and tactical decisions based on the theory of liability that we think exists.
That's correct.
However, the jurors are entitled to draw from that same set of facts that we have synthesized as best we could. The jurors are entitled to draw whatever...
If it pleases the court, I'd like to pay my mortgage.
Conclusions they see fit. Ultimately, they are the triers of fact. If everything I said was absolute gospel, then I'd win all my cases, I suppose.
And that's correct, and that's why instruction number 3 is coming out, because it prevented the jury, although, and let me say it again, when number 3 was presented, the first couple of times I turned it down, it was clearly a misstatement of law. Ultimately, you had one theory, and I realize the jury isn't bound by that theory, and your theory was that Mr. Spector put the gun in Ms. Clarkson's mouth, fired it, and that's how she died. And based upon that theory, instruction number 3, although it may be a misstatement of law, was consistent with that theory. It was a pinpoint instruction that matched your theory and told the jury what it had to do. Now that the jury, and I think it's important to look at where we are, they have indicated we have a problem, and the jurors mentioned specifically, one or more, had a problem, unknown as to what the problem is with instruction 3. We know that somebody is having a problem with it. If I can, you had your aha moment. It's like, wait a second, we have a theory, but somebody is going somewhere else with that, and we don't want to be bound by our theory because legally they can convict as long as they're drawing their inferences from the evidence and they're not speculating. We want to take advantage of that. There's no problem with that. That's perfectly legitimate. Although you never argued it, it's legitimate, and that's why 3 is coming out. It's too restrictive. It's unfair. The mere fact that it was confusing the jury doesn't mean it can come out. That pointed up a problem with that instruction.
Right.
I recognize, and I have told you all in chambers, that by taking away, if you will, an otherwise viable theory, if we had instructed on it, including the manslaughter instructions as to brandishing, yes, you're giving up something. But in my mind, with the argument you're making, you have two choices. You have to give up the brandishing argument because everyone keeps saying it's not there. If it is there, I have an absolute duty to instruct on it. Since I can instruct at this point, the other alternative is for the defense's motion for a mistrial to be granted. That's what the alternatives are.
And I guess I won't beat a dead horse. I just wanted to add a little food for thought because this is a kind of a dynamic process as we all think about this. I guess what I'm suggesting is that the other alternative is not simply a motion for a granted motion for mistrial. The other alternative is the jurors get the instructions that they've already been instructed on. The court answers the questions that they've got, the ones that we went over yesterday. The court re-instructs them on 520 and what malice requirement, what the malice requirements are. And if they don't meet it, whatever their theory of liability is, the alternative is a not guilty verdict. That is an option. That is the other alternative. It's not simply that we're stuck. Oh my goodness, if for instance there was a conviction in this case on appeal, some appellate court would say, well, wait a minute, they should have been given the instruction on involuntary manslaughter, although the defense didn't ask for it for tactical purposes. The prosecution didn't ask for it for tactical purposes. The jurors might have considered something less than assault with a deadly weapon, for instance, waving the gun around or whatever. And we, as appellate jurists, have to determine could they or should they have come back with with an involuntary manslaughter verdict. Well, the other alternative was simply not guilty. If the safety net, if you will, of the lesser included offense is not there, then they jump all the way down to not guilty. There is no safety net for any other conviction. It's guilt of second-degree murder or not guilty. And I guess that's what I'm trying to... I'm not as articulately putting it as I should, but...
No, I understand what you're saying, but that's still error. And the bottom line is, yeah, if they acquit, then that's the end of the process. But if they convict of murder, and the reason I don't think your solution, which certainly I thought of, and I'm sure we all thought of it long ago, was, is it not unreasonable, given the facts presented, that they could go off on this brandishing? And normally that would be covered by the instructions, but we're in agreement that brandishing can't exist, and therefore they have to be told that. That's my position. Now, the instruction that was submitted by the defense, drafted by Mr. Reardon, is unacceptable to me for the following reasons. It did incorporate the language of brandishing, that would be insufficient. To me, it ends up being one-sided. It does not tell them what they can consider. That was, if you will, instruction number 3 originally took care of that, took care of the act by describing it, but now that's no longer there because it's too restrictive. So what I would propose, and this is a draft, and it's a little bit long, but bear with me, and there may be other possibilities. Some of these possibilities may not be applicable. What I have done is I have taken 520. I have incorporated the acts that I believe have reasonably been shown by the evidence that might have occurred that would support a murder conviction. I have also incorporated the brandishing language so that the jury cannot consider that, because that would be inappropriate, and the instruction would read as follows. The defendant is charged with murder in violation of Penal Code Section 187. To prove that the defendant is guilty of this crime, the people must prove that, 1, the defendant committed an act with a deadly weapon, or we can use firearm or gun as the case may be, that caused the death of Lana Clarkson, such as and placing the gun in her mouth, at which time it discharged, or by pointing the gun at or against her head and it entered her mouth and discharged, or by pointing the gun at her to prevent her from leaving his house, causing a struggle which ended with the gun entering her mouth and discharging, or forcing her to place the gun in her mouth and it discharged. If you find, if you find Mr. Spector used the gun against Lana Clarkson, he must have done more than just drawing or exhibiting the gun in the immediate presence of Lana Clarkson in a rude, angry, or threatening manner. And then the instruction would go on with the rest of the murder, the implied malice and malice. Now, if you have any other theories, and I will hear from the defense if they think that any of those theories exceed the possibility of the evidence, those are the ones that came to my mind. I am happy to include or exclude as necessary.
I think Mr. Reardon wants to speak first.
Mr. Reardon.
Well, Your Honor, I think that, frankly, if our Special 3 was unacceptable because it limited in a very specific way the prosecution to the acts stated there, and you're now broadening it to make it clear that there could be other acts. I think we've erred in the other direction, because once you start I think particularly at this stage of the deliberations to give those specific examples would be wrong. If the court were to take I understand the court's concern that while we've hopefully met the court's concern that we rule out brandishing by using our paragraph there. The key words, of course, are in itself, or we could use alone to send the message that the brandishing alone isn't enough. But of course, as we agree, those actions accompanied by malice of forethought and death would be enough. If there were general language which said that these kinds of acts, however, can be sufficient if they're accompanied by the following elements, then I think we're in the area of general legal principles. The kind of instruction the court has given, I think, is subject to the argument that's often made about Sears instructions or pinpoint, which is that the defense is attempting to suggest to the jury the nature of the evidence when that's a task that only they can determine. So aside from our general objection to supplemental instruction on murder, we would specifically object to the listing of the hypotheticals, Your Honor. If we're then getting into yet another layer of objection, I don't see how that Mr. Spector forced Ms. Clarkson to put a gun in her mouth has any basis in the evidence, Your Honor. If the prosecution's original theory is that he placed the gun in, it seems like the other examples that you give are pretty close to that. But that is that he has the gun and the gun goes in the mouth. That's pretty close to their original theory. But the notion that he forced her to put the gun in her mouth, I just don't see anything but speculation that could support that, Your Honor.
All right.
I don't mean by saying that to suggest that I think the others are more acceptable. I think the examples are all problematical, and we would object to them on that ground.
Thank you. People?
Your Honor, actually, the way the court has fashioned the instruction as it, with the exception of my first comments, if we're going to get to a pinpoint, I'm going to call it a pinpoint instruction.
It is a form of a pinpoint instruction.
Tailored instruction. I think that's accurate. I think the four scenarios that the court penned, I think, are accurate with regard to what the reasonable juror could glean from the evidence as it's been presented. With regard to Mr. Reardon's last comment concerning forcing the gun in her mouth, first of all, we know that the gun was ultimately discharged in her mouth. We know that there was or at least there is evidence that a reasonable jury could accept that there was a struggle, given the bruising on her wrists, given the fact that one doesn't normally place a gun in one's own mouth. I mean, obviously the defense posture is if she was committing suicide, she would, but that's completely different. If the court is directing the jurors the evidence available to them or the theories available to them to that which can be reasonably gleaned from the evidence, these four absolutely cover it, and we wouldn't have any objection to it.
Are there any others that you, certainly Mr. Reardon has just indicated one that he has an objection to, but I feel it's within the realm of the evidence. Are there any others that you believe apply?
I'm quickly trying to think under the...
Well, don't strain yourself. I mean, and I will, however, Mr. Reardon made a suggestion that I will accept, and that is I will tell the jury I am not suggesting to them that these possibilities exist. They are merely possible explanations that they can draw from the evidence. They're not bound by it, nor are they limited by the language.
Before we get too far down.
Brad, just one sec, and then I'm sorry. I did just want to add one other comment, Your Honor.
Yes.
I'm not going to quarrel with the court's ruling, but I think we just do have to point out that the four scenarios that the court is now, well, when I say suggesting, I mean it's at least informing, telling the jury they can entertain, are discussed in the prosecution's closing argument, and therefore none of it was addressed in the defense argument. And the court tells the jury that, of course, the prosecution's argument is not evidence. I realize the court may now, and we welcome it, add language that it's not suggesting these are supported by the evidence, but nonetheless, with them coming, these possibilities being presented by the court at this stage in the trial, I think that it is, as with the problem with lesser included, it carries a powerful message that the court is suggesting that they reach a verdict along these alternative lines, and on that grounds.
We are about, I would say, 1 hour left. We got 47 minutes left in this video, and then the last video is 11 minutes. We're right at an hour left of this entire trial.
Well, I'm going to specifically put language that I'm not suggesting, that these are mere possibilities that they may consider. So,
Here's
yes.
an additional problem, Your Honor. Your hypothesis number 3, that he pointed a gun to prevent Ms. Clarkson from leaving. Pointing a gun is the significant element. Ascribing a motive to it is simply re-arguing the prosecution's theory, and it implies that the court has put credence into that theory. And I think that that would be improperly argumentative, no matter what the court admonishes them in terms
Water
of
running through me. Welcome in, everybody.
Simply
Thanks for being
saying
here.
that that's a
Appreciate it.
possibility says it's past the threshold of credibility with the court, and I think that that is improper. In addition, it doesn't propose any of the defense's alternative explanations that she was depressed about her job, that she put the gun in her mouth because of her depression, because she was intoxicated, she may have been simply experimenting with the gun. It doesn't posit any of the defense's explanations, which would potentially raise a doubt. So being concerned about our following the court's admonition to eliminate brandishing as a potential theory, this goes to the far alternative extreme, and it simply is re-arguing the prosecution's theories on variations of what Mr. Spector may have done to cause her death, and doesn't say at all what Ms. Clarkson may have done to cause her own death.
The bottom line is this is contained in the instruction defining murder. It doesn't belong there. You have argued reasonable doubt, and reasonable doubt, you've given them a complete alternative suggestion as to these events that mandates that Mr. Spector be acquitted. If they have a reasonable doubt or believe, even if they don't believe, just excuse me, let me finish. If they don't believe necessarily what your witnesses testified to, but it's enough to cause them to have a reasonable doubt, i.e. this might have happened that way, and therefore I have a reasonable doubt if that's what the jurors believe, then they should and must acquit.
Why don't we give them those equivalent scenarios so that they can consider those, so that they have those before them as they have the prosecution scenarios?
Because I don't think there's any instruction that would cover that. There's a way to do it. This is simply defining the theories under which they may convict of murder. I disagree with what you're saying. I don't think it fits in at all. You know, may I add, you've been given the opportunity. You have chosen for tactical reasons not to re-argue the case. I've given everyone, and the opportunity still exists. If you want to re-argue this, and of course reasonable doubt is part of that to the jury, take the opportunity and do so.
But that's taking the dog by the tail and waving him. If that was going to be where we were going to end up, we should have started out heading there. You can't retry the case after it's been submitted to the jury, after we've all completed our theories and done our evidence and made our tactical decision. You can't do it after a week of deliberation and say, well, why don't we try it another way? You know, the problem we have here is caused by the tension between Lee and Stouter-Jennings. The resolution would have been, now that we've figured out that brandishing may be something that they're concerned with, to instruct on lessers. But we can't because of where we are and what the state of the deliberations are.
Well, let me just say, on instructing on lessers, at this point, we still stand with the evidence doesn't show a brandishing. The evidence shows a completed act.
Well, be that as it may, we are in a position that we're trying to artificially create a way out of. I mean, there really is no other viable alternative than to mistry it and do it correctly the next time. we have, through our own efforts, gotten into a point where we can't instruct the way out of it. I mean, it is not a situation where Mr. Spector can fairly have this jury consider a revision, a re-scrambling of the egg, so to speak. I think that it would be appropriate to renew our motion for mistrial and not try to jury rig a solution that's going to come down to his detriment.
Well, first of all, once again, if I thought manslaughter was required as a matter of law, that would be the end of it. We would be there now. I am telling you that, first of all, take Lee out of the picture. I put Lee in, that I took a look at this case. I became concerned when I found it that it might apply to the facts of this case. It's holding to the degree that whether or not it applies to the facts of our case is somewhat ambiguous. I become satisfied after reading Lee that it applies to the facts of those cases because the nature, I was concerned about the nature of the wound. There was a possible brandishing. If you read what went on during the struggle that led to the death of the decedent in the Lee case, I can see why Justice Baxter reached the conclusion that he did. In this particular case, no one has ever suggested, the evidence is not suggested, and if you look at the People's 1101B evidence, which was admitted for a very specific purpose to show that Mr. Spector might have a motive, that he reacts in the same way, and the way he reacts based on the testimony, if the jurors find it to be credible, that's up to them, is each time he was placed in a similar situation, he actually placed a weapon to someone's head. That goes far beyond brandishing. That is the completed act. That is what the people are attempting to show happened in this case. There are also some alternatives to that which fall within those parameters which this instruction that I've drafted attempts to answer. If I believe that manslaughter had to be given, we would be done. There's nothing, your motion would have been granted. You know, the parties have consistently told me manslaughter doesn't apply.
Let me say, Your Honor, that when we reiterate the position that you correctly instruct the jury that there was no evidence to support manslaughter in this case, the prosecution's theory was that Mr. Spector committed an act that certainly was one consistent with the implied malice, and the defense position was simply that he never committed that act. So I continue to believe that you correctly instructed the jury in the original instructions you gave him, Your Honor.
All right, thank you. All right, with that in mind, I'm going to go back to chambers, redraft this instruction. I just want to make sure that we're on the same page with regards to, we're going to give special instruction number 4 as edited, and as regarding the jury's questions, does somebody have them there, or do you want, I need to get them out of chambers. Does anybody have a copy?
The jurors, you know what?
Yeah.
Let me just give you my copy.
Okay.
Alternative number 4 that the court...
I think this thing is cursed.
Gave?
Yes.
Can you read that again? I wanted to make sure.
Sure.
We understood
It
that.
was, or forcing her to place the gun in her mouth and it discharged. And that is within the possibility of the evidence.
So that implies that, well, when you say that, what evidence supports that?
It's simply a reasonable inference that whether, we don't know how the gun got in her mouth.
Who's holding it, her, him?
Doesn't make any difference.
So either one?
Yes.
Okay.
Okay? All right. We'll be going over the jurors' questions, whether the instruction should be taken by itself instead of taking all the instructions as a whole. I believe that will be answered by the more instruction, which is we're calling special instruction number 4.
Judge, we do need to address when you get to it, the special instruction 6, that the government has added some language to it, which I want to comment on.
Special instruction. Yes?
Let me give you,
I haven't seen it.
I'll give it to you right now. I'll also give you the edited version. We finished the editing on special 4 as well. Yeah, I do. These are both the court's copies with the history on top.
Yes, what, Mr. Rosen, you wanted to address something?
Yes, if I could for a moment. Special Instruction 6, which we've already chatted about. The prosecution indicated earlier this morning that they were going to add some language, but it looks like in their final draft they've added more than what we talked about. I don't have a problem with the first sentence starting with "in your deliberations." The problem I have is treat it as if you never heard of it. It adds too much emphasis to it, and you are withdrawing it, and you adequately state that in paragraphs 1, 2, and now the paragraph 3, but it should only be the one sentence. So we are asking that the court delete "treat it as if you never heard of it," that language.
I thought we had an agreement that we were going to give the instruction as drafted by the defense with one additional sentence.
Judge, the last sentence that I read to you in chambers is the following. In your deliberations from this point forward, do not consider the now withdrawn special instruction 3. Treat it as if you had never heard of it. That's exactly what I read to you.
As a matter of fact, we did discuss that,
And
Mr.
that's
Rosen.
exactly what I wrote. I didn't add one
That
word
was to tell them to completely disregard it.
Right. I didn't add anything or subtract anything.
That's specifically, now that Mr. Jackson reminds me, that's specifically what we had agreed upon when we left chambers.
I don't know that we agreed upon it. My impression was that they were going to draft it, add the language to it, and then we were going to take a look at it. And when I see it here in print, it is just those last few words that I think does overemphasize it too much. I mean, you are taking it out. It's being withdrawn. You look at the third paragraph, which should be the one sentence without the quote, unquote, treated as if you never heard of it, in conjunction with paragraphs 1 and paragraphs 2. I mean, it's about as clear and as strong as you can be. I think this just adds too much emphasis to it.
Okay, the objection is overruled. Okay. Okay, and we have special instruction 4. I just want to go over the, question number 1 is answered by special instruction 4. I want to make sure it is.
The ones with the hash marks through it, I think, are the ones that the court indicated we didn't need to address.
No, but I'm addressing number 1, and the question is whether the instruction be taken by itself. They were talking about number 3. It's no longer applicable, that's right, because 3 was actually out.
That's right.
It's out because it has been withdrawn. Question number 2, which dealt with instruction 3, is out. Question number 3 perhaps dealt with number 3. It's whether determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction.
I think your comment was at that time you were going to handle that in conjunction with number 1.
Okay. What I'm looking at there, because in the opening instruction, it tells them how to consider that, but I don't believe the more instruction addresses it. In the opening instruction, Calcrim 200, it is pay careful attention to all of these instructions and consider them together. Excuse me, that's not what I... Right. Pay careful attention to all of these instructions and consider them together. It tells them how to do it. You consider them, and I will simply reread that to them from Calcrim 200.
I think in the paper that you have in front of you, Judge, I indicated, or it should be, when it says Calcrim 200, it should say paragraph 2 and 6 or whatever. It should direct the court right to where it needs to go.
Question number 4.
Thank you.
We indicated, I think, we're not going to respond.
We're not going to respond to it because it basically tells them to consider everything in total. Question number 5, I want to reply that they cannot see the clothing because it's no longer in, number 1, it's not in evidence, and number 2,
it's not in the condition.
It's not in the condition it was, okay? Concepts of number 6, questions of reasonable doubt. I'll reread the reasonable doubt instruction. You have asked that I not respond to number 7, that it's appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable. Is that still the position, as opposed to saying that's basically, if one finds it to be unreasonable, that's their decision?
No, my position was it was covered in the more, if I didn't write it down there, our position is it's covered in the more instruction that each juror is, wherever that language is about each juror's independent.
Well, they're entitled to the individual judgment of each
There you
juror.
go.
Okay.
Yeah, I
Are you
think that covers
satisfied that? Yeah.
But I think the court's comment is apt, that a juror who holds an opinion that the juror feels is reasonable is entitled to hold it.
And that's the problem. They have to be told that. They're asking, and just because one has a differing view, that doesn't mean that they're unreasonable.
Absolutely.
Well,
I have no problem with you explaining that.
They have to be told that.
Sure,
Okay,
sure,
I'll
sure.
respond directly to it. And
You decided on A to omit.
I'm sorry.
Question 8, because it relates back to Special 3, which we've taken out, and it
All right.
falls in the same category as number 2.
It's going to take me about 5 minutes to rewrite the instruction, and I will read it to you before I give it to the jury, and we will proceed.
Would it be possible to maybe have copies while you're reading it so we'd have it in front of us?
You know what?
After you
I'm basically, at this point, going to handwrite it out.
Oh,
I'm going to read it to you, then we'll reduce it to a typed copy. I'm not sending it into the jury room at this time. I want the jury to...
Yeah, just as long as we have an opportunity to read.
Okay.
Your Honor, one question. The court did indicate that it would give the language prohibiting dealing with brandishing and why it is
Yes.
not a sufficient basis for the 187 conviction.
Yes, I am, and I'm also going to incorporate your language that these are merely possibilities, and I'm not suggesting anything, and the jury is free to accept them or reject them. All right, thank you. We'll be in recess for about 5 minutes. Set as, yes.
Does the, you want me to have somebody?
At some point.
And type that up for you?
No, I'm going to do it. I want to do this.
Welcome
yeah.
to the very end of the
But I'm gonna do it at a
trial.
later time.
I was reading something.
All right. The defendant's present with his counsel. The district attorneys are present. The jurors and the alternates are not present. I would propose and intend to read 520 modified as follows. The defendant is charged in count 1 with murder. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act with the firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time it discharged, pointing the gun at or against her head, at which time it entered her mouth and discharged, pointing the gun at her to prevent her from leaving his house, causing a struggle which resulted in the gun entering her mouth and discharging. By using these examples, I am not suggesting that any of these acts took place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. These are only possibilities that you may consider. The act committed by the defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And 2, and then go on with the rest of the 520 instruction.
Could we ask you to read those?
Sure.
Would you mind reading it a little more?
Absolutely.
Yeah, a little slower, please.
Okay. The defendant is charged in count 1 with murder. To prove the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act
Glad you stopped by,
with
guy.
a firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time
Don't choke
it
on water.
discharged, semicolon,
Going down
pointing
the
the
wrong
gun
hole.
at
Oh,
or
God.
against her head, at which time it entered her mouth and discharged, semicolon, pointing the gun at her to prevent her from leaving his house, causing a struggle which resulted in the gun entering her mouth and discharging. By using these examples,
Not helping
I
Bassett
am
with
not
my,
suggesting that any of these acts
my odds
took
here.
place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. They are only possibilities that you may consider. The act committed by the defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And then going on with the rest of 520.
May I be heard, Your Honor?
Absolutely.
Your Honor, we've argued other aspects of this. The court is going to give examples. We understand that. We've preserved our objections to them generally. But I have to make a specific objection to one clause of this that stands on a completely different level than any objection we've made to instructions thus far. And that is the phrase, or forcing her to place the gun in her mouth, end quote. That phrase simply must be deleted for these reasons. Quite broadly, there is probably not a single defense witness or a single prosecution witness who would have been called to testify in the way they had, who would have been offered by one side or the other to testify about the things that they did, if the prosecution ever had suggested at any point in this proceeding that Mr. Spector was guilty if Lana Clarkson was holding the gun in her own mouth. Would the defense have called expert after expert to say that 99% of interoral wounds are self-inflicted if it knew that the jury would consider a theory that the wound was self-inflicted while she was holding the gun in her mouth? Would the defense have called experts to say that the gun, the blood spatter on the gun, would have had a void on it if Mr. Spector was having it, but it didn't have that void? It was consistent with Ms. Clarkson having it, if it knew that the evidence that she was holding the gun would be offered to the jury, to a deadlock jury, for the first time as proof not of innocence, but of guilt. We are talking about a situation in which every piece of evidence the defense offered in this case was offered to prove that Lana Clarkson and not Mr. Spector was holding this gun. The prosecution argued the case on the theory it was Mr. Spector. They said they would prove beyond a reasonable doubt that Mr. Spector was holding this gun, and you're now offering them a theory under which they convict by finding it proved beyond a reasonable doubt that Ms. Clarkson was holding the gun. Would Mr. Spector have testified if he knew that all of his experts, all of his witnesses that pointed to Ms. Clarkson holding the gun were in fact incriminatory witnesses, and the only way he could defend himself was by testifying that he did not force her to take the gun? Would the court have admitted any of the 1101B evidence if the theory was that, in fact, Ms. Clarkson was forced to take the gun and put it in her mouth when there wasn't a single 1101B witness who testified that Mr. Spector ever gave them the gun or forced them to do anything with the gun? The identity of detail between the uncharged defense evidence and the prosecution's theory would have been completely absent. This court excluded evidence that Ms. Clarkson sometimes willingly put guns in her mouth. It ruled it irrelevant. If the theory was that she was forced to put the gun in her mouth, then the court might well have to have ruled that that evidence was relevant. Your Honor, you cannot have a trial in which, after a jury is deadlocked, they are offered a theory under which every single piece of defense evidence becomes incriminatory. It's a violation of due process notice. Your Honor, respectfully, I must say to you, you must excise that language from your examples. Any language which would suggest that this jury could convict on a theory that Ms. Clarkson was holding the gun. If the people want to propound that theory, Your Honor, we need a new trial. It is the fundamental principle of American law that you are told before the trial begins what you must defend against, and we're in a position where this jury would now be able to convict Mr. Spector precisely because he effectively rebutted each piece of the prosecution evidence. I must ask the court to strike that phrase.
Well, thank you. I'll hear from the people, but once again, you're entitled to notice of the charge, the crime itself, not the theories. That is an incorrect statement of law. I'll hear from the people.
Your Honor, The last statement that the court included in its instruction, Mr. Brunon argued the exact same points that Mr. Reardon is now arguing, just at a higher decibel level. It's a reasonable inference drawn from all the facts, and it's a reasonable inference that one or more jurors could draw from the facts that have been presented. They're entitled under this instruction, since we are tailoring this instruction to what the reasonable inferences are that they can draw, and we're giving the defense the benefit and the legal benefit, I suppose, of taking away any possibility that they could convict based on a brandishing or some form thereof. The court has tailored and defined what the reasonable inferences are that they could draw from the evidence, and that's one of them. It's perfectly appropriate.
Could the court ask the people or reiterate itself what shred of evidence
you didn't miss the end. We're right there,
was
though.
offered in this trial that
Got
Mr.
about
Spector ever forced,
30 minutes or so
asked,
left of this trial?
persuaded, in any way caused another person to put a gun in the mouth. There's a complete absence of any evidence in support of that. I mean, there's not a shred of evidence to that. The only evidence that would support that is the fact that the gun was in her mouth. And if you're looking for any argument that would make him guilty, then he must have forced her, but that is speculative. And Mr. Reardon didn't articulate what the excluded evidence was, but the court excluded evidence from Ms. Gibson that would have specifically stated that Ms. Clarkson frequently, voluntarily put items into her mouth in a titillating way or a suggestive way or a joking way that would certainly cut against any argument that she was forced to put such an item into her mouth. I mean, this not only is it unsupported by evidence, it would have been refuted by available evidence that the court excluded.
Well, I disagree with that theory, and I'll give you what to me is a perfectly valid, rational inference to draw in a minute, but I'll hear from the people.
Your Honor, with regard to Mr. Brunon's comments, what evidence is there that he may have forced Ms. Clarkson to do anything? There is a plethora of evidence that Mr. Spector, when confronted with this type of emotional stimuli from other 5 other 1101B witnesses, forced struggles with some of those or all of those women. He forced some of them upstairs. He forced some of them to take clothes off. He forced some of them into a chair. He forced some of them to stay in a hotel room. He forced some of them back into the house. That is force, and that's force used with a gun. Given the circumstances and the inferences that can be drawn about what happened inside the foyer, this is not something that's unreasonable. It's perfectly reasonable that he could have forced Ms. Clarkson to do any number of things, including put the gun in her mouth.
Your Honor, that's only half the picture. If you look at the cross-examination of the 1101Bs, each and every single one of them, all 5 of them, from Dorothy Melvin to the very last one, Deborah Robitaille, were asked questions by myself whether or not Mr. Spector ever forced them to touch the gun, whether Mr. Spector ever asked them to hold the gun, whether or not Mr. Spector ever asked them to place the gun against their head in any way, and most specifically, whether or not Mr. Spector at any time forced the gun in their mouth or asked them to put the gun in their mouth. Each and every one of those 5 1101B witnesses said no to all those questions.
Stretching again.
Uncontroverted.
Body's
It's a
hating on me
matter,
today.
the question is whether it's a reasonable inference that can be drawn from the results shown, and that's all that it is. The objection is overruled. Thank you. Anything further?
No, Your Honor.
Let's bring out the jurors and the alternates.
I just have
Yes.
one. I'm not a California lawyer, but there was one indication that brandishing under the California law, and you'll correct me if I'm wrong, hopefully I've learned a little bit, is that rude, angry, or threatening manner, or if done in a fight or quarrel.
But that's not, the fight or quarrel is not what was shown in this case. That's another alternative.
Well, there is an indication of a struggle. I mean, so a struggle, if you're going to draw inferences, could be a result of some type of quarrel they were having.
If you look at the case law, I don't believe, and believe me, I did look at that is not applicable under the theory it's being used. I will be happy to quickly relook at it.
And I believe only to see if I've learned anything in California law.
No, that is a different paragraph within the brandishing. Let me find the use note here. third paragraph of the bench note to 983, if the prosecution alleges that the defendant used the weapon in a fight, give alternative 2B. I don't believe that's what it is designed to be instructed on. If two people are fighting, you pull a gun. I don't think this is the facts of this case do not support that. One couple, Mr. Brennan.
The prosecution just argued that there was a struggle, and that's how she got the bruises on her arm.
I understand that, but it's not the kind of a fight that we are talking about here, one that clearly would not have been initiated or a mutual quarrel situation. If you look at the facts, if you have a case, Mr. Brennan, by all means.
It's not about cases, Judge. All of the interpretations...
Mr. Brennan, easy.
All of the interpretations the courts is drawing are going in one direction. This is another interpretation that there was some quarrel. I mean, as long as we're speculating as to what may have happened, there may have been some quarrel.
I understand this clearly, and I'm not a legal expert at all.
As long as we're speculating,
I understand exactly what Phil
than
Judge Dahart is saying.
Forcing the gun into her mouth, or forcing her to place the gun in her mouth.
What the people like to do.
Fiddler is saying. Good God.
Your Honor, it's not applicable. The entire reason that the court is trying to define this in terms of 520 is, I believe, to make sure that the jurors don't get misguided or misled, that they can use the exhibition of the firearm or the drawing or the exhibition of the firearm in any way, as opposed to the actual conduct that the court has laid out. I think it does exactly that with the way the court has already drafted the instruction.
Okay. While you call the jurors and the alternates, I'm going to go back and look at a couple cases and see if my theory is correct or if you are correct. If you are correct, I will add the language. If I don't give it, then you know that I don't agree with you. Okay? All right. Let's bring the jurors and the alternates.
Court's being in session.
All right. Back
Jury is back.
The jurors and the alternates are now present, or the other parties are present. Ladies and gentlemen, I'm now going to attempt to answer the questions that you had the other day. I'm going to be reading some additional instructions to you, deleting an instruction, and hopefully that we'll be able to cover all the areas that you had concerns with. The question of whether the instruction should be one instruction, I think it was actually you were concerned with special number 3, and I'm going to instruct you on special number 3 in a second, but I just want to and I think this will also apply to another question that you had. I'm going to reread to you just from the very first instruction that I gave you, Calcrim 200. Pay careful attention to all of these instructions and consider them together. Okay, that's the first thing that I will instruct you, which would answer question number 1. Your second question concerns special instruction 3, and I'm going to get to that in just a moment. Your third question was whether in determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction. And again, I will instruct you from Calcrim 200 that you are to pay careful attention to all of the instructions and consider them together. Okay? I think that will answer your fourth question, which had to do with totality. Question number 5, whether you can view the clothing articles on a mannequin. The answer to that is no, for 2 reasons. Number 1, the clothing is no longer in the condition that it was when the relevant matters took place. And number 2, the clothing is not in evidence, and you may not view items that are not in evidence. The pictures are in evidence. There have been explanations given, and you are bound by that, so you will not be given the clothing that was not introduced into evidence to view. Question number 6, the jurors are having problems with the concept of reasonable doubt, and I'm going to reread to you the reasonable doubt instruction.
One last ghoul. That actually looks like the same. That lower third down there looks like the actual same suit and wig, if I'm not mistaken, that he's rocking there. Thanks everyone that's come through randomly during this trial. All the people that have done it weekly with me. My God, you were fucking absolute publicly buzzed G's. And again, we start our next season, season 6, Charlie Adelson's 2023 trial, the same day his mother's jury selection starts, Tuesday night at 8 Eastern. You do not want to miss that. The opening.
They moved we changed this.
The opening show is a must-watch. Before we get to opening statements, I've got together some graphs that we're going to look at, and more like some graphics that we're going to look at and kind of get everyone up to speed on exactly how not only are we at Charlie's trial, but also at Donna's trial.
Instructions from what was then known as CalJur to CalCrim, they moved the reasonable doubt instruction. I used to know right where to look for it. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. He must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt unless I specifically tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves that...
Jersey Gin, starting out a new wheel. We had a spin earlier today. Thank you, Jersey Gin. I appreciate that. Always coming through, always super supportive, being amazing. And I appreciate that. Starting us out on a brand new wheel. Thank you, Jan.
Defendant guilty beyond a reasonable doubt. He is entitled to an acquittal, and you must find him not guilty. The next question you asked was whether it is appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable. In such a case, would that situation make the juror unreasonable? The answer is no. If one juror finds the evidence and concludes that there is a reasonable doubt based on that evidence, that does not mean that juror is being unreasonable because others disagree with him or her. Each juror decides for themselves whether there is a reasonable doubt on any element or any other aspect where that is what you are applying. It applies to each juror individually. Of course, you talk to each other and you come to, you discuss matters and you may decide whether or not a doubt is reasonable or possible or whatever, but the fact that one juror differs from the other, that does not make that juror unreasonable. Okay? The next question dealt with...
Dinah coming through. What up, loves? Welcome in here, Dinah. And also, absolute G around these parts. Always coming through, showing some love, and I appreciate that. $2. Thank you so much. Getting you on that wheel. And she's won a lot on here. She's a very lucky girl.
Instruction number 3, I'm about to give you a special instruction on that. And that is... as follows. This is now special instruction number 6. During our discussion yesterday, one or more of you sought clarification of an elaboration on the meaning of special instruction number 3. Upon reflection, I have decided that the other instructions I have given you adequately state the principles of law you are to apply in deciding this case. Rather than attempt to further explain special instruction number 3, I am withdrawing it. You therefore are to rely on the remaining instructions in your deliberations from this point forward. In withdrawing special instruction number 3 from your consideration, I do not intend to comment in any way on the correctness of the individual or collective opinions expressed by you in your deliberations to this point, nor do I intend to suggest anything about what opinions each of you should express or positions you should take in any further deliberations. In your deliberations from this point forward, do not consider the now withdrawn special instruction number 3. Treat it as though you had never heard of it. I am also now going to read you, we're going to modify and have modified CalCrim 520, which is the instruction on murder.
Yeah, it's
And I
those
ask that you
pigs.
listen to it because the language is now different.
Yeah, all that first stuff that I said, jury, well, it's changed.
I mean, at some point, we will get you at least one corrected copy of the instructions. I don't know that I'm going to make individual ones available to you, but we will get these corrected copies of the instructions I am now reading to you into you. But you certainly, when I'm done, and I will have one further instruction to read after this, you may go ahead and begin your deliberations. The defendant is charged in count 1 with murder. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act with a firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time it discharged, pointing the gun at or against her head, at which time it entered her mouth and discharged, pointing the gun at her to prevent her from leaving the house, causing a struggle, which resulted in the gun entering her mouth and discharging. By using these examples, I am not suggesting that any of these acts took place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. These are only possibilities that you may consider. The act committed by the defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And 2, when the defendant acted, he had a state of mind called malice aforethought. There are 2 kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant acted with express malice if he unlawfully intended to kill. The defendant acted with implied malice if 1, he intentionally committed an act, 2, the natural consequences of the act were dangerous to human life, 3, at the time he acted, he knew his act was dangerous to human life, and 4, he deliberately acted with conscious disregard for human life. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes death is committed. It does not require deliberation or the passage of any particular period of time. If you find the defendant guilty of murder, as a matter of law, it is murder of the 2nd degree. Finally, I am going to give you special instruction number 4, and this has to do with how you should now consider your deliberations. What I am now going to do right now, ladies and gentlemen, is have further instructions and directions to give you as to count 1. To assist you in your further deliberations, I am going to further instruct you as follows. Your goal as jurors should be to reach a fair and impartial verdict, if you are able to do so, based solely on the evidence presented and without regard for the consequences of your verdict. It is your duty as jurors to carefully consider, weigh, and evaluate all of the evidence presented at the trial, to discuss your views regarding the evidence, and listen to and consider the views of your fellow jurors. In the course of your further deliberations, you should not hesitate to re-examine your own views or to request your fellow jurors to re-examine theirs. You should not hesitate to change a view you once held if you are convinced it is wrong, or to suggest other jurors change their views if you are convinced they are wrong. Fair and effective jury deliberations require a frank and forthright exchange of views. As I previously instructed you, each of you must decide the case for yourself and should do so only after a full and complete consideration of all the evidence with your fellow jurors. It is your duty as jurors to deliberate with the goal of arriving at a verdict on the charge, if you can do so, without violence to your individual judgment. Both the people and the defendant are entitled to the individual judgment of each juror. As I previously instructed you, you have absolute discretion to conduct your deliberations in any way you deem appropriate. You may wish to consider changing the methods you have been following, at least temporarily, and try new methods. For example, you may wish to consider having different jurors lead the discussions for a period of time, or you may wish to experiment with reverse role-playing by having those on one side of an issue present and argue the other side's position and vice versa. This might enable you to better understand the other's position. By suggesting you should consider changes in your methods of deliberations, I want to stress I am not dictating or instructing you how to conduct your deliberations. I merely find you may find it productive to do whatever is necessary to ensure each juror has a full and fair opportunity to express his or her views and consider and understand the views of the other jurors. I also suggest you reread CalCrim Instructions 200.
Boom! Donna getting back in there. Welcome to Buzzed and Confused, Donna. Also getting another spot on the wheel. Thank you very much. Appreciate that.
And CalCrim Instruction 3550. The integrity of a trial requires that jurors at all times during their deliberations conduct themselves as required by the instructions. CalCrim Instruction 200 defines the duties of a juror. The decision the jury renders must be based on the facts and the law. You must determine what facts have been proved from the evidence received in the trial and not from any other source. A fact is something proved by the evidence or by stipulation. Second, you must apply the law I state to you to the facts as you determine them, and in this way arrive at your verdict. You must accept and follow the law as I stated to you, regardless of whether you agree with the law. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. CalCrim 3550 defines the jury's duty to deliberate. The decisions you make in this case must be based on the evidence received in the trial and the instructions given by the court. These are matters this instruction requires you to discuss for the purpose of reaching a verdict. CalCrim 3550 is also an instruction which recommends how jurors should approach their task. You should keep in mind the recommendations this instruction suggests when considering the additional instructions, comments, and suggestions I have made in the instructions now presented
Maybe
to you.
Grog's in the chat before that one
I hope my comments and
disappears.
suggestions may have some assistance to you. You're ordered to continue your deliberations at this time. If you have other questions, concerns, requests, or any communications you desire to report to me, please put those in writing on the form that my bailiff has provided you with. Have them signed and dated by your foreperson, and then please notify the bailiff. You may resume your deliberations at this time, and we will take the alternates back to their waiting area. 520, and if you'll take it and integrate it into 520.
We'll be happy to, Judge, and we'll also, I guess that's the only one that we have to.
It's the only one that needs
Judge,
to be
if
done.
I could ask the court to ask Wendy maybe, I know all the jurors have the old version of 520, and they also have Special Instruction 3 in the deliberation room. I would ask that those be removed post-haste.
Oh, that's right, to take from their copies. Well, we've certainly told them to disregard it, but we will at some point attempt to collect them.
Thanks, Judge.
Okay? I think the direction certainly is to how they're to proceed.
Certainly.
They understand it. Anything else? Okay, thank you.
Thank you, Judge.
Yes.
One minor thing, if there's a note, is it possible, because we're going to go back to the hotel and all that, we could possibly know like what it is, maybe to delay the court not getting time consumed, that we could all talk before we get here so the defense team has some indication of how to respond. I know
Sure.
the other day, we didn't know until we got here, and I know we delayed the court by having to take our own meeting and stuff.
Well, the bottom line, you really didn't delay anything because you would have had to be here. It doesn't mean that you delay it by having a meeting. I mean, if you're driving over from the car, which is 5.
Boom! Miss Wildside giving a $5 holla. Thank you so much, Wildside. I appreciate the hell out of that. As we're winding down here, baby. We're so close.
5 minutes along, that's fine.
We got about
But it needs to get
11
here as
minutes
soon
left
as
in this
possible
trial.
because there's an issue. And usually I will tell you what the issue is.
So close.
I deemed that
We're
I
so
wanted the
close,
parties
guys.
present before I discussed it with them, and I didn't even want to discuss it on the phone.
They had to think of Mr. Reardon to get on the phone, and we'd like to talk
I understand.
before we get here.
And I will
Thank
try
you,
to
sir.
accommodate you if I can.
Appreciate it.
Okay?
Jury's decision. It doesn't even want to switch over to the last video. I have to go actually. It's asking, am I still here? Do you want to continue? Yes, of course I want to continue. It's the end. What the fuck? Get in there. I'm doing some Netflix. Oh my God. Here we go. Last 9 minutes of the trial, ladies and gentlemen. Thanks to everyone who has been here. Oh my God. I don't even know what to say. Holy cow.
Now in session.
Season 5 of Murder Church has been 16 months long.
The defendant's present with his counsel. The district attorneys are present. The jurors and the alternates are present. Juror number 10, I understand you have sent me a communication indicating that the jury is unable to reach a unanimous verdict.
Yes.
Is it your belief that there's anything that I can do further that has not yet been done to assist the jurors in any way?
No.
Without again indicating which way the jury is leaning, could you give me two numbers, please?
10 and 2.
10 to 2. How many ballots have you taken?
Total or just as?
Total.
6.
6. All right, I want to poll the jurors individually to see if any of you or all of you agree with juror number 10's conclusion. Juror number 1, do you think there's anything more that can be done that would assist you or any other juror in arriving at a verdict in this case?
No.
Juror number 2?
No, Your Honor.
Juror number 3?
No, sir.
Juror number 4?
Yes, sir.
Juror number 5?
No, Your Honor.
Juror number 6?
No, Your Honor.
Juror number 7?
No, Your Honor.
Juror number 8?
No.
Juror number 9?
No, Your Honor.
Juror number 10?
No, sir.
Juror number 11?
No, Your Honor.
Juror number 12?
No, sir.
Does anybody wish to be heard? Okay.
No.
At this time, I will find that the jury is unable to arrive at a verdict and declare a mistrial in this matter. The jury is discharged. Before I discharge you, there is a final instruction I need to read you, which is read in every case. This is the concluding instruction after the jurors have completed their service. You have now completed your jury service in this case. On behalf of all the judges of the court, please accept my thanks for your time and effort. Now that the case is over, you may choose whether or not to discuss the case and your deliberations with anyone. I remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Let me tell you about some of the rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant, or their representatives may now talk to you about the case, including your deliberations. Those discussions must occur at a reasonable time and place and with your consent. Please immediately report to the court any unreasonable contact made without your consent by the lawyers in this case, their representatives, or the defendant. A lawyer, representative, or defendant who violates these rules violates a court order and may be fined. I order that the court's record of personal juror identifying information, including names, addresses, and telephone numbers, be sealed until further order of this court. In the future, if the court is asked to decide whether this information will be released, notice will be sent to any juror whose information is involved. You may oppose the release of this information and ask that any hearing on the release be closed to the public. The court will decide whether and under what conditions any information may be disclosed. What I'm going to ask you to do at this time, there are further things that we need to do. The jury commissioner needs to meet with you. The public information officer of the court is going to meet with you, and I'm just going to thank you personally. The jury room is too small to do that, as is my chambers. I'm going to ask that you all step into the jury room, including the alternates. I'll call you out again in just a few moments. So if you'll all step into the jury room at this time.
Your Honor, it sounded as if you said that the jurors cannot talk to the...
No, they may. If that's what it sounded like, it was wrong.
Okay.
No.
You said not.
You said no.
You may choose to discuss or not discuss the case
Judge
with
Dowhard.
anyone.
Passing page, $2. It's over. On to the next season. Season 6
I'm sorry if
starts
I misspoke, and
Tuesday
it's possible, and I
night.
certainly do apologize for that. Would you
8
all, including the
Eastern.
alternates,
Charlie
go ahead and step
Adelson.
into the jury room at this time? We'll buzz you out shortly. Just go ahead and step in the jury room.
Appreciate that. Halfway to a new
All right,
will.
the jurors and the alternates have left the courtroom. Have the people come to any conclusion as to how they wish to proceed with this matter?
Well, we think it should be set for a hearing in the near future that's acceptable to all parties. As the court knows, my office has a hierarchy that I have to speak with before I can conclusively tell the court what our plans are.
Okay.
I have a recommendation that I would make to the court. This is a suggestion. Maybe I could confer with Mr. Jackson, Mr. Dixon for a moment. We could pick a date, maybe 60 days out, set it for whatever you prefer, either a status conference or a pretrial at that time. It would give both sides an opportunity to reconnoiter and regroup and figure out where we are on this. Seems to make sense to me.
I think 60 days is that's way too long. I'm thinking perhaps a week or 10 days sometime within the next 2 weeks.
Well, may we approach for a moment on that?
That's some defense stuff right there. Stretch it out as long as humanly possible. This defense team.
With that clarification, I think that we can advance my suggestion to a date next week.
I would suggest Wednesday, October 3rd.
I just need to let Mr. Brunon check
Oh,
with his calendar
Lord.
and see how he's doing on that date. You're suggesting Wednesday the 3rd? That's fine with me.
Is the second...
The second is fine.
Second's not good.
Imagine being the alternate.
All right. I don't want to go beyond that. I may not be here at the end of the week, so.
I'll make the 3rd.
All right. At 10 o'clock, would that?
That's fine.
All right. The 3rd at 10 o'clock for further proceedings to set dates as necessary, whether that becomes necessary to discuss calendaring, if that becomes necessary.
If it's acceptable with the court, since it's going to be a lot of housekeeping matters, I'd like to waive Mr. Spector's.
He doesn't have to be present.
Thank you.
Now, let me explain what we're going to be doing. Because of the size of the jury, I'm going to meet briefly with the jury just to thank them. They need to meet with the court information officer. They need to meet with the jury commissioner. These are not public proceedings. These are matters. The public proceedings are basically terminated at this point, but I want to be able to use the courtroom because of the size and the number of people that will be present. I'm going to clear the courtroom. We will talk to the jurors, tell them, as I have already instructed them, they can talk to anyone. If any of them wish to speak to the media, I believe some arrangements have been made. If not, we're going to tell you that. I believe, I'm going to ask the lawyers, though, I'm going to clear you out of the courtroom, but I'm going to ask that you remain close because the jurors may wish to speak with you, and I want to be able to bring you back in. So with that in mind, that concludes the public proceedings in this matter.
You want us just to wait in the hallway?
Yeah, in the hallway, if you would. Oh, by the way, the orders as to parties and witnesses remain. There is to be the same as it was during the trial until we see where we're going. So all previous orders are in full force and effect.
Let me just have one quick moment before you take.
All right, thank you. Thank you. Yes.
In light of the court's ruling just now...
Quiet, please.
Mr. Taylor, this concerns you, I wanted to say. Because we're under a continuing gag order and a no dissemination order, could the court either deny the proposed order that's pending or at least hold it under submission until we need to take further action? At this point, there's no necessity to enter the order as requested, and as the court knows, I think there's serious jurisdictional issues and serious scope issues involving some of the items that the court didn't assist us in obtaining, particularly. I'm talking about the order submitted by Mr. Taylor, if I haven't been clear. Given the fact that the court has ordered us not to discuss the matter nor to disseminate any information to the media, I think that the proposed order is unnecessary at this point.
Well, what I'm going to do is sign the order, but it is subject to modification, and it does mean that you're precluded from raising any issue or bringing it back to the court's attention whenever it's necessary.
All right, just one point of clarification. We have, up until this point, shared information with civil counsel representing Mr. Spector. I assume they're exempted from the scope of that order.
Let me hear what Mr. Taylor's position is. But you know what, we can, right now, consider it a signed order, and then I said it's subject to modification anytime I really want to get to the jurors, and this could turn into a lengthy argument. You can bring it back to my attention anytime you want. There's nothing that's going to happen in the next 4 days that's going to make a difference, okay? That's over the next few days. So I'll sign the order. The order is, consider it an order subject to modification at any time. All right, I'm going to ask that the courtroom be cleared at this time, please. Thank you, ladies and gentlemen.
Dudes. Holy cow. Last 10 seconds right here. Let me go pat him on the back. Wow. And that is it. We have made it to the end of the Phil Spector trial. Holy cow. That was 16 months that we've all been through. You know, a lot of us have been here for the entire time. A lot of us, some people still start this trial and leave comments and then find us after the fact. Holy cow. I can't thank everyone enough for being fucking amazing, for being awesome, and for coming through. And, yeah, I mean, this has honestly been quite the experience. You know, I will probably never pick a trial this long again, just to be quite honest. This was originally voted upon, put into the stack of votes specifically because of Karen Reed's first trial. Imagine that. We went through 2 Karen Reed trials as well. 16 months altogether to get through the first trial, which did end in a mistrial, and those poor jurors. But in the second trial, which happened 2 years later, he was found guilty of second-degree murder, and he died in prison in 2021 due to COVID complications. So everyone that stuck through, I appreciate the hell out of it. It has been an absolute crazy ride. Again, I wanted to go deep today because I wanted to get this finished and done before Tuesday. I know. It almost doesn't even feel real. It almost doesn't even feel real. So yeah. Tuesday, guys, please come back through. Tuesday night will be a normal show, which will be Murder Church. And we'll have the book club on there as well. For the members that do participate in the book club, we currently read The Stranger Beside Me. We're getting close to ending that as well, to get into a second book in the book club. We read 2 chapters every week, and we're getting ready to go into chapters 32 and 33. But other than that, a Tuesday night at 8, you're going to want to see you're going to want to see the beginning of the new season 6, the Charlie Adelson trial, because Donna Adelson, the mother, the jury selection, the trial starts that day, for all intents and purposes. And I can't do Donna's trial because I work a day job. So I want to do something cool. And the next season is going to be Charlie Adelson's 2023 trial. And I know a lot of people watch that with Jay, including me, off and on. Again, I don't know every single bit of the details from said trial, but I do know a lot about these cases, and I put together kind of a primer to open up Tuesday with, to show exactly how we got to not only Charlie's trial, but even Donna's now. I think it'll be good for that as well. So please come through for season 6. I can't believe we've done that. That's crazy to even say. But my God, guys, we have done it. The best. 19 months right here with Gamby's. Only 3 months longer than this trial. That's right. You came in right at the beginning when we started this thing. Oh, man, yeah. All the people, I really appreciate it. We've cried. We've laughed. Yeah. Oh, Lord. Today, coming up on a 6-hour stream here again. This is my longest ever true crime stream. I kind of misspoke when I said that in the chat, because I have had some all-night movie marathons where I've went pretty deep. But, which, I mean, I guess my longest one there would have been 11 hours. But for a trial, today has been a lot of work. We put in some time, and I really appreciate everyone for coming in and holding out with me. Yeah, I do plan on watching the movie, Bassett, that was made about Phil Spector still. You know, I don't have a date on anything yet, but just keep an eye on everything. And, yeah. Wow. Nick Starro just sent in a bunch of viewers. Hell yeah, Nick. Appreciate that, dude. Well, I'm at the very end of Murder Church. Thank you, dude. I appreciate that. We just finished freaking season 5 of Murder Church. Unbelievable. And again, starting Tuesday, 8 Eastern. Please come back through. And check out Charlie Adelson's 2023 trial. I would appreciate the hell out of it, guys. Again, I can't even believe that we're actually here. It feels crazy. It feels insane. Any new folks popping in right now, right at the end of this, go ahead and sub up. Prepare for some more good stuff, for some more Murder Church, some more trials. I do mostly just the classic stuff on here, but I appreciate the hell out of that. Thank you, guys. Thank you. Getting rated up in here. Getting crazy. That's how you end a trial. That's how you end a stream and a trial, if I may say so myself. But wow. I don't even know what to say. Like, the folks that have hung out with me for 16 months in a row for this, again, we went through multiple trials. If you go to the live section, if you go to the playlist, that'd be the place to go. There's multiple other trials to check out that we've done. Been doing this for quite a while now. There we go. True Crime Addicted just subbed up. Welcome in here, True Crime. Appreciate that. Hell yeah. Hell yes. Some mighty fine folks. Love to see a raider come through here. That's awesome. Hell yeah, Tammy. Nice. And again, remember, Tuesday night at 8. I know Donna Adelson's trial starts that day. The jury selection starts. So, again, I can't actually cover that one in real time, again, because I work a regular job. But I wanted to do something basically for the next season of Murder Church to keep rocking. And I figured the 2023 Charlie Adelson trial would be perfect to kind of play off of that. So, damn, dude. I appreciate the shit out of it, man. Thank you so much for sending these folks in here. Yeah, there is a playlist, James, where you could check out this entire thing. And I hope there's not anything missing. Every once in a while I'll get a comment like, where's this one or where that one? I'll have to kind of go back and then put that in the playlist. But I think they're all in there. So yeah, check that out. Season 1 was Jeffrey Dahmer's insanity trial early on in the publicly buzzed sphere here. But yeah, fine folks coming through. I really appreciate it. Again, me going 6 hours is unusual. I will say that. I know a lot of streamers, that's a normal thing for them. People start in the morning and they go all freaking day long. You know, props to them because my body feels it. My back right now is feeling it. But hell yes, please get in here. Yeah, hit the bell if you're subbing up. Make sure you get a notification when I do go live. And again, you know, for new folks, I go live on Sunday, every Sunday morning, 9 Eastern. In the morning, we start Murder Church. Tuesday nights at 8 Eastern, we do Murder Church, and then we do something called Book Club. Again, currently we're reading The Stranger Beside Me. That's a Ted Bundy book. That's for members only. But then Thursday nights at 8, we do a show, and then Feral Fridays, we start at 9 in those evenings. And but yes, I appreciate the hell out of it, guys. This has been awesome. This has been awesome. holding on here for just a little bit longer because of that raid. I really appreciate that. That's fucking sweet. I didn't expect that. That's cool. It's been a day. Carrie coming. I've been lurking all day. Had to pick up my daughter 2 hours away. Love y'all, and that's perfect. You know, especially honestly, streams like this are perfect for journeys like that. You know, listen to it like a podcast or something. I will say my mic sound. The one comment that I get the most is about, I guess, how I freak out or get a little too loud. And it kind of plays off of the sound of the trial, which will be a little bit lower, and I kind of freak people out with how loud I get. And maybe that's on me with having the mic too loud, but hopefully you'll dig hanging out here, guys. We trying to do the damn thing. Wildside going to come through here at the end with a $2 holler. Appreciate that, Wildside. Appreciate that. And one thing for new folks walking through here, one cool thing that we do, we have a wheel, a physical wheel that we spin. Once I get 12 names, whether you're donating or become a member or however you do that, once we get 12 names, we give out some goodies here at Publicly Buzzed. I got some cool magnets. Oh shit, Murder Church magnets, hell yeah magnets. I've got some Publicly Buzzed coasters. Sometimes we do shirt giveaways, t-shirts. If you go to publiclybuzz.com, I got a bunch of cool merch on there, a bunch of shirts. But I really appreciate everyone for coming through here. And again, that raid is super generous, guys. Super cool. Wow. We did it. We did it. Still can't believe it. I'm actually canceling my wrestling stream tonight. I have a second channel where I stream wrestling on Sunday evenings, but I'm going to cancel that one and kind of just take the rest of the day to chill out before the work week starts for me. But again, this has been absolutely incredible. And that's right, Gambies. Make sure you join us on Feral Fridays. That's when we have the most fun. We usually go over to kick.com/publiclybuzzed after hanging out on YouTube for a little bit, and we watch a movie. And soon, I'm going to be watching the Phil Spector movie, where Spector is played by Al Pacino, and a special guest on that stream will be Linda Kinney Bodden herself. So prepare for that. So we got some really cool stuff coming down the stream here. Oh, man. And yeah, James, originally I started this because of the Karen Reed trial, of course. Alan Jackson being the prosecutor. That it was voted on by the Buzz Nation here, but that was heavily weighed upon as one of the reasons I think that it did get picked because, but we've already went through 2 Karen Reed trials, but seeing Alan Jackson as a prosecutor was incredibly interesting to watch. And then seeing Linda Kinney Bodden work was incredibly interesting to watch. I think she was my favorite defense attorney of his, too. So, hell yes. This has been awesome, guys. Again, I really appreciate the shit out of it. This has been crazy. This has been nuts. Still, unbelievable that we've made it. Unbelievable. Right here, we have Murder Church Sunday morning starting at 8 a.m. Well, 9 a.m. normally. I did start at 8 today, but it's normally a 9 a.m. thing. I put that extra time in today. We're about to hit 6 hours right now on this stream. But yes, Tuesdays and Thursdays at 8 and Feral Friday, 9 Eastern at night. And we do get a little crazier on Feral Fridays. It's usually more of a not true crime-y type show, but, we will dive into some true crime here and there. And I do have a PayPal. Yeah, let me pop that up here real quick. Boom, right there. You can get PayPal is publicly buzzed. Venmo is publicly buzzed. Cash App, the $, publicly buzzed. Any of that will also get you on a wheel as well. And that's how a lot of folks will get on the wheel. And I appreciate any kind of donations like that. So, did I miss something? I don't think I missed anything. We know how to party. I think that's right. Brooklyn's saying it best right there. So, all right, guys, I am going to get out of here again. You know what I'm going to do? I'm about to go buy the stuff to make Chicago dogs tonight. My boss at work made some Chicago dogs for her and her husband, and then was telling me how good they are. And I'm a chili dog person, right? I like a classic onions, chili, mustard, and slaw, optional, but I like slaw. So a Chicago dog having tomatoes, relish, onions, mustard, celery salt, and pickles was like, there's no way I'm going to like this. It was one of the best hot dogs I've ever had in my life. Yeah, I got that one. I did get that one, Jen. Afton coming through here right at the end. Afton, we just now finished this Phil Spector trial after 16 months. Boom. Boom. I'm excited. I'm really excited. And I had a really cool ending here. I had a bunch of nice, fine folks be dropped in on us here, which is really cool. Really appreciate it. But we're gonna do it. We're getting out of here. I think we're gonna do it. I think we gotta do it. I'm gonna go get the stuff to make some Chicago dolls. But again, one last plug. Do not forget Tuesday night, 8 Eastern, brand new trial. If I can get my fingers right here. Boom, 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 boom. Charlie Adelson, 2023 trial. Playing off of the Donna Adelson trial that is starting up the same day. Oh, dude, it blew my mind, Jen. I could not believe how good the Chicago dog was. I could not believe it. Incredible. All right, guys, let's get the hell out of here. Thank you all so much. Let's go. Enjoy the rest of your Sunday. I'll see you Tuesday night. Follow me on X. That's where all the updates will be. But yes, Tuesday night, mark it on your calendars. New stream coming. New season coming. Love you guys. Boom.
Nothing to see here.